Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations so that, setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Renuka Sagram Singh Suklal and Senator Amrita Deonarine, both of whom are out of the country, and to Senator Anthony Vera SC, who is ill. Honorable Senators, I have received the following correspondence from Her Excellency the President, Christine Carla Kangaloo, OR, TT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Christine Carla Kangaloo, ORTT, President of the Republic of Trinidad and Tobago, Commander-in-Chief of the Armed Forces, to Mr. Michael Seals. Whereas Senator the Honorable Renuka Sagram Singh Suklal is incapable of performing his duties as a senator by reason of her absence from Trinidad and Tobago, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)A and Section 44(4)A of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Michael Seals, to be a member of the Senate temporarily with effect from the 13th of June 2023 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Renuka Sagram Singh Suklal. To Mr. John Heath, SC, whereas Senator Amrita Deonarine is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)A and Section 44(4)C of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, John Heath, SC, to be a member of the Senate temporarily with effect from the 13th of June 2023 and continuing during the absence of Senator Amrita Deonarine from Trinidad and Tobago. To Dr. Margaret Burgess, whereas Senator Anthony Vera, SC, is incapable of performing his duties as a senator by reason of illness, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)B and Section 44(4)C of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Margaret Burgess, to be a member of the Senate temporarily with effect from the 13th of June 2023 and continuing during the absence of Senator Anthony Vera, SC, by reason of illness, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 12th day of June 2023. Honorable Senators are required to take the oath.
I, Michael Seals, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, John Heath, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Dr. Margaret Burgess, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Reports from committees.
The Vice President.
Thank you, Mr. President. Mr. President, I have the honor to present the following report as listed on the order paper in my name. The fifth report of the Joint Select Committee on Human Rights, Equality and Diversity, third session, 12th Parliament, on an examination of the implementation of the recommendations of the report by the independent investigating team appointed by the Cabinet of the Republic of Trinidad and Tobago to investigate reports of child abuse at children's homes. Urgent questions.
Leader of Government Business.
Mr. President, there are two urgent questions that we've received notice on. One for education, the government is prepared to respond. One for finance, we request of you that that urgent question be stood down to a point later in the proceedings today. Thank you, Mr. President.
Honourable Senators, the request by the Leader of Government Business for urgent question number 1 is so granted to be stood down to later in the proceedings. Senator Mark, the procedure has been put and the question has been stood down to later in the proceedings. Are you... Because the procedure is normal, Senator Mark. Be brief.
Mr. President, I would like you to rule on this matter. Rule on this matter. Mr. President, I know our Constitution is supreme, but I know as the President of the Senate, when you approve an urgent question, no matter what a minister might be doing, he has to drop that or those things and come to this Parliament. I am disappointed. I am disappointed, Mr. President, and I would like a clear ruling
Senator
on
Mark,
this matter.
Senator Mark, have a seat. Senators. I require no assistance. And there are simple rules. When I'm on my legs, the member speaking takes a seat and there will be silence in the chamber. Senator Mark, I have already ruled, and this question will be stood down till later in the proceedings. I'm now inviting you to ask the second urgent question on notice. Senator Mark.
We'll deal with this matter at another level. Mr. President, unacceptable. Mr. President, through you to the Honorable Minister of Education. In light of widespread flooding in the Barkpo and Moruga communities, causing students to miss their CSEC and CAPE exams, can the Minister advise what measures are being taken to ensure that the students are not disadvantaged?
In the Ministry of Education.
Thank you, Mr. President. Mr. President, in light of the inclement weather experienced on Monday, the 12th of June, 2023, and the flooding which ensued, the Ministry of Education made arrangements to facilitate the students who had difficulty getting to their centers to sit the CSEC examination. These matters were handled on a school-by-school and in some cases a student-by-student basis as the need arose. However, despite their best efforts, all students scheduled to sit the CXC examinations yesterday were not able to make it to an examination center. The Caribbean Examination Council does not schedule makeup examinations, so in cases like these, which have occurred previously, the Ministry of Education collects verified student-specific data from schools and makes representation to CXC for compassionate consideration on behalf of the students who were not able to sit their examinations. This has resulted in previous years in a prorated examination grade based on their performance in the examination papers they would have been able to sit and their SBA grade. Principals were requested yesterday to send in the information relating to the students who missed examinations due to flooding, and this is presently being received and collated by the Ministry of Education for submission to CXC. Parents of the students so affected were advised to liaise with the school principals to ensure that their children are on the list, which is submitted to CXC and the Ministry of Education. Thank you.
Senator Mark.
Mr. President, through you to the Honorable Minister. Is the Minister aware as we speak, flood waters are extremely high in Barkpo, Moruga, and Pina, and there's every likelihood, Mr. President, that students will not be able to travel to their examination center. Can I ask the Minister, through you, what urgent steps are being taken to mobilize the Army, right, and members of the protective services to use their huge, powerful equipment to traverse these high waters?
So, Senator Mark, that's something more like a statement.
Okay.
So I've gotten the question.
Yes.
The Minister in the Ministry of Education would have answered in her original answer to the question posed. Do you have another supplemental, Senator Mark?
Yeah. Mr. Honorable President, can the Minister indicate, having regard to advanced knowledge from the Met Office 2 days ago, that we were going to have extreme weather conditions, and knowing fully well CSEC and CAPE was being held from yesterday, can the Minister indicate what steps were taken by the Ministry to ensure that, for instance, contingency measures and or plans are put in place so those areas that are going to be affected, the students would have been able to travel to their centers in order to do the exam, Mr. President? Can I ask you?
Minister in the Ministry of Education.
Mr. President, through you, I heard a statement and I didn't hear a question. Could I just hear the Senator again, please? What was the
Mark,
question?
could you repeat the question succinctly,
Thank
please?
Yes, succinctly.
Yes.
Succinctly. Yeah.
Senator Roberts, please allow Senator Mark to ask the question.
Yeah. Through the Honorable President to the Honorable Minister, can you indicate whether, in light of the advanced knowledge to all of us given by the Met Office of the severe weather conditions that occurred yesterday and continues today until about 5 p.m. according to the Met Office. Could you indicate to this Honorable House whether, or Senate rather, whether the ministry took any contingency measures to address these developments that have now occurred and continues, Mr. President, as we speak?
Minister in the Ministry of Education.
Through you, Mr. President, I am asking for, I will prepare that information and I'll submit it to Senator Mark in the very near future regarding the contingency that was in place. But Mr. President, during the rainy season, we normally have natural disasters, and the very first statement that I make through you, Mr. President, is what takes place. We have contingency plans regarding CXC, where we usually use the prorated marks of the students prior. Thank you.
Questions on notice, questions for oral answer.
Leader of Government Business.
Thank you, Mr. President. Mr. President, there are 6 questions for oral response and 1 for written response. The government is prepared to answer all the questions on the order paper. Thank you.
Thank you. Thank you, Mr. President. Question number 68 to the Attorney General.
Thank you, Mr. President. Mr. President, this is a curious question since it is a matter of public record that on Friday, the 10th of February, 2023, 4 months ago, the Office of the Attorney General and Ministry of Legal Affairs and the Ministry of Trade and Industry held a media conference to provide an update on the Cabinet-approved proclamation of the Act. At that media conference, the public was informed that the Cabinet has decided that the Act will be partially proclaimed on Friday, 24th February 2023, through Section 39 thereof. Section 39 of the Act incorporates a transitional provision within the framework of the Act. This provision bestows upon all dealers holding valid scrap dealers' licenses issued under the previous legislation the status of being deemed valid until April 14th, 2023, for the purpose of continuity and smooth transition. After these developments, the following sections of the Scrap Metal Act were proclaimed, thereby commencing their legal effect as of February 24th. These were sections 1, 2, 3, subsection 2, 5, 9, subsections B, D, and E, 17, subsections 1, 3, 4, and 5, 18, subsections 1 and 3, 19, 21, 23, 1, 24, 1, subsections 2, 3, and 4, and 6, 25, 26, 34, 35, 36, 37, 38, 39, 40, and 41, and the second schedule of the Act. Thereafter, the Ministry of Trade issued an advisory in the Guardian daily newspaper of Sunday, 12 February, to bring awareness to the public of the partial proclamation of the Act and to inform all stakeholders in the scrap metal industry of the requirements to operate. Further, by means of a formal letter dated 14th April 2023, 2 months ago, the Ministry of Trade and Industry provided notification to stakeholders that the complete implementation of the Act required several actions, including the appointment of scrap metal inspectors, the formulation of an AML CFT PF risk assessment questionnaire for the scrap metal industry, and the drafting of regulations. I'm pleased to advise the Ministry of Trade and Industry, in collaboration with my ministry, has successfully completed all of these tasks. On the 14th of April, in accordance with Section 40 of the Act, the Ministry of Trade and Industry finalized the draft of the scrap metal regulations, and those regulations are now under review by the Legislation Review Committee, as is customary. Importantly, I ask this House to note that the proclamation of Section 3(1) of the Act, which concerns the important issue of the issuance of a collector's license, is contingent upon applicants obtaining a certificate of character from the Trinidad and Tobago Police Service. In conclusion, I reiterate the government is committed to the full implementation of the remaining sections of the Act in the shortest possible time, but this requires the full cooperation of and compliance by industry stakeholders. Thank you.
Yes, thank you, Mr. President. Can I ask the Attorney General whether the government, through his office, is experiencing challenges with getting the stakeholders together with a view to fully proclaiming the remaining sections of the Act? Can I ask the Attorney General?
The government is experiencing no challenges with getting collectors together or dealers together.
Right. Can you therefore advise this Honorable Senate, when does the government intend to bring all stakeholders together with a view to proclaiming the remaining sections of the Act at its earliest possible opportunity?
Thank you, Mr. President. I don't understand the question, when does the government intend to bring all stakeholders together? All stakeholders have been consulted throughout the passage and proclamation of this Act on a continuing basis. The only thing that is outstanding is the certificate of character from the police, which will allow us to proclaim the section in respect of collectors, and the draft regulations which are currently engaging the attention of the Legislative Review Committee, as I've already explained.
Can I ask, through you, to the Attorney General, whether the issuing of certificates of good character is or may be contributing to the hold-up of the export of, let's say, scrap metal, which apparently are held up as we speak at the port. So can you tell us whether there's a link between the issuing of certificates of good character and the failure of the government to allow the scrap iron dealers to continue their exportation of metal? That is what I'd like to clarify.
Thank you, Mr. President. If I may attempt to answer the several questions asked. Firstly, there is no hold-up in the export of scrap metal. The export of scrap metal continues on the basis of the deemed certificates that have been issued to dealers, continuing from the last Act, which was repealed, but continued under the transition provision. Secondly, with respect to the certificates of character, I do not know, nor do I ever expect to be able to speak on behalf of the police service of this country. And lastly, there is no confusion in the collection or exporting of scrap metal. Thank you.
Yeah, I think this is my final question. You are disturbing us, this honorable member. Better I ask her?
Senator Mark,
Sorry, sir, I apologize.
have a seat. I understand that. Please just ask your question.
May I ask the Honorable and Distinguished Attorney General the following? Attorney General, are you aware of concerns, rumblings among members of the scrap iron dealers as it concerns the government's failure to address fundamental issues confronting their membership, with the possibility of a threat being issued to disrupt operations of that industry? Is the Attorney General aware of such discontent that is growing, Mr. President, among the scrap iron dealers? Can I ask through you, Mr. President?
That question doesn't arise, Senator Mark. Next question on the order paper.
Yes, thank you, Mr. President. Question number 69 to the Attorney General.
Attorney General.
Thank you, Mr. President. Mr. President, we got it. Regarding part one of the question, it is a matter of public record which Senator Wade Mark must know that the Office of the Attorney General and Ministry of Legal Affairs has initiated an investigation into the circumstances surrounding the state's failure to file a defense in a civil action claiming malicious prosecution, which was brought by 9 former accused who were charged and subject to a criminal trial for the kidnapping and murder of businesswoman Vindra Naipaul Coleman. Senator Mark must also be well aware that the investigative team comprises lead investigator, Mr. Justice Stanley John retired, and Mrs. Pamela Shulera Hines. Further, it is a matter of public record that on Saturday, the 11th of February 2023, lead investigator, Mr. Justice Stanley John, delivered a public statement informing the populace of the terms of reference which govern the said investigation. Senator Mark must also know that part one of his question falls within the terms of reference and therefore the remit of the investigative team. Finally, it is a matter of public record as well that on the advice of the retained lead counsel, Mr. Ralston Nelson, senior counsel, an application was filed on the 27th of March 2023 in the High Court on behalf of the state in the matter of civil action 2020-01243 Sherwin Peters and others against the Attorney General to set aside both the default judgment and the award of damages made against the state in favor of those claimants. This substantive matter is ongoing before the High Court and therefore obviously is sub judice. And Senator Mark must know that it is a breach of Standing Order 47 to pursue any matter which relates to active proceedings in any court of record until the proceedings are ended by judgment or discontinuance. Thank you, Mr. President.
Senator Mark.
Things that you said, I don't know, or I should know. I leave that to the judgment of the President. May I ask, through you, Honorable President, to the Attorney General. Attorney General, can you tell this Honorable Senate what is the current status, or status, I should say, of the investigation being conducted by a retired Justice Stanley John into the missing file? Can you give this Honorable Senate what is the current status?
Senator Roberts, please allow Senator Mark to ask his question so we can hear it. Senator Mark, continue.
Yeah, Honorable Senator, Honorable Attorney General, through the President, can you clarify for this Honorable Senate the question I've posed to you? You want me to repeat it, or you got it?
I believe there was an interruption and I didn't hear the question.
You are very difficult.
Senator Mark, ask the question. Time is running.
But I understand you. Mr.
Ask the
President,
question,
may I ask
Senator
you
Mark.
through you, Mr. President. Sorry for pointing my fingers. I want to point it at you.
Senator Mark.
Sorry, sir. Mr. President. May I ask the Honorable Attorney General, the distinguished Attorney General, outstanding Attorney, extraordinary.
Senator Mark, Senator Mark, have a seat. Asking a question is a simple thing. Pose the question in the format that we all know a question is to be posed so that the proceedings can continue. There is a clock, as you are well aware of, as it relates to these proceedings.
Apologies to you again. Mr. President, through you, can I ask the Honorable Attorney General succinctly, what is the status of the investigation into the missing file?
Attorney General.
Thank you, Mr. President. In answer to Senator Mark, on the last public pronouncements made by Mr. Justice John, he had indicated that he expected to conclude his investigation by the end of June. Today is, I believe, the 13th of June, so I would expect that we will get the investigative report by the 31st of June. Beyond that, I'm not able to speak to the status of investigation. I don't get involved.
Senator Mark.
Mr. President, to the Honorable Attorney General and distinguished Attorney General, can I ask the Attorney General, having regard to the fact that the missing file mysteriously appeared once more in the office of the Solicitor General or your office, can you indicate why this retired justice is seeking so long an extension to submit his final report, as you said, till the end of June, in light of the rediscovery of the missing file. Can you share with this Honorable House the basis and rationale for this extended period of time for said investigation?
Attorney General.
Thank you very much, Mr. President. I am not aware that Justice John has sought an extension. What I'm aware of is that there are 9 points of reference in his terms of reference, and in his public pronouncements, when he spoke to that, he had indicated the outside end of the conclusion of his investigation, which he is within.
Distinguished and extraordinary Attorney General.
Senator Mark, leave out the extras, please. Just
Okay.
ask the question.
Can I ask the Honorable Attorney General, can the Attorney General advise this Honorable Senate what will be the final cost to the beleaguered taxpayers for this investigation into the missing file? Can I ask the Honorable Attorney
A
General?
question does not arise, Senator Mark. Final question.
Can I ask the Attorney General, what was the justification for the payment of close to $1 million to both Justice Rolston Nelson and retired Justice Stanley John for conducting an investigation into a missing file which has been rediscovered? Can you justify the rationale for this close to $1 million and counting to these 2 honorary and distinguished judges?
The question does not
our
arise,
former-
Senator Mark.
Does not arise.
Next question on the order paper.
Thank you, Mr. President. Look, I want to ask it now to the person who was answering all the questions. Mr. President, may I ask through you, question number 70 to the Honorable and Distinguished Minister of Trade and Industry.
Minister in the Ministry of Agriculture, Lands and Fisheries.
Thank you, Mr. President. I'm pleased to answer this question of both on the order paper on behalf of both of my colleagues, the Minister of Trade and the Minister of Agriculture. Mr. President, the Ministry of Agriculture, Land and Fisheries currently offers several services to registered farmers, including egg producers. These services are subsidized by the government and are at no cost to said farmers, which aims to reduce their incurred production costs. Some of these services offered as follows: veterinary services, preventative medicine, disease surveillance and hatchery monitoring, extension services, husbandry and management advice, lectures and presentation on poultry rearing, site visits and reports by the Ministry for all Agricultural Development Bank loan applications, guidance on the importation protocols to assist farmers in obtaining eggs or chicks for hatching or rearing, verification of poultry imports and farm follow-up visits. Veterinary officers and animal production and health staff are also available to assist all of these farmers. It should also be noted that all registered farmers are entitled to government subsidies and incentives on established inputs. Moreover, all farmers, whether they are registered with the Ministry of Agriculture or not, are encouraged to apply for these agricultural finance support program, as we commonly call it, the Agro Incentive Grant, through which they can access up to a maximum of $100,000 for their business expansion models. The Ministry of Agriculture, Land and Fisheries intends to review its policies with the intention to address the growing concerns of our stakeholders in these economic times, and remains committed to supporting our local egg farmers and the wider farming community. Thank you, Mr. President.
Yes, Mr. President, may I ask the Honorable, Honorable Minister, my friend, can you indicate to this Senate to what extent the various measures outlined by your good self have contributed to the reduction, if there has been a reduction in the price of eggs to the ordinary consumers in this country?
Minister in the Ministry.
Thank you, Mr. President. What I can say, Mr. President, a lot of the inputs regarding the production of eggs in Trinidad and Tobago has to do with the foreign inputs, which is our corn or grain or inputs in the feed manufacturing process, as this is the largest component in egg production. Some of these inputs, Mr. President, Trinidad and Tobago rarely in the international scheme is price takers. For example, corn, soya, wheat, middling. What I can say is that these prices internationally have been impacted by various reasons. One, the Russia-Ukraine conflict, transportation costs, as well as avian influenza in the US, where almost 50 million birds last year was destroyed to that disease and that virus, which totally impacted all of egg production in the world. So it's not just limited to Trinidad and Tobago. What I can say is, as we are coming out of the COVID protocols worldwide and shipping costs is kind of, I should say, going back to some form of normalcy, the input costs on the whole, Mr. President, is slowly going back down, and I intend to also have conversations with the producers, because another point note in the AIP program, the Agricultural Incentive Program, is any input related to the poultry sector that is not currently subsidized. These farmers are well aware of the process to simply write the Chief Technical Officer of the Ministry of Agriculture, identifying the inputs. It could be a machinery, equipment, any form of technology that they want to employ to reduce their cost of production. They can write the ministry's CTO, and we have a mechanism. It's multi-ministry approach. Ministry of Trade issues a minister's license to have duty relief on all these inputs. So it's a holistic approach. The government is working with our stakeholders. Our partner ministry, Ministry of Trade, Ministry of Agriculture, continues to monitor the situation. And I'll go one step further, Mr. President, and indicate we understood this whole issue of the input costs, grain, corn, and soya. And one of the conversations the Honorable Prime Minister would have had in Guyana in that recent visit is trying to source these inputs from right here in CARICOM territory, where Guyana is going to assist in corn and soya production that we can have further collaboration on. Thank you, Mr. President.
Senator Mark.
Yeah, can I ask the distinguished minister whether, well, let me recast my question. In light of the decision to review the policy of the government as it relates to assisting farmers in egg production and maybe other areas, can you provide to this Honorable Senate a time frame for same review, Mr. President?
Minister in the Ministry.
Thank you, Mr. President. What I can give the assurance is that this is something that we feel very strongly of, Senator Mark, through you, Mr. President. And it's an ongoing process because the Agricultural Incentive Program is continuously upgraded, and it takes into consideration the modern technology that is becoming available as time go by. So the AIP program is a work in progress, and I must say through this Honourable House that we are in active consultation with our stakeholders at all times, from the primary producers to the agro-processors, trying to make their lives a lot easier with the intervention of our partner ministries, and more so with Minister Kazim Hussein's direct intervention of consultation. Thank you.
Senator Mark.
Yeah, Mr. President, can I ask the Honourable Minister, given the fact that there has been, even though incrementally, a return to normalcy in terms of transportation costs, like the freight costs, right? And the production of corn, soya, and grains, as the Honourable Minister has said, Mr. President. Can the Honourable Minister indicate what kind of time frame, rather, would he consider for these inputs, reduction in input costs, to really benefit the consumers through lower prices for eggs, for example? Mr. President.
Minister in the Ministry.
Thank you, Mr. President. Mr. President, through this House, it would be difficult to really predict that because nobody experienced or nobody really planned for COVID, Mr. President, and that would have decimated the entire supply chain protocols that dictate, production costs and so on. So it wouldn't be wise for me to comment, Mr. President, because that is something challenging. It's evolving over time. But I can say we are actively engaging our stakeholders, and we are always dealing with our primary producers, the farmers, the most important people in this country, I would say, to make their lives easier. And the changes, Senator Mark, through you, Mr. President, is making the whole farmer registration process easier. And the ease of doing business with help from Minister Paula Gopisko in the Ministry of Trade, because her ministry also has a quite extensive package of grant funding that is available to our farming population. And I would also say that the farmers are now being given the respect by this government that they have not been given over the last administration. Thank you.
Senator Mark.
My final question. Yes.
Senator Mark, ask the question.
I'm being disturbed, sir.
Focus and ask the question, please.
Yeah, I'm going to focus on you.
Yes.
Mr. President, may I ask through you, Mr. President, given the fact that there's a tendency for prices to always go up and never come down in this country, can the minister indicate how confident he is that with a gradual reduction in the cost of inputs will eventually benefit the consumers through lower prices? Can the minister give any indication and assurance of prices being reduced given the gradual reduction in the cost of inputs that will ultimately benefit the consuming public, Mr. President?
The question does not arise, Senator Mark. Next question on the order paper.
Thank you, Mr. President.
Oh, Senator Richards, sorry.
Thank you.
Public Gallery, question number 120 to the Minister of National Security.
Minister of National Security.
Thank you, Mr. President. According to information provided by the Commissioner of Police, with respect to part 1 of the Senator's question, as it relates to robberies and burglaries conducted in homes and called home invasions, these statistics show that they have not increased overall. For as the record shows, there were 145 such events over the last 4 months, as compared to 185 such events as at the same period in 2022. However, we are mindful that that statistic gives no comfort to the victims of this very heinous and horrible crime and the experience that they suffer as a consequence of it. However, the specific areas or communities, in specific areas and communities, there may have been increases for the 4-month period as described in the question, February 2023 to May 2023 by the Senator. The provisional figures for communities within the following police districts where increases were recorded are as follows. Cunupia area, an increase from 5 in 2022 to 12 in 2023. St. Joseph, an increase from 9 to 11 for the same period, and Barataria from 9 to 10 for the same period. The Trinidad and Tobago Police Service continues to be very concerned about the incidence of home invasions and continue to undertake measures to address this serious problem. Several strategies aimed at assisting with the deterrence and suppression of such criminal violations, including home invasions, have been deployed. A special team has been designated to respond to home invasions across the country. The team comprises of intelligence officers, CID personnel, and analysts. In addition, efforts are well underway to enhance their training and to bolster the equipment and other resources that they need. As it relates to part 3 of the Senator's question, the Trinidad and Tobago Police Service has advised that the provisional data for occurrences of serious crimes over the last 6 months compared to the corresponding period in 2022 indicates a decrease of approximately 10%, as follows. Murders, an increase from 257 to 280, and we are talking about the 6-month period from December 2021 to May 2022 as compared to December 2022 to May 2023, the 6-month period the Senator spoke about. For woundings and shootings, a decrease from 372 in 2022 to 307. Rapes, incest, and other sexual offenses, a decrease from 422 to 389. Serious indecency, from a decrease from 21 to 9. Kidnapping, 59 to 50. Kidnapping for ransom, 2 to 0. Burglaries and break-ins, 862 down to 712. Robberies, 1,189 down to 1,151. Fraud offenses, 228 down to 275. General larceny, 1,060 down to 872. An increase, however, in larceny motor vehicles from 457 to 477. A decrease from 79 to 43 in respect of larceny from dwelling houses. Narcotic offenses showed an increase from 166 to 192. Possession of firearm and ammunition, a decrease from 597 to 507. Other serious crimes, a decrease from 606 to 532. So there have been, Mr. President, 3 categories of those crimes where we have witnessed increases, and these are murders, larceny motor vehicles, and narcotic offenses. Overall, for the same period, we had 6,377 in 2021 to 2022, the 6-month period, and for 2022 to 2023, 5,796. So we have seen a general decrease in serious crimes, but for the 3 categories as I have highlighted them. May I thank you, Mr. President?
Richard.
Thank you, Minister. Through you, Mr. President. Can the Minister clarify if the data given is for the corresponding period of the previous year or for the 6-month period immediately preceding the last 6 months?
Minister of National Security.
I gave figures for the 6-month period, the last 6 months, as compared to that 6-month period in the preceding year.
Senator Richards.
Can the Minister indicate if the TTPS has been able to do analysis of what may be the vulnerabilities or driving factors in the data presented regarding Cunupia, St. James, and Barataria in the even marginal increase in home invasions?
Minister.
The figures as I have related them would have come from the police's crime and problem analysis unit. I also indicated that in respect of home invasions, there are analysts operating inside of the team of law enforcement treating with it. So the answer to the Senator's question is indeed yes.
Senator Richards.
Can the Minister indicate if regarding murders, which if I remember correctly, the Minister indicated is one of the categories where we're seeing increases, if CAPA, the Police Crime and Analysis Unit, has been able to do an analysis as to the driving factors related to those increases in murders, which are the troubling statistic in many people's minds in the country?
Minister.
We have oftentimes, and within recent times, indicated some of the indicators we have seen in this regard. For one thing, the prevalence of assault weapons, automatic weapons, as compared to previous times where you might have had revolvers and pistols. Now with automatic weapons, we have seen more double murders in the last 72 hours. In this country, 96 hours, we have seen several, about 3 double murders. That is as a result of the prevalence of and the use of automatic weapons with 5.56 and 7.62 ammunition on use. That is one of the factors. Increased criminal gang activity. So the police service has, in this regard, established gang units in every single one of the 10 police divisions across the country, focused on gang reduction as well. We have also introduced, with the help of our partners in the United States, a gang reduction and community resilience program, which we call GRACE, to encourage communities to become more resilient to the presence and the proliferation of gang activity, because we understand at the base of this that these kinds of activities could never proliferate unless the people are minimally resistant. So we are taking action to ensure that those things are done. So those are some of the very complex issues that might explain an increase in murders, Mr. President, sorry.
Senator Richards.
Thank you, Mr. President. Finally, for the Minister, can the Minister give us a sense of what strategies are being employed by the police? Another category that you indicated showed an increase is car thefts, larceny of motor vehicles, and we've seen a lot of that being reported in the media. What strategies are being employed by the TCPS to curtail that and bring the perpetrators to justice?
Minister.
This kind of analysis, as I shared in respect of home invasions and the other crimes here, really always, and using the analysts within the police service, it provides them with an opportunity to look more astutely and more acutely at particular crimes. And yes, the car thefts have been emerging again, and they are treating with it in similar models. That is to say, analyzing it and focusing on it. And I want to take the opportunity to congratulate the Trinidad and Tobago Police Service. Recently, they had a major success with a car, permit me a colloquialism, a car thieving ring. And they were able to break it, and to great success. So the answer to the Senator's question is yes, and focus is being paid on the crimes as they raise their heads as being more frequent in the society. Thank you very much.
Senator Richards. Next question, any other people?
Thank you, Minister. Question number 121 to the Minister of Education.
Minister in the Ministry of Education.
Mr. President, I'm pleased to inform you that the Cabinet-appointed committee has completed its review of the changes to the conduct of the SEA and transition to secondary school and the Concordat. I'm also pleased to state, Mr. President, the report is currently before the Cabinet. The recommendations have been reviewed, and the decision of the Cabinet will be made public in due course.
Senator Richards.
Thank you. Through you, Mr. President. Thank you, Madam Minister, for that, what I consider good news. Can the Minister indicate if there's a timeline that the Cabinet will take to assess the report, and if the report will be made public?
Minister.
Mr. President, it would be made public once the Cabinet has completed its deliberations, and I cannot presume to put a deadline on something that is as weighty as this. But I can assure through you, Mr. President, the Senator, it is receiving the attention that it deserves, and it will be available in due course.
Senator Richards.
Thank you. Well, can I move on to the next question, given the Minister's response to that question?
Say again?
Can I move on to the next question, given
Yes.
the Minister's response? Thank you, Minister. Question number 122 to the Minister of Public Administration.
Minister of Public Administration.
Thank you, Mr. President. I trust you can hear and understand me. During the period January 2022 to May 2023, the Modernization and Services Improvement Division continued its implementation of the pilot phase of the Public Sector Performance Management System. 4 ministries, departments, and agencies were active participants and completed the first 2 stages of the PS-PMS cycle, initial and assess, and commenced stages 3 and 4, engage and plan respectively. The names of the MDAs where services are improved are as follows: Southwest Regional Health Authority, in respect of the Medical Records Department, Eastern Regional Health Authority with respect to the Pharmacy Department, Sagri Valley Hospital, Ministry of Public Admin, Public Management Consulting Division, and the Ministry of Social Development and Family Services, the Social Welfare Division. The government's plans to improve service delivery in the public service under the MPA MSID involves the following initiatives: Public Sector Scorecard Project to improve performance management of MDAs to be initiated before the end of fiscal 2023. Citizen feedback system to allow users of government services to provide complaints, compliments, suggestions for improvements, and to rate government services, also aiming for launch before the end of 2023. The Electronic Human Capital Management Project is a long-term technology plan aimed at modernizing the delivery of HR services to public officers and improving the effectiveness and efficiency of HCM for improved public service delivery across GOAT. The Ministry of Public Admin is providing support for this mandate, has actioned the documentation and comparison of functional requirements of all IRIS modules with other HCM software solutions. The government is aiming to deliver an upgraded solution in fiscal 2024. Change management training for the public service to increase the success of several transformation projects related to actual services being delivered by MDAs. This started earlier this year and continues into fiscal 2024. In addition to the above, the ministry also has a program relating to increasing and upgrading government office accommodation to have spaces better suited to delivering services. And finally, Mr. President, let me just underscore that these projects are in respect of the MSID program. They are not related to all of the other improvement initiatives occurring throughout the government service.
Mr. President, thank you, Minister, for the response. Can the Minister indicate what were the reasons chosen for these particular agencies to participate in, if I could describe it as a pilot project?
Thank you, Mr. President. It was a combination of the agencies that were most ready to participate and the agencies willing and responsive to our invitation across court to engage. We also try to ensure that there was a variety in terms of the entities coming on board.
If the rationale was ministries or agencies that were most ready to come on board, is the minister or the government worried that it may not be as effective in terms of ascertaining the impact of the protocol on those agencies because those were already ready to come on board?
Yes, Mr. President, ready does not mean that they were at a stage of delivery that made the program ineffective. It meant the people who were prepared and able to come on board. But I will say to you, through you, Mr. President, that we are currently reassessing the program to do a broader rollout because, in my respectful view, the pilot segment of the program has been too extended and we want to increase the impact. So we are currently in the process of amending the program to make it more effective across the public service.
Mr. President, in terms of the evaluation metrics that you identified and the measures for improvement, how much weighting was given to the public feedback in terms of the service delivery of those agencies identified and the actual impact on public satisfaction?
Through you, Mr. President, while the intention is to ascribe significant weight to public feedback, because the system for garnering and assessing that feedback is not yet in place, that is a project in progress. Not significant weight is being given at this time, but as I indicated in my initial response, we are seeking to roll out that program before the end of this year, and As such, once the program is properly rolled out, appropriate weight will be given to that because we consider that an important aspect of the program.
Thank you. Can the minister indicate if an independent company or agency was used in the application of the protocol and the evaluation of the results obtained?
I'm sorry, Mr. President, I missed the question.
Sorry. The question is if an independent agency or company was involved in applying the protocol to these 4 agencies and assessing the outcomes.
Mr. President, the ministry engaged consultants to assist us in the rollout and assessment of the program and its effectiveness.
Thank you.
Public business, government business, bills second reading.
Attorney General.
Thank you, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Repeal and Replace the Arbitration Act, Chapter 5, Number 1, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters, be now read a second time. Mr. President, I consider myself privileged to stand here today to pilot the Arbitration Bill 2023. This bill is of great importance to Trinidad and Tobago. It can breathe new life into our commercial climate and attract business, international business, and promote the ease of doing business in our jurisdiction. With this bill, Mr. President, the aim is to introduce a legal framework which facilitates the use of arbitration as a means of resolving disputes. Provision is made in this bill for both domestic and international arbitration. Undoubtedly, updating our current legislation will largely benefit trade and commerce in Trinidad and Tobago by signaling to the local and the international community that we have met the gold standard, the international benchmark in this area. Mr. President, this bill seeks to introduce Trinidad and Tobago's arbitration legislation by modernizing the legislation to incorporate the internationally accepted model, that is to say, the United Nations Commission on International Trade Law, UNCITRAL, to use the acronym, the UNCITRAL Model Law on Arbitration, as adopted on June 21st, 1985, and amended on July 7th, 2006. The bill not only complies with the UNCITRAL Model Law, but it also closely follows the Impact Justice Model Arbitration Bill 2022. This harmonization with the regional and internationally accepted standards for arbitration will encourage increased trade and commerce in our Twin Island Republic. The question arises relevantly, Mr. President, as we engage in this discussion today, what is arbitration? Arbitration, Mr. President, refers to a method of alternative dispute resolution which facilitates the resolution of disputes which are submitted to an arbitrator or arbitrators for a binding and enforceable determination of the dispute which has arisen between the parties. By the arbitration process, importantly, the parties to that dispute consent to an arbitration agreement as part of their commercial engagement with each other, with the intention of not going to court. Rather, it is a consensual alternative agreed by the parties in preference to engaging in time-consuming and expensive litigation in the national courts. Arbitration is therefore facilitated by A, the consent of the parties, B, the selection of arbitrators by the parties, C, the procedure being neutral, D, the procedure being private and confidential, E, and F, the finality of the decision of an arbitrator. Arbitration, Mr. President, has increasingly become the preferred method of resolving disputes worldwide as opposed to engaging in litigation. The process is recognized as an attractive alternative to litigation for the following reasons. The parties enjoy a faster resolution to their disputes as the process is simplified. A reduced resolution time results in lower costs associated with determining the dispute. The arbitration process is itself more flexible in that it allows for the parties to agree on all aspects of the procedure. Arbitration allows for the parties to select a person or panel whose expertise is directly relevant to the specific dispute. The parties can rely on the finality of the award since a court's intervention is limited. Arbitration is usually conducted in private as a confidential process, allowing for confidential information such as trade secrets to be kept private while the dispute is engaged and in due course resolved. There are international arbitration rules that parties can agree to beforehand. In promoting this bill today before this Honorable Senate, Mr. President, I say with confidence that Trinidad and Tobago has the competence to become a seat of arbitration, since there are capable persons who can sit as arbitrators in this country. As at the 1st of June 2023, the chair of the Trinidad and Tobago chapter of the Chartered Institute of Arbitrators, CIARB, confirms that the chapter has 80 members, which include associates, members, and fellows who can function within the arbitration process that will be enabled once this bill passes into law. Mr. President, this country's arbitration legislation currently is governed by the Arbitration Act, Chapter 5, Number 1, which was enacted in 1939 and last amended in 1997. The 1939 Act is itself based on earlier English arbitration legislation, namely the UK Arbitration Acts of 1889 and 1934. The 1939 Act, Chapter 5, Number 1 of Trinidad and Tobago, Mr. President, is antiquated and does not get past the front door of modern alternative dispute resolution aimed at embedding the ease of doing business for this country's commercial life. I do not think, with respect, Mr. President, that I need to persuade this august chamber that Trinidad and Tobago should not remain embedded in a 1939 legislative mechanism for doing business in 2023. The United Nations Commission on International Trade Law, UNCITAL, is the internationally accepted model for arbitration legislation, Mr. President. It is the gold standard. UNCITRAL was itself established in 1966 by United Nations General Assembly resolution. And the General Assembly recognized that disparities in national laws governing international trade created obstacles to the flow of trade, and it regarded the Commission as the vehicle by which the United Nations could play a more active role in reducing or removing those obstacles. The General Assembly gave the Commission the general mandate to further the progressive harmonization and unification of the law of international trade. The Commission has since become the core legal body of the United Nations system in the field of international trade law. That law, the UNCITRAL model law, was developed to harmonize arbitration and to address the inadequacies and disparities in national laws on arbitration, and has come to represent the internationally accepted legislative standard. As pinpointed by UNCITRAL, in an increasingly economically interdependent world, the importance of an improved legal framework for the facilitation of international trade and investment is widely and universally acknowledged. The model law covers all stages of the arbitral award process, from the arbitration agreement to the recognition and enforcement of the arbitral award. To date, Mr. President, legislation based on or influenced heavily by the UNCITRAL model law has been adopted in 87 states in a total of 120 jurisdictions. Such jurisdictions include, among others, Australia, Barbados, the British Virgin Islands, Canada, Hong Kong, India, Jamaica, Malaysia, Singapore, United Kingdom, and the United States of America. UNCITRAL is the established body that assists, harmonizes, and unifies jurisdictions that promote arbitration since 1966. Such assistance also includes the publication of arbitration rules. I am able today, Mr. President, to assure this Senate that my office extended an invitation to the UNCITRAL Secretariat to consider the very bill presently before this Senate as accordant with the UNCITRAL model law. And by letter dated the 6th of June, 2023, the UNCITRAL Secretariat commented on the actual bill presently before us and advised, with your leave, Mr. President, quote, "We are very pleased to see that one of the objectives of the bill, Clause 5, is to adopt the UNCITRAL model law on international commercial arbitration, which has been adopted by a number of jurisdictions to achieve harmonization. Having conducted a review of the bill, we can confirm that the bill is indeed in line with the model law and, if enacted as such, Trinidad and Tobago could appear among the list of jurisdictions that have adopted the model law." Unquote. The reference there to Trinidad and Tobago appearing among the list of jurisdictions, Mr. President, is because once this bill passes into law, there is a schedule to the UNCITRAL model law that is constantly updated, and Trinidad and Tobago will become the listed 121st jurisdiction which has adopted this model law. Impact Justice, Mr. President, is a CARICOM regional civil society justice sector reform project funded by the Government of Canada. The project goal of Impact Justice is to strengthen legal frameworks, to improve legal professionalism and the sharing of legal information, and to facilitate increased knowledge and use of alternative dispute resolution mechanisms in CARICOM member states. This arbitration bill also closely follows the Impact Justice Model Arbitration Bill 2022. As provided at the explanatory memorandum to that bill states itself as the model law proposed by Impact Justice in order to modernize and harmonize the arbitration laws in the Caribbean region, and is based for the most part on the UNCITRAL model law. Mr. President, by the passage of this Arbitration Bill 2023 into law, Trinidad and Tobago is better positioning itself to, among other things, negotiate contracts, including international contracts, to attract business, including international business, at a regional level to have increased ease of doing business within the Caribbean, and to help build capacity in the region for arbitrators and the profession. With the passage of this bill then, located as we are in the gateway between Europe and the Americas, and as we build out our already strong commercial links to Guyana and our other CARICOM neighbors, Trinidad and Tobago will be sending a very strong signal that we continue to be a center for commercial international business. Arbitration is used in a plethora of areas, such as the energy sector, in the construction industry, sport, telecommunications, and in land disputes, to name only a few. An immediate and well-known example, FIDIC, the International Federation of Consulting Engineers, is the global representative body for national associations of consulting engineers. In contracts, all contracts for construction projects, the FIDIC rules provide standard clauses for arbitration. It will therefore be possible in the FIDIC rules that can be introduced into construction contracts in this country that Trinidad and Tobago, with the passage of this legislation, will not only be signaling that it is consistent with the international gold standard, but can have its companies insert clauses into those contracts for the seat of arbitration arising out of any dispute in a FIDIC context to be right here in Trinidad and Tobago. The recognition that Trinidad is UNCITRAL compliant, therefore, paves the way for the international community and the government of Trinidad and Tobago, the commercial community and the government of Trinidad and Tobago, to identify this country as a seat of arbitration in negotiating our commercial contracts, since arbitration being conducted in Trinidad and Tobago to resolve commercial disputes will be capable of being promoted as a viable option right here. Mr. President, this bill, the Arbitration Bill 2023, has been informed by, among other things, a policy that was prepared by the Law Reform Commission of the Office of the Attorney General and Ministry of Affairs. It was also extensively informed by a process of consultation with stakeholders on this bill, an important part of the process engaged in by my office. A draft bill was first produced in 2019, and stakeholders were invited to submit comments on it. The comments as submitted by stakeholders were considered by the Office of the Chief Parliamentary Counsel, and a new draft from the 2019 draft was produced in 2021 and continued to evolve. The bill was further reviewed, inclusive of the consideration of the comparative arbitration legislation out of Jamaica, Barbados, and the British Virgin Islands following the Model Impact Justice Arbitration Law. The revised bill was then submitted for further review by stakeholders, Mr. President, in August 2021, and comments received from those who responded have been considered. Those who were reached out to include the Trinidad and Tobago chapter of Chartered Institute of Arbitrators, the Association of Trinidad and Tobago Insurance Companies, the Ministry of Trade and Industry, excuse me, the Judiciary of the Republic of Trinidad and Tobago, the Trinidad and Tobago Chamber of Commerce, Bankers Association of Trinidad and Tobago, the Office of the Director of Public Prosecutions, the Financial Intelligence Unit of Trinidad and Tobago, the Law Association of Trinidad and Tobago, the Registrar General's Department, Trinidad and Tobago Contractors Association, and the Trinidad and Tobago Police Service. What are the benefits, Mr. President, which will accrue from this new legislation? We've already touched on some of them. A modern arbitration regime will signal to the international community that we are a jurisdiction that is well suited for international trade, business, and foreign investment, with increased ease of doing business within our jurisdiction. An updated Arbitration Act will herald the requisite recognition that disputes can be resolved through a modern, efficient, and internationally recognized arbitration procedure that can be utilized in respect of transnational contracts. There will be savings for our local court system, since arbitration will bring the significant benefit that resolving commercial disputes through arbitration allows the High Court in its commercial jurisdiction to concentrate on other commercial disputes, and therefore saves the time and resources available to the local courts. This is particularly relevant where a commercial dispute may not be ideally suited for adjudication on account of the scale, complexity, and unfamiliarity of an issue within our jurisdiction. Foreign international companies considering whether to invest or do business in Trinidad and Tobago will be more inclined to do so if there is modern legislation that facilitates arbitration to the same standard as the UNCITRAL model law. Further, it will be attractive to foreign investors, Mr. President, and companies if there is a mechanism to settle disputes through arbitration rather than expensive, time-consuming litigation in the courts in Trinidad and Tobago. Local companies are also increasingly turning towards arbitration, given the advantages over litigation where time and cost are concerned. A modern Arbitration Act therefore benefits our local international stakeholders who conduct business within Trinidad and Tobago. Trinidad and Tobago, Mr. President, has the potential to become, as a result, a center for international arbitration. For some time now, Mr. President, there has been a lot of competition among an increasing number of jurisdictions to be chosen as the seat for the arbitration of disputes. Regionally, in 2015, Jamaica established the Jamaican International Arbitration Center Limited and has been lobbying the international arbitration community as a viable arbitration center in the Caribbean. Likewise, the British Virgin Islands International Arbitration Center was launched in 2017. A modern Arbitration Act will undoubtedly aid in positioning Trinidad and Tobago as a preferred place for international arbitration. The bill signals that as a nation we are suited to conducting international arbitration and will allow foreign representatives to appear before a court or the arbitral tribunal and to have rights of audience. Furthermore, and we will see when we get to examine the bill, there are provisions for tax exemptions and on fees charged and expenses incurred by any arbitrator or foreign representative in an international arbitrator, which lasts for a continuous period of 30 days or less, so that expedition is encouraged in a period of 365 days in any annual period. Trinidad and Tobago, Mr. President, as I have said before, and it cannot be emphasized too much, is in a unique geographic location, being a Caribbean island in the gateway from North and Latin America to Europe. Flowing from this, there can be significant derivative economic benefits, provided we attract parties from Central, Latin America, South America, and North America to settle their arbitral disputes in Trinidad and Tobago when they are contracting with us. Should this bill be brought into law, there would therefore be an opportunity for the development of that arbitration center. Indeed, Mr. President, the Port of Spain International Waterfront Center was originally intended as a beacon for international investors. There is a publication that I could come to, but I won't trouble you, August 26, 2021, in which the Right Honorable late Prime Minister Patrick Manning spoke to that International Waterfront Center becoming the beacon for international trade and commerce. That is the vision which we are now given reality to by the passage of this bill into legislation. Mr. President, it will speak to the diversification of our economy, coupled with the need to earn more foreign exchange, as well as to arrest the flight of foreign exchange. In this regard, it is ever more important to attract foreign investment from different sectors. Arbitration matters are currently being sent to other jurisdictions, such as New York, the United States of America, and the United Kingdom. The designation of Trinidad and Tobago as an arbitration center, once this bill passes into law, will contribute to the earning of foreign exchange when we establish ourselves as a preferred option for arbitration through, one, attracting Caribbean-based disputes from countries such as Guyana and other CARICOM nations, attracting South and Latin American-based disputes, and identification as a training center for arbitration. Mr. President, I could speak at length, but I will turn at this stage to look at the bill for the purpose of assisting members of this Honorable Senate to understand the significance of the legislation that we are seeking to ask the Senate to bring into effect as the law of Trinidad and Tobago. The bill is in 10 parts. Part 1 of the bill, Mr. President, most importantly, at clause 5, speaks to the objects of the bill. And it is quite clear from the objects of the bill everything that I have already been speaking to, and you will recall that it was that clause which the UNCITRAL Secretariat in their letter of the 6th of June paid particular attention to. So when we look at clause 5 of the bill, the objects of this act are to A, facilitate domestic and international trade and commerce by encouraging the use of arbitration as a method of resolving disputes. B, to facilitate and obtain the fair and speedy resolution of disputes by arbitration without unnecessary delay or expense. C, to facilitate the use of arbitration agreements in domestic and international matters. D, to facilitate the recognition and enforcement of arbitral awards. And E, and this was pointed to by the Secretariat, to adopt the UNCITRAL model law. We will see, for example, Mr. President, in Part 1, that the Act, and one would not find this in the 1939 legislation, the Act in its definition section defines what we now understand to be data message and electronic communication. So data message is defined in this bill as information generated, sent, received, or stored by electronic, magnetic, optical, or similar means, including electronic data exchange, EDI, electronic mail, telegram, telex, or telecopy. That is just one example, Mr. President, why I have said that I do not consider that I need to persuade this Honorable Senate that we should decline to pass this bill into law and remain embedded in the 1939 legislation, which presently is the law that obtains in Trinidad and Tobago. Mr. President, Part 2 of the Act, and may I pause before I go to Part 2, may I just spend a little time on Clause 8 and 9 of the Act. Clauses 8 and 9, in matters governed by this court, by this Act, a court shall not intervene except as provided in this Act, and Section 9 tells us the functions referred to in Sections 14, and a number of sections are given, shall be performed by the court. May I just, we will look at it when we go through the Act in detail, but may I just speak to the significance of these two sections? The significance of these two sections, Mr. President, is to give effect to the UNCITRAL model law that essentially allows the parties by consent to determine among themselves that they will have recourse to arbitration for the speedy, confidential, expert resolution of their disputes, and to the extent that they can do so, save as is otherwise expressly provided by this Act. And the expressly provided is articulate and clear. Section 8, a court shall not intervene except as provided in this Act. And the intention behind that, which speaks to the intent of the UNCITRAL model law, is to give contracting parties the confidence that by having chosen and having opted for a process of commercial arbitration, in the arbitration framework that this piece of legislation is setting up, the disputes will not get mired in the lengthy, expensive, protracted process that now obtains so unfortunately in the Supreme Court of this country. So what this bill is speaking to in its vision and its declaration to the international community is the expeditious resolution of commercial disputes, so that parties can with confidence know that they will not only be able to resolve their disputes within an expeditious period of time, but can get on with doing business with each other within that short space of time when once the dispute has been resolved at arbitration. And that is the significance of Sections 8 and 9, among others, in this legislation that we are asking the Senate today to pass. If we look at Part 2 of the bill, Mr. President, Part 2 deals with the arbitration agreement. And we see that Clause 10 defines the form of the arbitration agreement. And again, there are some significant passages in here that tell us that we couldn't possibly even imagine accomplishing this in the 1939 time warp that Arbitration Act Chapter 5, Number 1 has us quoting. So we will see not only that an arbitration agreement, and I am at Clause 10, speaks to the fact that it must be in writing, but we will see that, as an example, at Clause 10.4, the requirement that an arbitration agreement be in writing is met by an electronic communication which contains the terms of the arbitration agreement if the information contained therein is accessible so as to be usable for subsequent reference. And throughout this bill, you will see that it recognizes that the reality in which we live, trade, engage in commerce today is propelled and developed through the medium of electronic communication, and therefore the legislation recognizes that contracts can be formed by an exchange of emails in no time at all, provided, according to normal contract law, the terms of those contracts are sufficiently clear so as to be enforceable. So, without dwelling unduly, I emphasize the modern concept that this legislation, this bill, is asking the Senate to embrace so as to put Trinidad and Tobago on a platform from which it can attract significant international commerce and business. Mr. President, Part 3 of the bill speaks to the composition of the arbitral tribunal. And you see that Clause 13 tells us immediately, and this is the core of what arbitration is about, the parties are free to determine the number of arbitrators. So it is the parties to the contract who, in the first instance, are going to choose those persons who will enable them to resolve disputes which may arise in the currency of the performance of the contract. So that they will go in the area of energy, in the area of telecommunications, in other highly specialized areas, they will be able to select by agreement one or more arbitrators who are specialized and skilled in the area of the contract so as to be able effectively to give justice to a fair determination of the dispute which has arisen. And Part 3, Clause 10, Clause 13 goes on to tell us that if the parties fail to be able to pick to choose the arbitrators, that is one of the limited instances, and you see at Clause 14, in which one might go to the court to ask the court to appoint an arbitrator if the parties are unable to agree. So it is not that the court has been entirely excluded, but the function and role of the court is limited to allow primacy to the agreement of the contracting parties, not only to contract, but to resolve the disputes which may or may not arise. And that goes very significantly, Mr. President, to the composition of the arbitrators. We will see at Clause 14 of the bill that there is explicit inclusion that a person shall not be precluded by reason of his nationality from acting as an arbitrator. So the significance there is that international business coming to do business in Trinidad and Tobago will have the confidence of knowing that they can approach the other party to the dispute to say, let us bring in someone from outside of Trinidad who has a degree of specialization in this area in which our dispute has arisen, so that we are confident that the dispute will not only be expeditiously resolved, but resolved by someone who has the specialized competence in the area of our dispute. And the prime examples are telecommunications, intellectual property, energy contracts, where you require a level of expertise. You will see clauses 14 to 18, Mr. President, allowing for a procedure for grounds of challenge of an arbitrator on the basis of justifiable doubts as to his or her impartiality or independence or qualifications, and the procedure for such a challenge are set out at clauses 15 and 16. Clause 17 addresses the circumstances where there is failure of the arbitrator to perform his functions or fails to act without delay. Clause 18 addresses the appointment of a substitute arbitrator. And clauses 19 through 20 deal with recommendations, a situation in which there is the possibility of an umpire who will be chosen to assist in the resolution process, where I read from paragraph 19, where the parties have agreed there is to be an umpire, they are free to agree as to what the functions of the umpire are to be. Part 4 of the bill before this Senate, Mr. President, speaks to the jurisdiction of the arbitral panel, the arbitral tribunal. And the jurisdiction there, it is emphasized at clause 21 that an arbitral tribunal may rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement. And there are provisions in this bill, Mr. President, which speak again to the issue of expedition, even where there may be disputes that arise where the arbitral panel is being asked to ascertain whether it has proper jurisdiction, the process continues in the interim. And that speaks to one of the areas that became quite pervasive in the commercial litigation. I recall when I was in private practice and Chief Justice de la Bastide was Chief Justice of this country, the area known as collateral attacks. It became quite prevalent in the civil courts. Whenever a dispute arose, an interim dispute, to bring side winds into court, to get the court to determine dispute A or B, and to delay the final determination of the actual dispute that went to the high courts. And I recall Chief Justice de la Bastide was very keen to produce rules that would eliminate, and judgments that would eliminate those collateral attacks. Well, built in to this jurisdiction of the arbitral tribunal in the bill that we are asking the Senate to pass are safeguards against collateral attacks, because even if you bring challenges while the arbitral panel is sitting, the arbitral panel continues to sit to adjudicate and eventually will in due course determine the side challenge that has been brought without impeding the process of the tribunal getting on with its work. Mr. President, the clause 5 deals with interim measures and preliminary orders. And that is an important part of the interim protection that can be afforded to parties whilst the tribunal is adjudicating on the dispute. So that clause 22 says, unless otherwise agreed by the parties, an arbitral tribunal may, at the request of a party, grant interim measures. And there is detailed provision made for interim measures and preliminary orders to be made by the arbitral panel whilst the dispute is ongoing, to provide for protection with adequate security being provided by the party who is asking for interim measures, so as to ensure that the process is not abused. Mr. President, clauses 22 through to 32 of the bill deal with those interim measures and preliminary orders and are quite detailed to protect the parties from any interim damage that may occur while the disputes are engaging the attention of the arbitrator, and are comparable and even improved on the processes that have been developed by the common law in our civil courts to ensure that throughout the arbitral process, parties are adequately protected and are confident to ensure at the end of the arbitral process that they have got due process and the protection of the law. When we go to part 6, Mr. President, conduct of arbitral proceedings, we see that equal treatment is accorded to the parties, clause 33. Clause 34 allows the parties to agree on the procedure that they will employ in the manner in which the tribunal conducts its business. Clause 35 allows, in today's world, not, I dare say, in the world of 1939, for virtual hearings to be conducted in arbitration, so that one party to the contract can remain in London and be assured of the fact that in the seat of arbitration taking place in Trinidad and Tobago, that party is getting a fair hearing. Clause 39(1) allows for the parties to agree on the language to be used in arbitration proceedings, because we recognize that in the international world in which we live, not everyone speaks the same language, so that the parties can make agreement for the language in which the arbitral tribunal will engage the fair adjudication of the dispute. Part 7 of the bill allows for the making of awards and the termination of proceedings. Some notable features: Clause 46, the arbitral tribunal is to decide a dispute in accordance with rules chosen by the parties as applicable to the substance of the dispute or the law of the state with which the subject matter of the proceedings is most closely connected. Clause 47, any decision of the arbitral tribunal where there is more than one arbitrator is to be made by a majority of all of its members. Clause 49, there is provision for the form and content of the award to be in writing and signed by the arbitrator or majority of arbitrators. Clause 50, every written agreement is to be deemed to include a provision that the costs of the arbitration shall be in the discretion of the arbitral tribunal. And at Clause 51, it is provided that the arbitral tribunal has the power to award interest.
Attorney General, you have 5 more minutes.
Thank you very much, Mr. President. We see Part 8, recourse against the award, takes us to Clause 55. And I would emphasize, with reference to Clause 55, the number of circumstances in which the parties are allowed to ask the court. This is where the court is allowed an interventionist rule. The number of instances in which, and I look now at Clause 55, recourse to a court against an award may be made only by an application for setting aside in accordance with subsections 2 and 3. And that subsections 2 and 3 set out the circumstances in which the award may be set aside. Mr. President, Part 9 deals with recognition and enforcement of awards, and then we go finally to Clause 10. In the totality and the complete overview of this bill, which is before the House, Mr. President, I would like to emphasize that the urgent implementation of a modern arbitration regime is required, consistent with the UNCITRAL model law, if Trinidad and Tobago is to get in line and stay in line with the growing trend in favor of the resolution of commercial and other disputes by non-judicial mechanisms. It is vital that the modern arbitration laws of Trinidad and Tobago are enacted if we are to be considered a place that is good for international trade and business and for attracting foreign investment. Mr. President, as I wind up, I look forward to the invaluable contributions of honorable senators on this bill, and in the circumstances, I beg to move. Thank you.
Honorable Senators, before I put the question, permit me to welcome the students of the Rio Claro East Secondary School that are joining us today in the public gallery. Honorable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Repeal and Replace the Arbitration Act, Chapter 501, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters be now read a second time. Senator Lakshmi Dayal.
Thank you, Mr. President, for the opportunity to contribute on this bill here today before us, which seeks to modernize our legislative framework for arbitration proceedings. Mr. President, alternative dispute resolution is undoubtedly worldwide recognized as something which we ought to embrace in order to save precious judicial time, to arrive at more amicable solutions to disputes, and it has served, the various forms of ADR has really served to do us well, particularly, for example, in the areas of family law, where mediation has been adopted to a large extent. And so it is incumbent upon us as a country to move forward with ADR, and particularly with this bill, we are looking at commercial arrangements and having arbitration become more significant and important and regulated in a modern framework so that it could be encouraged. Unlike mediation, where parties are assisted at arriving at an agreement, arbitration employs the use of a neutral third party who will adjudicate on a matter, much like a court hearing, because you still file statements, witness statements, your statement of case, defenses, and so on. But they are allowed to adjudicate the matter, and they have more flexibility in terms of the admissibility of evidence and weight given to evidence, and they are not confined to some of the strictures that you would find in traditional litigation processes. And so, depending on the nature of the contract that is executed between the parties, usually at the time that they are, let's say, for example, entering into a construction contract, they may include clauses which would specify things about the arbitration, and they may agree or disagree to be bound by the final arbitration award. Now, the thing about arbitration is that there is a lot of flexibility, and that is something that makes it attractive to the parties, because they get the opportunity to sort of set their own terms and conditions. And there are also many other benefits, and some of them I will discuss for the benefit of the public and people who would be interested in this area, because it's still not, I think, fully understood about all of the benefits that could accrue to parties in commercial arrangements when they adopt arbitration. And it is our duty to sell arbitration as an alternative to the persons who could benefit from it. Now, when you have two of the main advantages that are really sold to the public on arbitration relates to cost and time, because it is seen as something that can happen much quicker than you can get a matter, let's say, for a typical breach of contract claim through the courts. And given the state that what we're facing right now with our judiciary having a massive backlog of cases that need to be cleared, complex commercial arbitrations and complex commercial cases could actually be adjudicated upon much quicker through a means of arbitration. But the cost of arbitration is also something that is raised from time to time. Now, and I'll get to it a little bit later, because we do have to ensure that the cost factor is something that we look at, and we ensure that if Trinidad wants to become an attractive seat of arbitration, that we monitor and that we put things in place to ensure that cost-wise it becomes attractive for people to not just locally engage in arbitration, but to attract people to come here and utilize Trinidad and Tobago as a seat of arbitration. Now, the judiciary's last available annual report speaks to the importance of ADR as a whole, because in fact they listed it and listed the promotion of ADR going forward as one of their significant goals. I could not find statistics in that report about the number of matters resolved, for example, commercial cases by means of referral to an arbitrator. Those statistics were not available from the judiciary, unfortunately, but they did report a very high clearance rate for mediation when it came to things such as what we call running down actions. And that's important, and I think that it really does speak to the fact that if we promote and encourage this type of alternative dispute resolution, that we can bear fruit and improve our clearance rate for commercial disputes. In fact, what we could have happening is that these matters do not reach the courts at all. So rather than having matters filed in the court and utilizing court resources and then being referred to arbitration and so on, we can, if we have this modern, usable, implemented framework that really does encourage and really does enhance the attractiveness of arbitration, we could just see matters actually not reaching the steps of the Hall of Justice at all. And that is, of course, what we would want in a case such as this. So having this strong modern legislative framework is important to the country because, you know, the strength of your laws and the implemented framework can make the difference in how attractive the country will be as well for investment. In fact, when you look at the ease of doing business, one of the indicators that a country is judged by, it's the way they describe it is time and cost to resolve a commercial dispute and the quality of judicial processes. And that is unfortunately one of the areas that we have ranked lower than many of our Caribbean neighbors in recent times. So hopefully with this legislation, if we get it right, we can improve on that particular rating because we have in fact ranked lower than the Latin American and Caribbean average on that particular indicator. And so we want to improve on those things because that in itself will say, because people are hesitant to invest in a country if they believe that they will not be able to access swift justice in the event of a commercial type of dispute. So if we get this right, it could actually help us in more than one way in terms of not just attracting people to come here and utilize our arbitration services, but to promote foreign investors, foreign direct investment, and to attract foreign direct investment because persons will have more confidence to invest in a country where there is a substantial and working system to expeditiously resolve disputes. Disputes seem to be quite inevitable when you're dealing with multi-million-dollar contracts, construction, and all these very complicated commercial financing arrangements and all of that. They always have issues which arise. One of the things that that I didn't hear mentioned, but it's important to note, is that you could also have before the arbitration process an adjudication process that is built into many of the contracts. And the adjudication process is then subject to something that could be set aside by an arbitrator or a court later on, because that's the proviso that they include in the adjudication process. And many construction type contracts that I've seen include adjudication. So we have to take responsibility as a country to promote those types of clauses in contracts because there's no law, this law, and there's no other law can force people to go into arbitration. It is a voluntary thing. And even those standard form contracts from FIDIC and those things include arbitration clauses, those could also be modified. As the Attorney General said, it could be modified to include Trinidad would be the seat of the arbitration, or you could modify it and take it out altogether. It's not very common, particularly when you're dealing with cross-border type contracts. And the reason for that is because internationally, again, it is recognized and it is something that generally people want to have in their contracts. But I have noted, for example, typical clauses that refer to our existing arbitration law when you're dealing with lease arrangements, commercial lease arrangements, for example. You may have the parties, because you're dealing with people who sometimes are on unequal footing. And it isn't always attractive to tell, let's say, for example, a smaller business which may be leasing commercial space or equipment or something like that from a much larger enterprise, to say, well, listen, you're signing a lease or some sort of contract now, and you're agreeing to go the route of arbitration before you can get to the court. Because we have, there's some sense of comfort that people take in knowing that they can file a claim in the court and seek justice. They are perhaps later on disappointed when they realize how long it takes for the matter to go through the court process. But getting them to agree at the early stage of the contract, when everything is nice and rosy and you're happy to get into this arrangement with your business partner and so on, that if things were to go downhill, you will in fact have as your first stop, so to speak, an arbitration, and that you're agreeing to be bound by that arbitration. It may not be so attractive, especially to small to medium-sized businesses that are growing, because they may not understand. And they may be hesitant to say, well, I'm going to be bound by a decision by someone that we will have to agree on. They may feel that the imbalance in power between the two parties may affect the outcome of the award, and they may take some comfort in feeling that, no, I would prefer to go to a judge. So I have actually, in my personal experience, seen where people ask that that arbitration clause be taken out from sometimes, commercial lease arrangements and all of that, because they simply do not want to, at the get-go, bind themselves to something that is not a court, because a court of law and a judge carries with it a certain amount of confidence that people may have. And so we have to build confidence in the arbitration process if it is you want it to become that popular and to become, something that people will adopt easily in all types of contracts as an alternative to typical court processes. Apart from the benefits of time and cost, the benefit really of other benefits that could redound to parties involving who opt to engage in arbitration is really that the selected arbitrator could be trained in the particular field, which is the field of the dispute. So, for example, you may have someone who is an arbitrator who would be a specialist in construction law. You can have an arbitrator who might have experience in complex international commercial arrangements. We, unfortunately, and this is something that I would hope would be given consideration in due course, we don't have specialized commercial courts in Trinidad and Tobago like they have in the United Kingdom. In the United Kingdom, the commercial court, has a panel of really highly specialized and trained commercial law judges, and they would sit in the High Court and adjudicate on matters of this nature. In Trinidad and Tobago, if you file a commercial dispute, you go before any judge in the civil arena who is on the civil, who has a civil court docket in front of them, and you may end up before a judge who has no experience in commercial law. You may end up before a judge who has had a practice in family law or public law, but has never really done something specific to construction or has never done anything related to commercial contracts and so on. And if you were to go the route of arbitration, you can actually, because the parties are allowed to select and agree upon the arbitrator, and if you utilize services available for arbitration in Trinidad and Tobago, then you can, in fact, achieve the benefit of having a very specialized person to sit down and adjudicate upon your matter, and that can be very helpful as well. I say that then to say, however, that it is important to ensure, if we want this to work, that we do not have any sort of bar to persons becoming trained arbitrators, that we have a formal system of recognizing and registering our arbitrators, and that we open it up to an extent that you have arbitrators trained in many different fields so that you don't end up with a sort of a cartel of arbitrators, because that will, of course, result in increased cost. And then you lose the benefits of that you want here, or that you are touting of arbitration. Because as long as something is controlled, some sort of service, whether it's a product or a service or whatever it is controlled by a small group of people, then, they can control the cost. And we don't want that cost. We also don't want a limit on the range of experiences that the arbitrators may, in fact, have. So that would, of course, make the whole arbitration more attractive if you have that wide range of persons available in different fields, whether it is construction, experience with FIDIC contracts, international commercial arrangements, financing, and so on. Then you want to have those things available in Trinidad and Tobago to make it attractive to people to use it and to attract people to come here and adjudicate on those matters. Certification for arbitrators is something that is also important if you want to build confidence. And so hopefully coming out of this bill being promoted and here today, that there would be steps taken to assure the public of the certification and the quality of certification that is afforded to our local arbitrators in order to make it attractive in that regard. Now, if you want a bill to work, there are two things that I noted in the bill that I would want to speak on, and that is the clause 55, which deals with the setting aside of the award and also the issue of confidentiality. Before I get to that, though, I just want to talk about a little bit, as we were speaking about buy-in and having confidence in the arbitrators themselves. And the issue of buy-in comes a lot from consultation. Now, the Attorney General did mention that there was consultation in the bill coming back to 2019, and he listed a number of persons who were consulted. Whilst we have no reason to doubt what the Attorney General said in terms of the submissions and being taken into consideration, we don't know what the comments were coming from any of the parties. We haven't heard, there wasn't, as far as I'm aware, a public consultation on the adoption of this UNCITRAL model legislation. I have not heard, well, at least it didn't, to my knowledge, in terms of the Impact Justice Project and their model law. I don't know how much consultation they had on that law, because I understand from what the Attorney General was saying and from my own research that it is closely modeled on that particular model law. So locally, if you, again, you want arbitration and you're promoting arbitration as an alternative, you want to get buy-in. I noticed from the list of stakeholders listed by the Attorney General, I did not hear the JCC listed there, for example. They represent a number of bodies. And, you know, I would have liked to hear their contribution. I did hear him mention the Contractors Association. Well, they are members of the JCC, I believe. But, you know, we still don't know what their concerns were. And I wonder if this bill, because of the fact that it will affect so many stakeholders and it would affect so many persons, and because you want to, and the only way that it will really become attractive and get buy-in is if you hear people's concerns, I wonder if this bill would not have been something that might have been suitable for a joint select committee of both houses to sit and consider, because that is really the means whereby all of us and all parliamentarians could sit and listen to the concerns raised by the stakeholders. As it is right now, we are given the names of persons who were consulted or asked to provide feedback on the proposed bill, but we don't know what the feedback was. And we don't know what, if anything, was actioned after that feedback was sent. I have no doubt, I have no reason to doubt that what the Attorney General says in terms of it being taken on board, but I think I would like to, and I think other persons here would have liked to have the opportunity to interrogate the concerns of stakeholders in this, because that will give us the assurance as well. And again, I've noticed joint select committees attract quite a bit of, I never thought people used to pay attention to these things, but I think Senator Richards could agree with me. We sit on one particular committee that attracts quite a lot of attention. And I'm always, because I've sat on a few JSCs where we deal with legislation, I'm very impressed by the level of public interest and feedback that we get when we're dealing with legislation. So a matter like this, perhaps we should have, or maybe the government may still wish to consider whether or not they wish to refer it to a JSC, because all of the various stakeholders would have the opportunity to come before us. All of the stakeholders may have the opportunity to come before us, and we could hear their concerns, determine if they are legitimate, whether they're not, and if we could perhaps find a way to give assurance to the stakeholders who we want to utilize this bill. You see, talking about a classic objection, Mr. Vice President, it was not too long ago that we stood here listening to, a bill being promoted in this House by the government saying that they had buy-in and touting all the benefits of it, only to have land in our hand on that morning objections from the Law Association of Trinidad and Tobago. Yes, so we have reason to doubt them. Yes, and as much as I say that I have no reason to doubt the Attorney General when he says that from 2019 to now they've had consultations and that they were taken on board. I have no reason to doubt. Sometimes we have reasons to doubt, when they say that, all of the concerns and sometimes it isn't possible to address all of the concerns. And that's fine. I understand that, because I've, again, sat on JSCs where I've heard several unreasonable concerns being raised by stakeholders. But the Parliament as a whole should be allowed to be the judge of that. And the only way to do that is through a JSC.
Yes. Let's not fail things in secrecy.
concerns were raised and they were addressed by all of the stakeholders who are an important part of the operationalization and the success of this legislation, then there is nothing to hide. Full candor is, should be the order of the day. So there is no reason to hide from that and to look at it in that regard. Mr. Vice President, since 2017, Jamaica adopted this UNCITRAL model legislation. And, up to last year, I think it was, the 13th of December 2022, an article carried in the Jamaican newspaper, the Gleaner, titled, and if with your kind leave, I would read. Sorry.
Standing Order 51(1), E, F, and G, respectively. Thank you.
So the standing order being raised, honorable senators, is one of there being silence in the chamber while a member is contributing. So I would ask that we just control the level of talk that is happening, where there's mumbling that may raise to the point of slight disturbance to the member speaking. Continue, Senator Lakshmi Dayal.
Yes. Thank you, Mr. Vice President. Mr. President. Yes, Mr. President. And with your leave, I would just read a little bit from this article published in the Gleaner on the 13th of December 2022. And it is captioned, and of course we relate to our Caribbean neighbors because we all have similar experiences. Our culture is very similar and so on. And the caption is "Arbitration, a hard sell to Jamaicans." And when I read this article, it resonated with me because many of the concerns raised in the article, I could see them as being concerns here that we have to address. So we must learn from what they say. And it spoke about the fact that it says, even though Jamaicans enjoy an impressive track record in conflict resolution using ADR strategies, they are yet to be convinced of its effectiveness as an alternative to the well-established courtroom proceedings, Minister of Justice Delroy Chuck disclosed on Thursday. In fact, he admitted that it was a very hard sell to his countrymen. So passing the law is one thing, but selling it, really selling it, because again, as I repeat, there's no mandatory rule that you must resort to arbitration or that you must include an arbitration clause in your private contractual arrangements. And if we want more people to adopt it, we really do have to sell it. Now, it went on to say that, perhaps the judiciary, and I did note the Attorney General saying that the judiciary should not be left out of it, that they would be, they can refer and all of that. But I think that there needs to be more incentivization. And perhaps the government, after passing this law, can look at other countries and jurisdictions as to how else they can incentivize arbitration for parties. So don't just say, listen, you're guaranteed to get this thing done cheaper and quicker than if you go to the High Court, because that may not be enough. As I said before, the court is clothed with a certain level of respect and dignity, and it's looked at as, the route to go. And if you're making something literally alternative to the court system, it has to be made equally attractive. So, for example, if parties go to the court, but there is an arbitration clause in their contract that may be optional or something like that, and they opt to go that route, there should be some way that they could perhaps, recover some cost, or that the court can, afford them some. We have to be creative. We have to be creative to incentivize things, whether it's some kind of tax incentive, whatever it is, to just try to incentivize this, because we don't want to suffer the same route as Jamaica, having, they've invested in this legislation since 2017, they've adopted it, they've advertised themselves as an international seat of arbitration and look to develop themselves in the Caribbean as I think from what I've been reading, the foremost provider of these services, but they cannot even get enough locals, according to their own Minister of Justice, to buy into the process. So that being said, I want to look a little bit now at the issue of some of the specific clauses that I noted, and my other colleagues would spend some time on some of the others, but particularly the confidentiality clause. Now, confidentiality is another benefit that many people find of arbitration, because it allows you to conduct the proceedings in private, which is unlike court proceedings, which are, generally speaking, only in exceptional cases, you have closed proceedings. But when you're dealing with disputes that involve trade secrets, pricing information, and those kinds of things, it is attractive to have confidentiality. The issue here, and the issue which arose in a matter previously, is the fact that in this country, one of the largest procurers of services, whether it is construction or otherwise, and enters into contractual arrangements, is the state. And if you have wholly owned state enterprises entering into contracts in which there's an arbitration clause and then going the route of arbitration, the confidentiality clauses could then serve as a shield to prevent the dissemination of information which may be of interest to the public. And that, Mr. President, is something of concern to us. Because, you see, we do not want a situation to arise where, as much as arbitration has benefits, and I've spent the first part of my contribution, I would say, touting the benefits of arbitration because I'm in agreement with much of what has been said about it. I do not believe that our laws, our local, statutory provisions, which encourage, promote, and basically, solidify within our legal system the concepts of transparency and accountability when it comes to the expenditure of public funds should be trumped by any confidentiality that may arise out of arbitration. And there was an attempt to do just that with respect to an arbitration that took place between Petrotrin, at the time, a wholly owned state enterprise belonging to the people of Trinidad and Tobago, and a company by the name of WGTL, because there was an arbitration which Petrotrin won, and then there was the decision thereafter, based on what had taken place in the arbitration proceedings and documents supposedly, which were filed as part of those arbitration proceedings, decisions were taken by the government and the board of Petrotrin in relation to litigation, and it had a very strong political flavor, I would say, to those proceedings, and it was a matter of public interest. And when you had a litigant, and I will hear my learned friends say I come to Ravi down the debate, but when you had a particular public interest litigant going, yes, it was Ravi, of course, standing in defense of democracy as usual. And we had the foremost public interest litigant in the country at the moment, Mr. Ravi Bhalgovind Maharaj, filing a freedom of information request, right? He's good enough to force you to call an election. You can stoop so much you want, right? So you can stoop so much you want. No amount of stooping will change the fact that he forced the whole PNM government to call an election on the 14th of August. But that being said, Mr. Ravi Bhalgovind Maharaj had to file a freedom of information request to seek disclosure because he was very concerned about the decision of Petrotrin relying on information in these cloistered proceedings to discontinue the case against Malcolm Jones and that $1.3 billion loss that Petrotrin suffered in the WGTL project. And the fact that whilst that litigation was there and continued before the court, that this was a person who was, appointed to a standing committee of energy and all of that. So there were public concerns. And again, we had to go all the way to the Privy Council because they did not even wish to grant leave at the local level for, judicial review. And the Privy Council ended up ruling that that is a very arguable case when you are arguing the Section 35 public interest override in the Freedom of Information Act, as when it comes to the balancing that need for transparency and accountability against the rules of confidentiality in cases. In that case, it was the LCIA, London Court of International Arbitration Rules. And the argument being put forward in that case was really that, look, you cannot contract yourself out of statutory provisions that embrace accountability and transparency. And that was the concern in that matter. Now, by the time leave was granted, before the judicial review matter could see its way through the court, the documents were in fact disclosed. But I think it is important to look at that judgment and what the Privy Council says, because they said here at paragraph 46 of the judgment in that matter, and this is, forgive me, citation, 2019 UK PC 21, Privy Council matter at clause 46. Says, so far as concerns public benefits for the public interest of disclosure of, and persons are named, statements, the board considers that it is arguable that they are of significant weight with a view of securing transparency and accountability in relation to relevant decisions in a number of respects. Without seeking to be in any way exhaustive, the board refers to the following possible public interest benefits of disclosure. A, to enable the public to understand and, if appropriate, criticize decisions taken by Petrotrin in embarking on the joint venture and in entering into a guarantee which have proved to be so costly to it. B, to enable the public to be fully informed about those matters and Mr. Jones' involvement in them so that they could, if appropriate, criticize or oppose the appointment of Mr. Jones to roles within government with a focus on energy matters, such as his appointment as a member of the Cabinet Standing Committee on Energy. And C, enable the public to understand, if appropriate, criticize the decisions to bring a civil claim against Mr. Jones in the first place and then to abandon it. So, because this matter was a very convoluted one, it was one of grave public concern. So the Privy Council set out how much public interest you may have in a case like this, and it was a case specifically dealing with arbitration where confidentiality was invoked. Now, what we have here with confidentiality by way of clause 60, there was nothing in the old law, the 1930s law, that dealt with confidentiality. But we have now in this particular proposed bill by clause 60 that arbitral proceedings shall be private and confidential. It goes on to say that disclosure relating to the arbitration shall be actionable if there's a breach, unless, and then there are very specific areas that say that there is a, could be permitted and would not be actionable because it's an actionable breach if in fact there's a leak of the confidential information. And these things that are specified here, these circumstances in clause 62A to G, it does say is in the public interest. So I'm just I'm not concerned, but I really do want to ensure that it is understood that no rules, because we don't have rules yet made under this particular, legislation, but that no rules should be made or anything should be done that would circumscribe freedom of information. Because I do believe that freedom of information as it relates to public entities, wholly owned state enterprises, because they are such large participants in contractual arrangements, we must never, ever, ever allow any law to circumscribe that transparency that is afforded to the citizens of Trinidad and Tobago by good UNC law called the Freedom of Information Act. So after that, Mr. Vice President, the second area that I would like to look at is clause 55, and that is the setting aside what recourse against awards, right? This is in part 8 of the bill. Now, the previous clause 19 of the old legislation dealt with the ability to set aside an arbitral award. And this particular clause proposed in this bill is a lot more specific in terms of the grounds upon which the party could make the application, and you are required to furnish proof of that you meet one of these grounds. For reference, I would just read the clause 19 as it exists, section 19 as it exists in the Arbitration Act right now. Section 19 says, where an arbitrator or umpire has misconducted himself in the proceedings, the court may remove him, but before making such order, the arbitrator or umpire may, if the court so directs, be given an opportunity showing cause against such order. And an arbitrator or an umpire who has misconducted himself in the proceedings, or an arbitration or award has been improperly procured, the court may set aside the award. So that improperly procured, it's very broad. It is extremely broad in terms of the grounds by which one party may be able to approach the court to have the award set aside under our Arbitration Act. What you have here now is a lot more specific, and I am concerned that we do not limit the ability of a party to
Senator, you
go
have 5 more minutes.
Okay, well, that's that time fly. Yes, that we don't have, that we do not afford parties the full range of opportunities to go before the court and set aside an award. Again, Mr. Vice President, it is not in our too distant memory that there was a lot of uproar in this country about an arbitration award to a company by the name of AV Drilling, again involving Petrotrin. And it came to the public's attention that the attorney acting for Petrotrin had advised that the application should be made to set aside the award, and that advice was not followed, and alternative advice sought, and so on and so forth. So I say all of that to say that the ability of a party to go before the court, we ought not to circumscribe those things too narrowly. I know we are following model legislation, but again, when you are dealing with, in our local circumstances, a number of state-owned enterprises. You see, the problem we have with these state-owned enterprises that have specific roles and functions is that we treat them as though they are private entities, but they belong to the people of Trinidad and Tobago. And they ought to be seeking not a political objective, and they ought not to be seen to be pursuing political objectives, but they ought to be seen as pursuing the interests of the people of Trinidad and Tobago. And there was a lot of uproar regarding that matter, and I want to say that today, what I consider to be these criteria set out for an award to be set aside under section clause 55(2), I find them to be quite narrow. I find them to be very restrictive, and as much as it may seem attractive to have a situation where persons can feel that they would confidently be able to conclude their dispute by way of the arbitration, we don't want, in cases involving state enterprises and so on, that you have so much restriction in terms of the ability to apply to set aside the award. Mr. President, in closing, I just wish to say that we are not opposed to any form of ADR. We are not opposed to anything that will promote Trinidad and Tobago as a center for arbitration. And although we may have some catching up to do in terms of with Caribbean neighbors who have tried to get much more ahead of us and to market themselves in that regard, I want to say that it's possible, it could be done, but we want a strong framework. We also want a framework that will support, again, the interests of the citizens of Trinidad and Tobago. Something that I found to be very interesting, and I just want to make very quick mention of, is a Jamaican attorney who has served as Attorney General, I believe, in the Turks and Caicos Islands, or one of those islands, has actually introduced a completely virtual arbitration platform. And he's been doing it. It's been rolled out through the Center for Arbitration in Jamaica, and it's called iNeutral. And it allows, if I can, and I would just want to read a little bit about it. It was discussed in the Jamaica Observer, and it's something that was developed by Christopher Malcolm and called the Digital Peacemaker. And, I hope to see that if we are really going to market Trinidad and Tobago as a center for arbitration and encourage people locally to get involved in arbitration and to adopt arbitration, that we could also be creative in the use of this type of technology to now take it beyond the courtroom setting, to take it beyond any sort of traditional methods, because, we have to adopt this type of technology. And if our regional counterparts are already doing it, then we have a lot of, we have some catching up to do if we want to be competitive. And, Mr. President, I would close by saying, however, that there's no substitute for consultation and buy-in, and I reiterate that, again, if we want to really get this right and get it working and make it attractive, we should have, the Parliament should have the opportunity to really consult in a deeper and more meaningful way with our stakeholders. I thank you.
Senator C. Prasad.
Mr. President, thank you for the opportunity to contribute to the debate on the Arbitration Bill 2023 and other related matters. As defined, arbitration is a form of alternate dispute resolution in which the claimant seeks redress from the respondent through an independent arbitrator. The court is usually not involved, but the matter can be referred for arbitration by the court, or the arbitrator may seek the court's involvement when the arbitration process fails. Arbitration in Trinidad and Tobago is currently governed by the Arbitration Act 501, enacted in 1939 and based on English arbitration legislation of 1889 and 1934. It does not reflect modern best practices, and it's not in line with international commercial legislation. In fact, Mr. President, quite a few of our laws fall into this category and require updating and/or replacing. The current Arbitration Act provides that an arbitration agreement is irrevocable except by the leave of the High Court and shall have the same effect in all respects as if it was an order of the court. Trinidad trade and industrial practices have changed dramatically since 1939, but our laws relating to arbitration have not been modernized. In 1939, which is 83 years ago, there were no computers, photocopiers, cell phones, or the internet, just to name a few, but our arbitration laws remained trapped in the early 1900s. Mr. President, the bill before us is based on the United Nations Commission on International Trade Law, UNCITRAL model, and you can find it in clauses 2 and clause 5E of the bill. UNCITRAL was established in 1966, pursuant to a resolution of the General Assembly of the United Nations. Its mandate is to further the progressive harmonization and unification of the law of international trade, and in that respect to bear in mind the interests of all peoples, particularly those of developing countries in the extensive development of international trade. Pursuant to that mandate, UNCITRAL formed a committee of expert jurists that formulated a model law which was adopted on June 21st, 1985. The objective would be that it would be adopted by many worldwide jurisdictions to standardize and harmonize the laws relating to arbitration and dispute resolution. Since then, the model law, as amended on July 7, 2006, has been adopted by 86 divergent legal and economic states in a total of 119 jurisdictions, including Jamaica, Barbados, the British Virgin Islands, Australia, India, Hong Kong, Singapore, Canada, and the United States. Arbitration has become a standard requirement in most modern contracts for the resolution of disputes. And if Trinidad and Tobago intend to attract international trade and investment, and become a more attractive venue for international arbitrations to be held, it is important that our arbitration laws are recognized and approved by UNCITRAL as being in line with the model law and certified by the Secretariat and included in the list of jurisdictions that have adopted the modern law. Mr. President, businesses, including international investors, demand neutral, timely, cost-efficient, enforceable, and predictable arbitration and dispute resolution mechanisms. Modern arbitration legislation will encourage disputants to select arbitration as a means of resolving their disputes and differences, thereby relieving the courts of hundreds, if not thousands, of matters that would otherwise have to be litigated. The backlog of cases awaiting trial will be invariably reduced. Clause 5 of the bill. Mr. President, businesses are not prepared to wait 2 or more years to have their cases heard and then face the possibility of an appeal resulting in further delay and possibly compromising operations. Businesses will prefer an independent, neutral person with subject matter and dispute resolution experience to hear the evidence and submissions of the parties and then have an expert arbitrator rule on the matter based on the provisions for dispute settlement which are included in the contract. According to the 2019 World Bank Doing Business report, Trinidad and Tobago ranks 174 out of 190 countries in the ease of enforcing contracts. It takes 1,340 days, or about 3 years, 8 months, to resolve a commercial dispute in Trinidad and Tobago, whereas in Latin America and the Caribbean region, it takes 768.5 days, or 2 years, 2 months, to resolve commercial disputes in the first instance courts. Arbitration offers several benefits over litigation. 1, speed and efficiency. Arbitration is generally faster than litigation. The parties involved can select their arbitrator or arbitrators who will dedicate specific time to the case. This allows for more streamlined proceedings and quicker resolution compared to the often lengthy court process. Clause 5 of the bill. 2, flexibility and informality. Arbitration offers greater flexibility in terms of scheduling and procedures. Parties can agree on the time, date, and location of the arbitration, making it more convenient for all involved. The process is generally less formal than litigation, which can lead to a more relaxed atmosphere. Clauses 33 to 45 of the bill. 3, expertise and specialization. Parties can choose arbitrators with specific expertise and knowledge in the subject matter of the dispute. This allows for decisions to be made by individuals who have a deeper understanding of the industry or technical aspects involved, potentially leading to more informed and well-reasoned outcomes. Judges have expertise in law, but do not generally have deep knowledge in industry or have the technical expertise. Clauses 13 to 20 of the bill. Clause 19 and 20, use of an umpire. Mr. President, the use of an umpire is not part of the UNCITRAL model. I would be grateful if the Honourable Attorney General would provide his thinking on deviating from the UNCITRAL model and including the use of an umpire in the bill. 4, confidentiality. Arbitration proceedings are typically private and confidential. Unlike court cases, which are generally open to the public, arbitration offers a greater level of confidentiality. This can be particularly beneficial for disputes involving sensitive or confidential information that the parties prefer to keep out of the public domain. Clause 10 of the bill. 5, cost effectiveness. While arbitration does involve costs, it can be often more cost-effective compared to litigation. The streamlined nature of the process and the ability to choose arbitrators can help reduce expenses as compared to discovery, court fees, and other litigation-related costs. Clause 50 to 54 of the bill. 6, finality and enforceability. Arbitration awards are usually final and binding, providing certainty to the parties involved. Arbitral awards enjoy greater enforceability under the New York Convention on the Recognition and Arbitration of Arbitral Awards, clauses 48, 56, and 57 of the bill. 7, preserving business relationships. In commercial disputes, arbitration can help maintain business relationships between the parties, as arbitration offers a more cooperative and less adversarial environment. It can provide an opportunities for the parties to preserve their working relationship while resolving their differences. However, Mr. President, while I generally support arbitration over litigation to settle disputes, there are some potential disadvantages to consider. 1, limited recourse to appeal. In arbitration, the right to appeal an arbitrator's decision is generally more restricted than in litigation. The grounds for challenging an arbitration award are typically limited and usually involve demonstrating serious procedural irregularities or arbitrator misconduct. This limited recourse to appeal can limit the opportunity to correct potential errors or obtain a different outcome. 2, lack of formal discovery. Compared to litigation, arbitration often has more limited discovery procedures. This means that parties may have less access to information and evidence that could be crucial to their case. This can potentially result in a less comprehensive presentation of facts and a reduced ability to uncover critical evidence. 3, cost allocation. While arbitration can be more cost-effective than litigation, it is not always the case. The costs of an arbitration can still be significant, especially if complex issues or multiple arbitrators are involved. Additionally, arbitrators often charge fees based on their hourly rates, which can add up over the course of the proceedings. The parties are generally responsible for paying these costs, which can be a disadvantage for parties with limited resources. 4, limited precedential value. Unlike court judgment, arbitration awards typically do not establish binding legal precedents. This means that subsequent arbitrators are not necessarily bound to follow the reasoning or outcome of previous arbitration cases. Consequently, arbitration may lack the consistency and predictability that could be achieved through a well-developed body of legal precedents in the court system. 5, lack of public scrutiny and transparency. While confidentiality can be seen as an advantage, it can be a disadvantage in certain situations. The private nature of arbitration means that the proceedings and the decisions are not available to the public. This lack of public scrutiny and transparency can raise concerns about accountability and fairness, particularly in disputes that involve matters of public interest. 6, limited remedies and relief. In some cases, arbitration may not offer the same range of remedies and relief as the court system. For example, certain equitable remedies or injunctive relief may not be available in arbitration. Depending on the nature of the dispute, this limitation could be a disadvantage if the parties require specific types of relief that are not within the scope of the arbitration. Mr. President, while arbitration can be a viable method of dispute resolution in many cases, there are certain circumstances where it may not be recommended. I will provide a few situations where arbitration may not be the most suitable option. 1, inequality of bargaining power. If there's a significant power imbalance between the parties involved, arbitration may not be the best choice. The party with less bargaining power may feel pressured to agree to arbitration terms that are unfavorable or biased against them. In such cases, a court proceeding with established rules and procedures may provide a more level playing field. 2, public interest and legal precedent. When a dispute involves matters of public interest or the interpretation of important legal principles, litigation may be preferable. Court judgments establish binding precedents that can guide future cases and ensure consistency in the application of the law. Arbitration, on the other hand, does not create legal precedents and may not adequately address broader legal issues. Mr. President, notwithstanding the provisions of Section 60, I'm concerned that any of the parties have the ability to deliberately conceal matters in the public's interest using arbitration. 3, the need for immediate injunctive relief. If a party requires immediate injunctive relief, such as a court order to stop certain actions or preserve assets, arbitration may not be the most effective option. Courts have the authority to grant such relief promptly, whereas the process in arbitration may not be as expeditious, potentially resulting in a delay that could be detrimental to the requesting party. 4. Complex matters of law or public policy. Arbitration may not be suitable for disputes involving complex legal issues or matters of public policy. Courts are equipped with established legal systems, extensive rules, and a judiciary experienced in handling intricate legal matters. The flexibility and informality of arbitration may not provide the same level of legal expertise and comprehensive analysis required for complex cases. 5. Limited discovery and evidentiary issues. If a dispute necessitates extensive discovery procedures or access to third-party evidence, arbitration's limited discovery process may be inadequate. Courts typically offer more robust mechanisms for gathering evidence, including the subpoena power and broader discovery tools. In such cases, litigation may be more appropriate to ensure thorough examination of the evidence. 6. Need for appellate review. If the parties desire a more extensive review process or believe that there may be significant legal errors in the decision, litigation may be preferred. Arbitration awards generally have limited grounds for appeal, while court judgments may be subjective to more extensive appellate review. It is important to note that the suitability of arbitration depends on the specific circumstances of each case. Careful consideration needs to be given to the parties' goals, complexity of the disputes, and the nature of the issues involved when deciding whether arbitration is appropriate to resolve the dispute. In my view, it is necessary to update our ancient arbitration laws and processes in keeping with modern international practice. This is a necessity so that Trinidad and Tobago enhances its position in the Ease of Doing Business Index, become a more attractive place for international investors, and becomes a seat for international arbitrations. Thank you, Mr. President.
Honourable Senators, before I call on the next speaker, permit me to revert to item 8 on the order paper. Senator Mark.
To the Honourable Minister of Finance, in light of the $913.5 million losses or lost suffered by the Heritage and Stabilization Fund in 2022. Can the Minister indicate the specific investment portfolio areas which resulted in the losses and whether government continues to monitor same to prevent further losses? Mr. President.
Minister of Finance.
Thank you very much, Mr. President, and let me apologize for not being available at 10 a.m. I have a team here from the Fiscal Affairs Division of the IMF providing very important technical assistance. The information that Senator Mark requires is available in the 2022 report of the Heritage and Stabilization Fund, which covers the period October 1st, 2021 to September 30th,
2022. It is a public document because it was laid in Parliament by me in February of this year, 4 months ago. It will be available from the Parliament, and in fact, it should be available to all senators. Specifically, the concept that the loss in 2022 is a catastrophe, I would ask the Honourable Senator, don't be like the Express, please. I would read the data for the comprehensive income of the fund. I can start with 2015. The comprehensive income for that year was $120 million. 2016, the comprehensive income was $305 million. 2017, the comprehensive income was $429 million. 2018, the comprehensive income was $203 million. These are all positive numbers. 2019, the comprehensive income was $288 million. 2020, the comprehensive income, positive income, $457 million. 2021, the positive comprehensive income, $624 million. So if you take just those years that I just called out there, from 2015 to 2021.
Minister, the time frame for the answer has expired.
Thank you.
Senator Mark.
Yeah. Mr. President, you know, I feel a sense, or put it another way, the weight of history seems to be weighing on me. Because I'm looking at whether we have a Houdini.
No, Senator Mark, just question. Is that, again, I have repeated ad nauseum that there's a time frame for these proceedings. So just please pose the question as succinctly as possible.
I asked the Honorable Minister when I'm seeing a magician before me. I just want to ask the Honorable Minister, as ultimately responsible for this Heritage and Stabilization Fund, how can he explain to the people of this country the disappearance of close to 6 billion TT dollars? Let the minister through you tell the people of this country how
Senator Mark, it sounds a lot more like a statement as opposed to a question.
Can I ask?
So you've asked the question, I've got it. Minister of Finance.
Thank you very much, Mr. President. I was reading out those figures there because if you total them, you'll get in excess of $2 billion with a B, US dollars. The comprehensive income so far for 2023 is in the order of $700 million US dollars. So if you add the comprehensive income over the period I just mentioned, 2015 to 2023, and you subtract the loss in 2022, you will get somewhere in excess of $2 billion US dollars, or 12 billion Trinidad and Tobago dollars. The whole point is that one has to look at these things from a long-term perspective. As I said, don't be like the Express. The fund has earned $12 billion over the last 5 years.
Minister, that is the time for urgent questions has now expired in its totality. So we shall now revert back to the proceedings that was occurring prior to the reverting to item 8. Minister of Trade and Industry.
Before I even start, Mr. President, 51, point of order, 51 E, G, and F.
Okay, so we have heard what that standing order refers to earlier, and I would just ask once again that we maintain a certain level of silence to allow the member contributing to make their contribution. Continue, Minister of Trade and Industry.
Thank you very much, Mr. President, and let me say how pleased I am to be able and honored to be able to say some words on this particular bill, which I can say from the outset that I support as Minister of Trade and Industry 100%. So I'm happy to contribute to the bill, which in the first instance would repeal and replace the Arbitration Act, Chapter 501, and in the second provide what would be a very modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters. And you would know that one of the core responsibilities of the Ministry of Trade and Industry is to grow trade, business, and investment. And as such, much of the activities that we are engaged in are geared towards creating this very facilitative and supportive environment for business through all sorts of initiatives and programs. But it is also through the development of modern and appropriate legislation, and this is what we have come here today to do, and I can say that this bill will support business and investment activities and trading activities and so on. This bill will seek to improve the trade and investment climate in Trinidad and Tobago, and of course, and it will assist with all of the ministry's efforts to holistically upgrade the framework for attracting investment and also exports as well, increasing our exports. As it stands, we are continuing to expand and increase our efforts in terms of expanding exports regionally and internationally. And once you're speaking about internationally, there's every likelihood that there would be agreements entered into. So it's not only just about investments, it's also for all the entire gamut of business activities, because once you're talking about beyond the region, internationally, you're likely to get into commercial agreements, and therefore, as a natural consequence of this increased internal and cross-border commercial activity, there is the likelihood of having increased disputes, potential disputes, which normally would occur in the course of doing business. So, and we know, of course, and many speakers before me have spoken to the reasons why arbitration ought to be chosen as against the normal course of action through the courts, and I will not go there necessarily, but just to add my voice to the fact that international arbitration, commercial arbitration is increasingly the preferred choice for businesses, and I almost said large businesses and multinational corporations, but I would hasten to add that this also would be useful to SMEs as well, and in terms of their choice for remedy where there are issues in their contractual arrangements and so on. Okay, so generally, I would say that it's definitely the preferred course of action, and especially where we look at circumstances around international litigation. Usually, the outcomes can be unpredictable and unreliable. It could be costly, and it could be riddled with time delays and so on. Again, supporting the bill which we've come here to discuss today. I just want to I want to go to, Mr. President, a paper which was published by the World Bank in 2013, setting out the results of a study in respect of arbitrating and mediating disputes in 100 economies, and among other things, the effect on foreign direct investment. And the study posited that economies with better systems for the arbitration and mediation of disputes tended to receive more FDI inflows. All the more reasons why we should, in fact, support the bill which is before us, Mr. President. And it will be recalled that a medium-term goal for Trinidad and Tobago was outlined in Vision 2030, and I can't leave Vision 2030 out of the picture. The National Development Strategy of Trinidad and Tobago, under Theme 4, in particular, building globally competitive businesses, is for Trinidad and Tobago to be a premier investment location and for businesses to be the producers of a wide range of products and services and so on. And the short-term aspiration is for Trinidad and Tobago to be a more attractive destination for investment and for trade and for the business environment to be conducive to entrepreneurship and innovation and to contribute to the economy as well. So with that said, I can just strictly go now. I can go straight to the objectives of the bill, which fits well into our national objectives. And the speakers before me would have attached themselves to Clause 5 of the bill, which provides a snapshot of what the Act seeks to do. And I will just truncate these objectives and to say it will facilitate. It's the facilitation of domestic and international trade and commerce. It's the facilitation and achievement of a fair and speedy resolution of disputes by arbitration without unnecessary delay or expense. It is the facilitation of the use of arbitration agreements in domestic and international affairs. It's the facilitation of the recognition and enforcement of arbitral awards. And finally, the adoption of the UN Central Model Law. And I go right into. There's no need for me to speak any longer about why one would favor the arbitration system as against the courts or so on. I'm not going to go into there. But again, let us recognize, Mr. President, that the majority of contracts that cross borders into international markets implement mechanisms to settle disputes through international commercial arbitration. That is the modern construct of these kinds of agreements. So the importance of commercial arbitration and the need for a bill like this arises from the difficulties with local and international firms facing when they use the domestic courts in another country's jurisdictions to enforce cross-border contracts. Hence, its arbitration is usually embedded as a mechanism that is embedded into their agreements, especially with regard to all of these cross-border agreements. And so I can tell you that I've put together 9 reasons why this bill would be of benefit to trade, business, and investment. And one, and we spoke earlier about the flexibility, a previous speaker, but I would truncate here. Arbitration is a robust yet flexible alternative to resolve commercial disputes. And it is, again, I made the point that Trinidad and Tobago will receive greater economic benefits and reduce barriers to trade where domestic and international trading and investment partners are assured that their disputes can be efficiently handled and dispute settlements easily reinforced. And the bill affords users a really viable and effective alternative to litigation to settle this domestic and international disputes of a commercial nature. And it provides a modernized and harmonized approach to arbitration in Trinidad and Tobago, and it offers an escape from the long-winded litigious process before the court. And the current act, need I say, the current act before us is inadequate. It's also inconsistent with international practices, and it presents a slew of problems which seem to deter parties from utilizing it as a tool for dispute settlement. And there are all sorts of problems. And one of the major ones that I picked up in my research is the fact that the arbitration agreement, this is within the current law, the arbitration agreement is not separable from the main contract. And what this means is that where a contract contained an arbitration clause and an arbitration tribunal found that the contract itself is invalid and unenforceable, the arbitration clause could not be separated from the rest of the contract, and itself would be considered valid and enforceable. So again, that's a reason why one should not would be attracted to the arbitration approach, but in a more strengthened piece of legislation. Clause 21 of the bill would remedy this in that it provides an arbitration clause that forms part of a contract shall be treated as an agreement independent of the other terms of the contract. In other words, in direct contrast to the old piece of legislation, right? It provides, as I said, clause 21, that the clause that forms part of the contract shall be treated as an agreement independent of the other terms of the contract, and that where an arbitral tribunal finds a contract is null and void, it is not automatic that the arbitration clause is also null and void. So that's a huge plus. And the other kinds of problems that you have with the existing legislation, which we will now replace and repeal, is that arbitrators do not have the power to determine their jurisdiction. Arbitrators lack powers to grant orders of interim relief, and in the absence of agreement by the parties, the default number of arbitrators is 1, and there is no reference to the appointment of an umpire to resolve deadlocks in the appointment of arbitrators. And the grounds for setting aside an award are limited to misconduct by the arbitrator and the improper procurement of the arbitration of the award. There are excessive opportunities for interference by the court, again, under the old system, such as the power of the court to set aside the appointment of an arbitrator in certain circumstances, etc., etc. And therefore, with the passage of this bill, arbitration will provide parties to a dispute with a more flexible process, and then allowing them, therefore, to choose to follow rules of a recognized institution, to also to design their own procedural framework, which is tailored to the particular trade dispute at hand, and also be empowered to select the number and the identity of the arbitrators that they wish to appoint, and ultimately they would have some input or control as compared to litigation, where the legal system and its processes are fixed, and the parties have no control over the date of hearings, the adjournments, the filing of documents, etc. So again, this robust arbitration framework that we're putting in place now would send a strong message to our investors and our traders and our business persons, again, that our business environment is much more stable and efficient and fair. And of course, I think this will make all the parties feel a little bit more secure when they're dealing with especially with their overseas suppliers and their franchise and financiers, franchisors, and so on. The second benefit I would go to would be the intervention by subject matter experts in trade or business and investment. And by its very nature, trade and investment, it's very wide and varied and complex. And disputes can arise from anywhere, and it could be quite complex and technical in nature. And very few persons could really understand and appreciate the catalyst that will give rise to these kinds of disputes. And I mean, how would you remedy these grievances without adding damage to the commercial relationship? Because ideally, the parties would want to deal with the issue at hand while preserving the commercial relationship. And this is what the new legislation will allow you to do. Arbitration, again, in this case, and I am speaking about the intervention of by a subject matter, it will be overseen by an arbitrator who usually possesses some kind of expertise in the subject matter at hand, where under the court system, a judge probably would lack that kind of expertise. And parties to the dispute will have a wide discretion when choosing the arbitrator, and they can seek to establish the credentials of a potential arbitrator before appointment to ensure that the person has sufficient expertise in trade or investment or in business as with regards to the particular dispute. And that particular screening and assessment process can help in avoiding delays and costs associated with the extensive technical briefing of a less experienced arbitrator. right? And clause 43 of the bill provides for the appointment of experts by the arbitral tribunal to report to it on a specific issue, which would have to be determined by the arbitral tribunal, or require a party to give the expert any relevant information, or to produce or provide access to any relevant documents, goods, or property for inspection by the expert. So, I mean, with the appropriate expert, whether it be trade, investment, or business, again, this intervention would lead to successful outcomes and with the particular dispute at hand. And again, greater speed. The other benefit that I would go to, the third benefit, would be the strengthening of the overall arbitration laws in Trinidad and Tobago. And you know, Mr. President, we are signatory to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention. Trinidad and Tobago would have enacted the arbitration foreign arbitral awards, which was passed in 1996, and which gives the New York Convention some effect in Trinidad and Tobago. And that means that an award pursuant to an arbitration agreement in a state that is party to the New York Convention, that can be enforced. That award can be enforced in Trinidad and in Tobago. And further, Trinidad and Tobago also gave effect to its ratification of the International Center for Settlement of Investment Disputes Convention through the enactment of the Investment Dispute Awards Act, which was passed in 1968 and facilitates the enforcement of awards in certain investment disputes. So once this bill is passed and subsequently enacted, it will provide for a very robust legislative scheme governing and regulating arbitration in Trinidad and Tobago. And again, this is an alternative feature, as domestic and international investors would have a secure means by which to arbitrate and to enforce their cross-border disputes and so on. The other benefit, again, I would go to awards. And Part 7 of the bill provides extensive details on the making of an award and on the termination of proceedings. And again, this would be of interest to all of the parties involved in any trade or commerce or investment dispute in Trinidad and Tobago. And because it will offer guidelines in terms of rules and guidelines that would be used by the arbitral tribunal to determine a dispute. It will aid in determining how decisions will be made by the arbitral tribunal. There will be guidelines which are to be adhered to where settlement is agreed during the course of the arbitral proceedings. It will determine the form and contents of the award. It will determine the cost of the arbitration. It will determine the cost associated with an aborted arbitration. And it would also give guidance as to when terminating an arbitral proceedings, and it would also govern time limits as well as the process by which an award or an additional award may be corrected and interpreted. So again, Clause 51 of the bill also provides adequate details on the possibility of interest on the award, and I don't think that it's important for me to go in any further on this. But another plus, again, would be the recognition and enforcement of awards. And therefore, once a winning party has successfully obtained an arbitration award, if the unsuccessful party does not voluntarily want to comply with it, there are steps to be taken to enforce it. And therefore, two noteworthy clauses of the bill that speaks to enforcement of awards would be Clause 30 and, of course, Clause 56. And again, Clause 30 of the bill states that where interim measures are issued by an arbitral tribunal, it will be recognized as binding and enforceable upon application. Clause 56 also provides for the fulfillment of this objective, as it stipulates that an award, irrespective of the country in which it was made, shall be recognized as binding, and upon application in writing to the competent court shall be enforced, provided it does not fall within one of the exceptions detailed at Clause 57. So again, it gives you that other additional support with regard to recognition and enforcement of awards. We spoke earlier, someone spoke earlier about confidentiality. Confidentiality could only be a plus, and as it stands today, with arbitration steadily steadily emerging as an alternative to litigation for resolving disputes, commercial disputes, confidentiality continues to remain one of its most extenuating features. And a commercial arbitration proceeding differs from traditional litigation in the sense that both parties agree not to disclose anything in relation to the dispute and the arbitration proceedings, including documents, transcripts, notes of the evidence in the arbitration and award. And therefore, I think it's very important because, again, I had said before that companies really want to preserve their commercial arrangements and agreements. It's only where the dispute arises they want to be able to deal with that and move forward to their continuing commercial arrangement. So that it is a fact that most companies and businesses will not want to publicly be associated with having a matter settled before the court, especially in instances when it can result in loss of goodwill or so. It can happen. Putting the matter through the court, dragging it in the public domain, really can erode a company's goodwill. And therefore, goodwill relates to business and profits, etc. So this bill, in its construct, provides these companies and businesses with a better mechanism and a good alternative with the prime ethos of, yes, speed and limitation and limitation of costs and so on, but a high degree of confidentiality. And Clause 60 of the bill, Mr. President, will provide for arbitral proceedings to be held privately and confidentially, as opposed to the court proceedings, which are open to the public. And is further bolstered, this Clause 60, by the imposition of sanctions, whereby if there's a disclosure, either by a tribunal or a party to the proceedings, it would be actionable as a breach of an obligation of confidence unless the disclosure is authorized or required. So, therefore, another plus. And generally, I would say that this would aid against affecting a company's reputational damage and so on. So, very, very important. Overall, another plus would be the lower transaction costs. It will enable, of course, to strengthen the enforcement of commercial contracts, the passage of this bill. Generally, with proceedings where there are experts involved, you have chosen the arbitrators, etc. The time is constrained, and therefore, generally there is lower transaction costs ascribed to arbitration. And then another plus would be for the whole question of foreign representation. And I mean, the litigation to resolve cross-border disputes, let us admit, can be quite daunting for parties, whether you're a national or international investor and so on. So the bill before us seeks to eliminate this barrier to investment in terms of having to contract counsel in a particular jurisdiction, which is going to be quite expensive and so on, and of course finding counsel with the particular expertise as well. So this bill eliminates this barrier to investment by allowing the parties to investment and business to choose a foreign representative who is not required to be entered into legal practice in Trinidad and Tobago, and that is a huge plus. So that according to Clause 58, parties can choose a foreign legal representative, and such a representative is not required to be enrolled as an attorney of law under the laws of Trinidad and Tobago, since for the purposes of their bill, their appearance in an arbitration will not constitute legal practice as defined by the Legal Profession Act. The representative will also be exempt from payment of taxes and fees, or payment of taxes or fees once the arbitration lasts for a continuous period of 30 days or less within 1 calendar year. And I mean, this provision will encourage international companies to look towards arbitration as a really viable option to dispute resolution instead of looking immediately towards litigation. It will be expensive, and therefore international firms can retain their trusted counsel from anywhere in the world and not have to rely on going through the process to find legal representation in a foreign country. And as I said, costs will be substantially reduced, also. But there is that caveat that it must off a period of 30 days or less in a period of the 365 days of the year where that person would be exempt. Again, the ninth prospect and ninth benefit that I would go to is the fact that this new arbitration legislative framework creates an opportunity for the development of our professionals. And so, Mr. President, the bill represents a change in legislative framework which will require adaptation and adjustment by our professionals, for example, our lawyers, our engineers, chartered surveyors, which will and they are all likely to be participants in this process, and therefore, the bill and the arbitration in and of itself would offer many exciting prospects for our professionals to become specialized in this niche area, to sit as arbitrators or to appear before an arbitrator. And really, it can spur the development of a new cadre of holistic and flexible dispute professionals. And I want to say, Mr. President, that there's already been an increase in the training of persons to become arbitrators across the region, including in Trinidad and Tobago. And as in my research, I found out that as of 2019, there were about 191 members of the Caribbean branch of the Chartered Institute of Arbitrators working across the region, including lawyers and engineers and chartered surveyors and so on. The Trinidad and Tobago chapter of the Caribbean branch, as of 2019, had a membership of approximately 60 fellows, members and associates, and I'm sure by now that figure has grown many times over because there are a number of interested professionals I know that I myself know of have found the area exciting and have found themselves being trained and to be able to enter this field. I spoke earlier about the fact that this may seemingly be attractive to large businesses and large commercial entities and potential investors and so on, but I want to highlight its utility to small and medium-sized enterprises as well. And a recent study developed by the Commonwealth Secretariat's Office of Civil and Criminal Justice Reform on international commercial arbitration shows that SMEs in the Commonwealth, and I think it's an interesting statistic, which make up 95% and 99% of the private sector, are often reluctant to trade beyond their national borders, and that is in fact so. I say that because I live it all the time as a result of the anxiety and the very intimidating circumstances and the costly task of having to tackle a commercial dispute should a commercial dispute arise with suppliers or buyers in another jurisdiction. And so it is that when we're going along on trade missions and so on, I make a point of ensuring that the SMEs come along with us and they understand the laws and the environment, the business environment, particularly those outside the CARICOM areas and so on. Again, we want our SMEs to continue now to trade beyond into the region to external countries. I'm talking about DR, by example, where we went to, and I say beyond the CARICOM region. And again, usually you would find that the whole question of the dispute would tend to dissuade or deter SMEs from engaging in extensive commercial business activity outside of Trinidad and Tobago. But again, I think this construct of the bill would bring some ease to SMEs in terms of the ability to solve these disputes when they arise a little bit more easily than as a traditional bill would have allowed. And another study done in 2019 by Petra Butler and Georgia Whelan, entitled "Does the Dispute Resolution Regime in Europe Really Serve Micro, Small and Medium Enterprises?" found, Mr. President, that international commercial arbitration will be able to fulfill the SME's cross-border dispute resolution needs to a greater extent than the current default mechanism of cross-border litigation. So this is to be hailed as a benefit, this legislation here today, as a benefit to all SMEs as they seek to extend their wings outside of Trinidad and Tobago and beyond the region as well. Yeah? I also I also looked at some of the local case law in respect of arbitration. And in fact, I'd asked myself when, in doing the research, tell me about some of the local cases and so on. But it reminded me, Minister, of course, you know this is confidential in nature, so obviously you can't find it. It's not available unless, of course, the matters are reported in the press, or for some reason the matter then has to be taken before the courts and so on. But in any event, there are cases. Senator Janti Lachmadale would have chosen those, selected those that she wished to speak about, and there are others, and I don't think I need to go into to very many of them, but there would have been the case of Motilal Ramhit and Sons Contracted Limited versus the EFCL, where in that case the court was required to determine whether a stay should be granted in accordance with Section 7 of the current Arbitration Act, or the inherent jurisdiction of the court, after the first defendant argued that the claims before the court ought to be referred to arbitration as agreed by the parties. And the learnings from this, at paragraph 17 of the judgment, the court concluded that in all of the circumstances of the case, it did not consider that there were any bars to the court granting and exercising its discretion to grant a stay of the proceedings to permit the matter to move forward expeditiously to arbitration and to return to the court swiftly thereafter if the arbitration was unsuccessful. Some learnings, therefore, from some matters before the court. And there have been, I saw cases related to sport as well and so on. I need not go into that. But I look generally at arbitration in the Caribbean as Minister of Trade and Industry with a keen interest of the region. But in the region, I would tell you, I went right to the CSME to understand and to bring to this House the relevance of arbitration. So, Mr. President, paragraph 2 of Article 74 of the revised Treaty of Chaguaramas, establishing the Caribbean Community, including the CARICOM Single Market and Economy, mandates member states to harmonize their laws and administrative practices in respect of commercial arbitration. And someone highlighted before, we are a little bit behind. I'm speaking about the region. There are countries that have moved ahead, but at the same time, we are all called to move in sync with the revised treaty of Chaguaramas and more particularly the CARICOM Single Market and Economy. And so we are all encouraged to harmonize our laws and administrative practices in respect of commercial arbitration. And I could go directly and quote, paragraph 1 of Article 223 of the revised treaty directs member states to encourage, and I quote, to encourage and facilitate to the maximum extent possible the use of arbitration and other modes of dispute settlement for the private settlement of private commercial disputes among community nationals as well as among community nationals and nationals of third states. And further, paragraph 2 of Article 223 mandates each member to provide appropriate procedures in this legislation to ensure observance of agreements to arbitrate and for the recognition and enforcement of arbitral awards in such disputes. And this is why we are here today, and I'm sure that there's no party in this honored place today that would not support the bill which is before us, of course, given the construct as well, given by the CSME within the RTC. And again, so Clause 5 of the Arbitration Bill calls for the facilitation of domestic and international trade and commerce by encouraging the use of arbitration as a method of resolving disputes. And in this way, we would be positioned to fulfill our mandate under Article 223 of the revised treaty. And I think many persons, some of the persons who spoke before me would have spoken about they would have made reference to Caribbean jurisdictions and in general, the fact that we are lagging behind. And so, we are really called upon to support this bill which is before us and move swiftly towards implementation of this very modern legal framework. We are playing some catch-up. There are only a few countries within the region that have moved towards the setting of these arbitration centers. But I want to say that there have been some inroads, and I'll take the positives, including Trinidad and Tobago, in terms of the establishment of bodies to provide and promote arbitration services. I want to say that, and I must point out, the Dispute Resolution Center of Trinidad and Tobago was developed by the Trinidad and Tobago Chamber of Commerce and officially launched sometime in 1996. So it's quite some time now that we've been involved in ADR. And it was launched then by the by the then Chief Justice Michael de Labastide. And the center aimed to be the premier institution for the promotion and operation of ADR training system within Trinidad and Tobago. And since then, of course, that center offers parties a choice of local and international arbitrators, and many of whom are retired High Court and Court of Appeal judges and so on. And this center has a long-standing representation on the International Court of Arbitration, first led by, of course, so there have been some positives. First led by Mr. Justice Warner, then of course, after that, the Honorable Justice of Appeal Roger Hammersmith, with senior local attorneys and former judges like Honorable Madam Justice Ernestine Seeley, Honorable Justice of Appeal Humphrey Stallmeyer, and the Honorable Justice Lionel Jones, having been appointed to sit on the International Court of Arbitration. So Minister, there have been...
You have just under 5 minutes.
Thank you. So that there have been some inroads made by Trinidad and Tobago and some successes, right? But today, what is before us is the need to upgrade our arbitration legislation, and I'm sure that we will all support it, and of course, and by that example, encourage many of our Caribbean neighbors, apart from the BVI and Barbados and Jamaica, to get on board and to bring and to put in place this this very piece of healthy legislation. So I spoke about, as I conclude, I spoke about the advantages of efficiency and speed and cost effectiveness, confidentiality, and finality, enforceability, expertise, flexibility, neutrality, and all of this, right? And I would say that adoption of this UNCITRAL model law would encourage all of our businesses and our domestic and international partners or regional partners to look toward arbitration as a preferred form of commercial dispute settlement and so on. So instead of spending years tied up in our courts and so on, disagreements can be resolved speedily and efficiently by referring to an arbitral tribunal as agreed on by all of the parties. And of course, the chosen arbitrator, as I've said before, can have, or is expected to have, or will be designed to have, the choice would be that of someone who has specialized knowledge, and therefore encouraging early agreement to the dispute at hand and so on. And of course, this is going to help us to open up all sorts of prospects, and this bill, in addition to the other constructs within the Ministry of Trade and Industry, the new initiatives like the Special Economic Zones Initiative, and also the new Trade and Investment Agency, Trade and Investment Promotion Agency, all of these new mechanisms will in fact be attractive to international investors and also local investors as well, and really would encourage extensive trading activity. And by so doing, we have the private sector contributing more, greater to our economy. And that, at the end of the day, is always the result that we want, which would, at the end of the day, comes down to the benefit of the people of Trinidad and Tobago. At the end of the day, when we pass this legislation, again, we will be positioning our country to be a modern location for international arbitration in the Caribbean, Mr. Deputy President, or Mr. Vice President, and I want to thank you.
Senator Mark.
Mr. President, Mr. Vice President, as I rise to contribute to this particular bill known as the Arbitration Bill, I want to begin by posing a question which I will seek to resolve at the end of my contribution, or before the end. I hope that this Senate, and by extension the Parliament, is not being used by unknown and unseen forces to promote their own private, selfish agenda. I say no more. I say no more at this time. Mr. President, Mr. Vice President, this bill is supposed to contain some 10 parts and some 68 clauses. It was tabled on May the 23rd. When I checked the time frame, it would make us 21 days from that date. It took the government 5 years, draft after draft, in order to arrive at the bill that is before us today. But we are being asked to speed up, to pass this measure. Today, a very voluminous, complex, detailed piece of legislation that took the government 5 years, and to give us, the lawmakers, Mr. President, Mr. Vice President, less than 20 days. With no research staff, we had to fight on our own to do serious research. Mr. President, you know, when we were dealing with the land acquisition measures some time ago, I brought to your attention, and this honorable House attention, about a television program back in the 80s known as the Highway to Heaven. Highway to Heaven. And I said the highway that was being built from Komuto to Guayco to Toko, going through Manzanilla some time later on, is really known as the Highway to Heaven. Because we have evidence to show where big Sawati and Papis bought up lands along the Guayco main road before the construction of the highway got going.
Point of order, Mr. President.
And we have the evidence here.
Standing Order 46-1, please.
Senator Mark, as much as you have now started your contribution and you are introducing, you need to bring it into the bill. And I understand it's an introduction, but let me just add that within that debate, those claims that you were making were responded to already.
Why my friend is so jumpy? Okay? I want to ask you, Mr. Vice President, and I want to quote a standing order for the benefit of this honorable Senate. Because this Senate and us here in the opposition will not be used by anybody to promote their own private agenda. So I want to ask, Mr. President, through you, I want to ask, through you, Understanding Order 42.5, I wanted to ask the Attorney General who piloted this bill today why he did not declare, why did the Attorney General not declare his interest in this bill? Why he didn't do it? That is a contempt of this honorable Parliament. If you have a previous or a current financial or pecuniary interest in any company that promoted arbitration
Senator Ma.
in this country. I am asking why.
Have a seat. Senator Ma, come on my feet. Are you raising a standing order or are you speaking?
I am asking you to rule on standing order.
Have a seat, Senator Mark. Have a seat, Senator Mark. Have a seat, Senator Mark. Have a seat in silence, Senator Mark. I would like you to sit. Yes. You need to. Senator Mark, can you take a seat, please? Senator Mark, within the remit of the introduction of the bill by the Honorable Attorney General, all matters would have come to pass that needed to come to pass. If it is needed that he needs to clarify, you can ask so in summation. But your comments are bordering on another standing order of imputing improper motives. Kindly get to the task at hand and discuss the 10 clauses and the 68 clauses and the 10 paragraphs, please.
President, Mr. Vice President, I have evidence that I am standing by. You could take me to the Privileges Committee. You could have it.
Yes, bring it, sir.
I have evidence, Mr. Vice President, to show where our Attorney General, who piloted this bill, was the chairman of a company called Dialogue Solutions. Dialogue Solutions. And I have the evidence here. I have the evidence here, Mr. President, and that is why I invoke 42.5. Because I wanted to know.
Mr. President, on a point of order, please. Mr. President, on a point of order. 46.6. The Attorney General is the titular head of the bar. The Attorney General is senior counsel of long standing, and this is a matter of law. Arbitration is a matter of law. Obviously, he has an interest in the matter in his position as Attorney General.
46.6 upheld, Senator Mark. 46.6 upheld. Okay. Can you move on to your next point, please?
I'm not in Mr. President, this is the Senate of Trinidad and Tobago. Yes. This is the Senate.
Correct.
And I am telling this Honorable Senate that in 2019, the Attorney General in private practice, Honorable Member, Minister of Tourism, Mr. President, was the chairman of a company called Dialogue Solutions. And Dialogue Solutions, Mr. President, Dialogue Solution was launched, according to the information I have before me, on the 11th of October 2019. And you know who was the chairman of it? Who? Reginald Amor, the Attorney General. Reginald Amor.
As raised before by yourself, Senator, Standing Orders 51, 1E, F, and G. Kindly allow the member to make his contribution in silence.
So, Mr. I am not casting any aspersions, I mean facts. Facts I have here.
But who else in our company?
So, Mr. President, Mr. Vice President, I am saying they cannot take the Senate for granted. The Attorney General had a duty and a responsibility under Standing Order 42.5 to declare and disclose his interests. Not as Attorney General, but as a former member of a company that promoted arbitration. That's what I'm arguing here. And what I'm saying, Mr. President,
what I'm saying is that I have a statement when this company was launched on the date I have here is the 11th of October 2019. That is when this company was launched. So, and the chairman of the company, according to what I have before me, is now our Attorney General. Well, all right, all I'm saying is that he was there before. And I'm saying that whatever happened in the past, you have to declare it now. That is what I'm saying, Mr. President. I am not against the Attorney General, you know. All I'm saying is that declare your interest. Say, look, in the past, honorable members of this end, I was the chairman of Dialogue Solutions, and that company that I led offered arbitration services, mediation services, alternative dispute matters. That is all I'm saying, Mr. President. And when I look, Mr. President, at some of the, I would like the Attorney General, when he's winding up, to tell us if that company is still alive, if it's dead, or if somebody buy it out. I want the Attorney General at the end of this debate to tell Trinidad and Tobago if Dialogue Solutions is still alive, it's dead, or somebody else buy it out. Mr. President, Mr. Vice President, hear what's going on now. I shocked when I saw the membership of the board of directors. I saw the independent Senator Anthony Vera, as a director on this board. I can't believe it. He's a director
Mr. President,
of the board, right? And I'm saying,
point of order.
Mr.
President, Mr. Vice President, on a point of order 46(6). No senator shall make an imputation of improper motives against any member or...
Senators, a member is on his feet raising a point of order. Kindly allow him to do so.
Thank you, Mr. Vice President. Or an offensive reference to a member's private affairs. Mr. President, Senator Mark has now gone ad nauseum into exactly this with respect to two senators who are currently members of this chamber.
Senator Mark,
you can bring a
you
substantive
are treading
motion.
on a dangerous slope. I ask that you bring it back to the debate as it applies to the debate. 46(6) in this case is upheld. You are not just carrying an individual, but you're carrying a portion of the Senate into disrepute at this moment.
Mr. President, I say I am prepared for any member to take me to the Committee of Privileges. Any member, I am prepared. Take me to the Committee of Privileges. You have the evidence here. I have the evidence here. I have the evidence.
Mr. President, on a point of order.
Senator Mark, the volume and the use of language is unsenatorial at this stage.
I apologize to you, sir.
Can you have respect for the chamber that we're in through the chair? Please.
What I'm saying is that I was just putting to you and bringing to your attention that we are debating a very serious matter. And it was incumbent upon our Honorable Attorney General to just indicate to this House that he was formally associated with a company. That is all.
Senator Mark,
interest.
Senator Mark,
that is all.
Careful when you're sitting, please. Many standing orders have been raised for the same point that you are laboring. I ask that you move on from this point. It has been taken into record, and I am sure a response or an answer will come forthwith.
So as I move on, Mr. Vice President, one Elizabeth Solomon who's a judge of the Industrial Court, is also a member of the board of directors of this body. So all I'm asking, Mr. Vice President, is that these are matters that ought to have been declared. Mr. Vice President, I just want to quote a statement for this Honorable Senate without referring to the name of anyone. But I'm quoting a statement. Just a
Senator
statement.
Mark, as you are very well aware, 46(8) does not allow for the use and calling of names of judges at any point in time in any debate. I'm giving you a stern warning of the standing order 46(8).
I'm guided, sir. I'm guided. I am quoting from a document I have here. And I want members of this Honorable Senate, including your good self, sir, to pay attention. We will not be used. Never. Mr. President, I quote, to this end, listen carefully, it's worth pointing out that members of our board have been key. Listen to this, sir. Members of our board have been key to drafting the arbitration bill.
Senator Ma. Senator Ma, have a seat.
Senator Mark, the standing orders that have been raised in relation to what is before us, as put forward by the Vice President of the Senate, please adhere to them. Continue.
And I'm guided, sir. Mr. President, I'm glad you're back, because you will understand what I'm doing here. I am not casting any aspersions on anybody. I'm just giving some facts. And if I'm wrong, you are there to guide me. And I appreciate that. What I'm saying, Mr. President, without calling names, I'm quoting from a document. And I can share this document with the entire Senate. Right? Where we are being told in a document coming from the lips of an individual, right, that the members of our board has been key to drafting the arbitration bill for Trinidad and Tobago, which will modernize the legal framework for arbitration in Trinidad and Tobago. So I am quoting from a document, Mr. President, showing that we are dealing with something called the Arbitration Bill, and we are being told in a document in 2019
Mr. President, on a point of order.
Was responsible for drafting.
Let there be silence in this chamber. This type of behavior will not be tolerated. On many occasions, I have indicated that there is a simple procedure to follow. When a point of order is being raised, there will be silence. It is raised and then dispensed with by the chair. Nothing else will be tolerated. Point of order.
Mr. President, Senator Mark persists under standing order to violate standing order 46(6). All of this is under the rubric of imputing improper motives, particularly, Mr. President, as he has not indicated the document from which he is quoting.
So, what we are dealing with before us is the Arbitration Bill. Senator Mark, what you are speaking to, be very, very careful, because it does fall under the rubric of imputing improper motives, because that is the essence of what you're saying and putting forward. Tread extremely carefully.
Mr. President, I think I have said enough, Mr. President, on this matter to allow the Attorney General the opportunity when he's winding up to make a confession to this House. Mr. President, I would not pursue this matter any further.
President, on a point of order.
Have a seat, Senator Mark.
Sorry, sir. About this. Yes, I'm going to.
Mark, I just spoke to the procedure. Have a seat, Senator Mark. Point of order.
Mr. President, Standing Order 46.6, Senator Mark has persisted in his deliberate imputation of improper motives in this chamber.
So, Senator Mark, 46.6 has been raised. Move on from that point. It is not to be repeated in any way, form, or fashion.
Mr. President, you know, some time ago when I was speaking, I spoke about a concept called state capture, where the private sector, in collusion with the government and politicians, conspire, Mr. President, in decision-making in an effort to promote private interests at the expense of public interests. And I also made the point that it takes many forms, and one of the manifestations is legislation. And what I was attempting to do, based on my research, I was trying to determine, for instance, how this bill arrived here. And I did my research. And I came upon the matters that I brought to your attention, which I'm not going to go through, because you have advised me to stick, right, to what I'm saying. But, Mr. President, I want to tell this honorable Senator through you, this opposition bench will not be used and abused and cornered in promoting legislation that has a private gender origination. Mr. President, my understanding is that this industry is valued at over $25 billion. That is the prospects. And the question here, I think my colleague, Senator Jayanti, when she was speaking on arbitration, Mr. President, she was making the point, we have to avoid cartel formations. And Mr. President, what we are seeing on our landscape in Trinidad and Tobago is one or two companies that are involved in arbitration, or what you call, Mr. President, alternative dispute resolution, which is a term that captures mediation, arbitration in TNT. I have a second one. It has nothing to do with no member of parliament here. I have a second one here that tells me, Mr. President, that we need to understand that there's a company in Trinidad and Tobago called ADR Services Limited. And they have a second company called B&B Transformation or Transformative Solutions. And when you look at the bio of these companies, they are all specializing in arbitration
mediation, or what I would want to say called ADR services. And when I looked at the team here, I see a fellow called Professor Jerry Brooks. He's leading this company. And you have a host of other people whose names I wouldn't call because they're not members of parliament. But so what I am asking this government, what is the policy here? And the AG was very specific when he was winding up, Mr. President. He said this thing is urgent, and we need to address this matter
Senator Mark,
and have it passed.
have a seat. The essence of your arguments thus far are going down a line of imputation. Before us, we have a bill with 68 clauses. And in a debate, it is expected that you would state your opinions based on the clauses that's in the bill before us. You have been speaking for some time now, and as I've indicated, everything that you've said is going down one particular line. I would ask you now to get to the clauses of the bill and state your opinions on that.
Mr. President, may I ask for your guidance on this matter? I understand when we are dealing with second bill or bill second reading, we deal with the merits and the principles, which is really the policy of the bill. Now, à part ça, we look at the clauses, but when we go in the committee stage of the bill, that is when we deal with the clauses in detail. Before that, my understanding is that the merits and the principles and the policy of the bill is what we are dealing with.
Okay, so one, this is not a debate. You're not debating me. Two, I have indicated that the essence of what you're saying is in breach of the standing orders. And I've guided you and invited you to get to the bill by way of the clauses and the contents therein moving forward. This is the final warning on that.
Mr. President, I am guided by your warning. I am guided. I say no more on this, except outside I will say more. Mr. President, let me indicate to you 68 clauses in this bill, 10 parts. In this bill, I asked the Attorney General, where is the code of ethics for the arbitrators? I see none. When I look at comparative legislation, I am seeing where they have code or codes of ethics. When I look at the Mediation Act that was passed in 2004, I see a code of ethics. So, Mr. President, I'm asking the question, where's the code of ethics? I would like to ask, Mr. President, through your good self, let's go on to what is called, Mr. President, as you would want to direct me and advise me, and I take your advice. Let's go to clauses 63 to 68, Mr. President. Mr. President, are you following me? Are you following me? Yes, I am. Okay, good. Okay. So when we go between 64 to 68, I see where the Attorney General has arrogated unto himself the power to make rules and regulations. But the Parliament seemed to be just a tribune on the way. So we are asked to approve 68 clauses, 10 parts, Mr. President.
Mindful of brandishing the paperwork, as you're well aware, in order to do so, you would need the prior approval of the chair.
No, I'm not sure. No, this is the bill.
Senator Mark, that is not allowed.
Okay, sir,
just
sir, all right,
you know
sir,
how to do it. You know how to do it. So just make sure you don't brandish it.
Okay, thank you. Mr. President, what I'm saying is that in clause 65, it states that the Attorney General may make regulations generally for giving effect to the purposes of this act. But in many civil suits and many matters, where the Attorney General is involved, the citizens on civil matters would sue the Attorney General. So the Attorney General is conflicted. So I am saying, Mr. President, when you look at clause 65 of the bill, the Attorney General wants to make regulations without any oversight, without any supervision, and the Attorney General is conflicted under the law. Because if there's a civil suit in the court and the government has not paid me money for my work, Mr. President, I sue the Attorney General. And if in that contract, Mr. President, there's a provision that talks about arbitration, I will then have to subject my company to arbitration because it is in the law. It is in the contract, which is a law. The question here, Mr. President, how can the Attorney General be in a conflicting situation and then give himself the authority to make regulations? It doesn't make sense. So I am suggesting, Mr. President, that we delete that completely. And if he's not deleting it, bring the entire Parliament into it. In other words, if the AG wishes to make regulations, Mr. President, he does that with an affirmative resolution of the board Parliament. Let us be involved in it, and not just the executive through the Attorney General. So that is an area that I would like to ask the Attorney General to consider. Mr. President, in going through this bill, I also observed that there's no provision for an annual report. And I would like to suggest with your leave, Mr. President, that the Attorney General consider inserting into the legislation an annual report, so that as the Parliament has given life to this piece of legislation to modernize and to reform arbitration matters in our country, both at a domestic and international level, Mr. President, we should be privy to either an annual administrative report to see how we are progressing as a nation, since we give the permission to go ahead with it within a legal framework, rather, Mr. President. So that's the point I'm making, an annual report. And the other area, Mr. President, I'd like to suggest for the Attorney General's consideration, Mr. President, has to do with a review of the legislation. You would recall that we first passed arbitration law in 1939. That is the act that we are seeking to replace and repeal in this act or bill that is before us. The next time you had what is called an amendment was in 1981. And then we had another amendment in 1996, 1997, when we brought legislation called Foreign Arbitral Awards Act of 1996, 1997, which gave effect to what's called the New York Convention. The New York Convention is the convention of 1958 that allowed all states to engage in arbitration in spite of languages. Luckily, Trinidad and Tobago, Mr. President, based on my research, acceded to that convention since 1966 with 2 reservations. So we have been in the forefront of moving towards arbitration as a means of settling international disputes. And that is why we signed off on the convention known as the New York Convention. We signed off on that. And that is manifested here. So what I'm saying, Mr. President, the last time we brought amendments to our legislation on arbitration before this day, where we are debating the Arbitration Bill of 2023, was in 1996. I am suggesting, Mr. President, we don't have to wait for 26 years. to come back to review. So I am suggesting to the government, through the Attorney General and the government team, kindly insert, Mr. President, a provision in the legislation that will subject this law to review every 3 years. So that is another provision I'm suggesting to enhance and upgrade and strengthen the legislation. Mr. President, if we are to promote arbitration as a means, Mr. President, as a means of settling international commercial disputes between parties, there are 3 essential bedrocks that we need to pay attention to. We need to pay attention to political stability in our country. We always have to be promoting political stability. That is a very important ingredient in promoting arbitration as a means of settling disputes between parties. Another important area, Mr. President, that we need to pay attention to is the respect for the rule of law. There was recently a project called the Justice Project. And the Justice Project is an international document, Mr. President, which shows that our principle of the rule of law, the scale, the ranking of our country is going down and going down and going down and not up. So how are we going to seek to promote arbitration when the rule of law is being shown internationally, Mr. President, as one that is under threat in Trinidad and Tobago? So it's a contradiction. So that's the second ingredient, Mr. President, we need to promote if we are considering, Mr. President, this arbitration. And not only arbitration, Mr. President, the Honorable Attorney General said that we wish to promote Trinidad and Tobago as an international arbitration center where we can attract foreigners to our country to engage in discussions on matters of in dispute for settlement purposes. So if we are to attract foreign investors to our country and use Trinidad and Tobago as an international arbitration center, I'm saying, Mr. President, political stability, respect for the rule of law, and most importantly, the existence of an independent and impartial judiciary in our country. That is another fundamental principle that you have to focus on, Mr. President, as we seek to promote arbitration as a means, Mr. President, of seeking to settle disputes internationally within our borders. Mr. President, I think the Honorable Attorney General said when he was speaking that all our FIDIC contracts have this provision on arbitration. Trinidad and Tobago, the Trinidad and Tobago government spends between $25 to $30 billion a year in the acquisition and the procurement of goods and services. And they do that, Mr. President, through central government, through local government, and through the state enterprise sector.
Senator Mark, you have 1 more minute.
State enterprise sector. So that is an area that I would like to ensure that the government does not use the state enterprise sector, does not use its authority to funnel these matters to selected companies and firms that are associated with the ruling party. That is what we have to avoid, Mr. President. That is my concern. And finally, the Honorable Attorney General talked about attracting foreigners to earn foreign exchange. But you know what, Mr. President? If you have the choice, and that is right, to bring in a foreigner as opposed to a local, what is going to happen? We are going to have a drain on our foreign exchange. So on the one hand, we want to attract and earn foreign exchange. On the other hand, we might be draining foreign exchange. Mr. President, this is a very important bill. In closing, I call on the government to have this matter referred to a joint select committee so that the public and interest group can come forward and give their perspective on the matter. Mr. President, I thank you.
Senator Timal.
Mr. President, I do thank you for the opportunity to contribute to this bill before us. Mr. President, we have all heard about the many benefits to be derived from structured arbitration, particularly where the conditions of agreement for arbitration are well outlined, succinct, and can be easily interpreted, not by the arbitrators only, but actually by the many parties who engage in contractual arrangements with each other for mutual benefit. So I will not really go much into that because I think that has been well covered. But Mr. President, with your permission, I'll go straight into the bill itself before us. And I will go to section 4(2), which deals with the application of the Act. And section 4(2) speaks about the provisions of this Act apply only if the place of arbitration is in Trinidad and Tobago, except sections 11, 12, 30, 31 and 32, 56 and 57. Now, Mr. President, with regards to section 11 of the bill, the essence of the section tells us that the court can refer the parties to arbitration in matters which is the subject of an arbitration agreement. Also, sections 12, 30, 31, and 32 deals with the court granting an interim measure of protection. Now, the Honorable Attorney General did mention in his contribution that the interim measures is indeed a marked benefit to parties under this Act. But coming back to the question, section 11, the question I have is, by not allowing this section to be applicable to domestic arbitration, are we not depriving the parties who seek resolution under domestic arbitration the opportunity where the court can refer the parties to arbitration? Are we denying the parties subjected to domestic arbitration this feature of the bill before us? And although the provisions of sections 22 to 29 allows for interim measures and preliminary orders, we need to note this is by the arbitral panel only when it comes to domestic arbitration. And the role of the court is not being allowed for domestic arbitration, again, regarding interim measures and preliminary orders, except for those powers being granted to the arbitral panel. So the question is why? Why are we denying the parties engaged in domestic arbitration this facility under the bill, or this recourse under the bill? Now, similarly, sections 56 and 57 deals with recognition and enforcement of awards and the role of court in these matters. Again, the question is raised in the matter of domestic arbitration, where is the resort of the court? Where is the resort available to the parties of the arbitration, to the court, for recognition of and enforcement of awards? Because to me, this deals purely with international arbitration. And with regards to recourse for recognition and enforcement of awards, what are the clauses that giving our local parties the resort that is necessary to the court? Mr. President, I'd like to go to clause section 5E. Now, section 5 deals with the objects of the Act, the objectives of the Act, and section E states that adopt amongst the 5 objects that are listed in section 5. Section 5E states adopt the UNCITRAL model law. Now, in terms of the adaptation of the UNCITRAL model law, of course, there's no objection because the entire arbitration bill before us is based on this UNCITRAL model law. But my question is, why don't we qualify this statement here about the adoption of the UNCITRAL model law? And I'm proposing that following that statement there, adopt the UNCITRAL model law, we should add subject to the provisions of this Act. Now, the reason why I'm saying subject to the provisions of this Act, because the bill before us, there are significant additions to the UNCITRAL model law. And for instance, the umpire, the usage of an umpire. And if we are adopting a model law, I think it is always important that we distinguish that it's not just a blanket adoption, but it should be subject to the provisions of this Act. In addition, all laws are subject to revisions over a period of time. So I'm sure that the UNCITRAL model law is going to be revised on a regular basis. So the future revisions of a model law, if we are using that as a basic object in this legislation to state that we should adopt the UNCITRAL model law, taking into account possible future revisions to the model law, I think as a safeguard, we should add subject to the provisions of this Act. Mr. President, I'd like to go to sections 8 and 9 of the bill before us. And it provides for the intervention. It is stated here that these sections provide for the intervention of the court through sections 14, 16, 17, 21, 38, 44, 55, 60, 61, and 62. Now, Mr. President, what I'm trying to really wrap my head around is that, one of the clear objectives of going to arbitration is to really avoid having to go to court when a matter could be settled out of court, for many reasons. And one of them being it would help with declogging, the burden on the courts of Trinidad and Tobago. By many cases, that could be handled by arbitration. But we have the arbitral panel. We have also provisions for a possible umpire. And then we have the court. So in the whole process, we have these 3 entities. And by going through this bill within the short time that was afforded to us, I cannot but help but think, the synergy between these 3 respective entities and the possible areas of overlap and conflict about the respective rules. And whether by preventing the intervention of the court through the sections that are outlined there, whether or not it is a disservice to the parties that seek arbitration, that seek the route of arbitration. And in section 14, it deals with appointment of third arbitrator and the sole arbitrator, and the role of the court there. Now, in the process of the selection of the arbitrator, we are providing for the intervention of the court. And really and truly, I'm just wondering whether or not we can relook at these, all the clauses that are listed in 8 and 9 with regards to minimizing the intervention of the court or eliminating the intervention of the court in these matters. Because section 17 states that where there are no procedures for challenging an arbitrator, the court intervenes when procedures for resolving the challenge by the arbitral panel are not successful. I mean, why do we have this when we have provisions for an empire? Either in the arbitration panel or to replace the arbitral panel. Yet still we have the role for the court here, and whether we should not relieve the court of that burden. Then section 17, failure or impossibility to act on the part of any arbitrator. Again, you know, the comment comes back the same. I mean, is it a bit redundant here, particularly when the bill is introducing an umpire that is not in the UNCITRAL model law? And is it an overkill? I'm asking. Then the jurisdiction of the arbitral tribunal in section 21 is the court to rule on a plea by either party regarding the jurisdiction of the arbitral panel after the plea is considered by the panel. Again, a question of redundancy to some extent, in my opinion. Then section 38, consolidation of arbitrations, where the court solely decides to consolidate 2 or more arbitrations on application of any party to the arbitration proceedings. Now, what I note here is that the arbitral panel has no role in this section of the Act. And my question is why? You may have 2 or more arbitral proceedings going on, and you know, the arbitral panel, and maybe the Honorable Attorney General can clarify this if I'm getting it wrong. But there's no role for the arbitral panel in the process of, or the arbitral panels, I should say, in the process of bringing about a consolidation so you can have one arbitral hearing to consider this combined situation. So the lack of the role for the arbitral panel there. And section 44, where the court can be asked to provide assistance in the taking of evidence. Now, maybe the intent of this provision is good because the arbitral panel may not have the resources, or they may have to contract or outsource this service, particularly in terms of when you want to think, there will be a concern about confidentiality as well. But, you know, aren't we placing a burden on the court here? Because in terms of taking of evidence, the burden on the court, I mean, at present, under the tremendous workload of the court, I mean, legislating for the court to be asked to provide assistance in the taking of the evidence, I'm just questioning whether we really need to legislate that. or the arbitral panel could have the powers to seek, the taking of evidence by service providers, including the court if they so want to. So, Mr. President, with regards to Sections 8 and 9 and all of those respective clauses, I am suggesting that maybe upon further review, that the role of the court, if the objective is to minimize the burden on the court, that the role of the court, this extensive role of the court still in arbitration proceedings, could possibly be reviewed to minimize the input and the burden on the courts of Trinidad and Tobago. Mr. President, I go to clause section 12, and the question of clause section 12 deals with the court being able to issue an interim measure of protection and for a court to grant such measure. And my question is, here, maybe it's elsewhere, and Honorable Attorney General could advise, but this question of interim measure from the court, is there a forerunner to it, in that an arbitration panel has to be appointed, and deliberations by the arbitral panel have to start, and a party based on the proceedings of the arbitral panel can say, well, let me trigger this condition that is being allowed for in Section 12, so that the court can intervene regarding interim measures. Mr. President, Part 3, composition of the arbitral panel. Clause 14, Section 14, deals with the parties agreeing to a procedure for appointing an arbitral tribunal. And failing which, where an arbitral tribunal cannot be appointed. Clause Section 14.3 says that each party shall appoint one arbitrator, and the two arbitrators so appointed shall appoint a third arbitrator. Now, in an arbitration with a sole arbitrator, it goes on, if the parties are unable to agree on the arbitrator shall be appointed upon request of a party by the court. Now, what I think is missing here, Mr. President, is in a situation where we have a panel with 3 arbitrators. Now, it gives the power to the 2 arbitrators, one from the respective party, to appoint a third arbitrator. But, Mr. President, I'm not seeing any mention being made of who would be the chair of that arbitration panel. It is not mentioned specifically here. And I think it needs to be mentioned. Out of the panel, who would be the chair of that arbitration panel, or who would be the presiding arbitrator of that panel? Now, we may take it for granted and say, well, of course, it's the third arbitrator that has been appointed by the 2 arbitrators. But I am suggesting we cannot take it for granted that any panel comprising of 3 arbitrators or more, the legislation should have guidelines for the appointment of a presiding arbitrator or a chairman of the panel. And then I'm suggesting, seeing that the whole concept of an umpire has been introduced as a possible arbitrator, is rather than have a situation where we have a third arbitrator, and then we have to appoint an umpire in addition to a third arbitrator, why not have the third arbitrator function as an umpire? Why can't that be considered, where you have the third arbitrator also functioning as an umpire? Because the third arbitrator has not been appointed by the committee, by the parties, but they are being appointed by the two arbitrators that have been selected by the committee. Now, Mr. President, Senator Lachmidial did raise in her contribution she did mention about competence and qualifications of arbitrators. And this bill is silent on qualifications of arbitrators. And I am wondering why, because, I mean, quite a few pieces of legislation come to this Senate on appointment of board members, specialists and all of these things. And almost all of the legislation that has come before us would seek to legislate qualifications of arbitrators. Now we can say that it will be covered in the regulations that is catered for in Section 65. But we have to bear in mind that Section 65 of the regulations states that the Attorney General may, not shall, may issue regulations under this particular act. And I cannot help but remember when we looked at the Valuation of Land Act last week or the week before, where it also catered for the original act, also catered for the minister issuing regulations, but the minister may consider issuing regulations. And what we realized was, in decades had passed since the legislation was in effect, and no regulations were issued at all. None whatsoever. So this thing about that the Attorney General may issue regulations, particularly when the bill before us is deficient in speaking about the qualifications of arbitrators, I consider that to be a rather serious matter. Because, there are other arbitration manuals outside here that place heavy emphasis on qualifications and competence of arbitrators. And the Attorney General, the Honorable Attorney General, did mention about FIDIC, the International Federation of Consulting Engineers, being the benchmark, being the base contractual document for almost all our procurement contracts, particularly in which the state is involved, because we more or less use that as the model conditions of contract for procurement of goods and services. And, that document in particular, there are several, but throughout the various FIDIC conditions of contract for design build, for construction, for procurement of equipment, and all of those things, just some of the basic qualifications, and I would just like to probably mention a few of them to bring across, to strengthen what I'm saying, that really the qualifications should be legislated, or at least the key qualifications should be legislated. And one of them is that the arbitrator shall have no financial interest or otherwise in either of the parties, except in those circumstances, except for payment for services that would be done by the parties to the arbitration. And then also the arbitrator shall not previously have been employed as a consultant or an employee of either of the parties, except in those circumstances which have been disclosed in writing to the parties prior to the appointment of the arbitrator. Then the arbitrator shall have disclosed in writing to the parties prior to his appointment any professional or personal relationships with any director, officer, or employee of the parties, or any prior
President,
involvement in the project.
Sorry to interrupt, Learned Senator, but can I just have a reference to the section you're referring to, please? I'm not following.
Mr. President, this is from the FIDIC conditions of contract for design bill. I don't have the exact clause, and I'm not quoting verbatim from the particular document.
No, I apologize. Through you, Mr. President, I thought the Learned Senator was referring to the bill, so I was asking what section of the bill was being referred to. My apologies.
Okay. Since you might have a seat, AG, just repeat what you were saying.
I thought that the Learned Senator was referring to the bill, so I had interrupted to ask if he could tell me which section of the bill he was referring to. My apologies.
Okay. Thank you, AG. And I mean, I could go on and keep adding things, but I would just add that the arbitrator shall not enter into discussions or make any agreement with any of the parties regarding employment or regarding any other benefits after ceasing to be an arbitrator. So, Honorable AG, I just mentioned those because I'm making the point about qualification of arbitrators and whether as legislators we should leave it to regulations that may be done, or whether or not, the legislation should really consider inserting a clause that covers qualifications of arbitrators and maybe cross-reference it, because you did mention in your contribution about the Chartered Institute of Arbitrators and their presence here in Trinidad and Tobago and their membership being up to 80 or so. And I think it would consolidate what you were saying about, making Trinidad and Tobago a center for arbitration. If, this whole aspect of qualifications, the choosing of arbitrators, it's nailed down a bit more than what is in the Act before us. Mr. President, I'd like to go to Section 16, Section 4, that deals with challenges before the court. And what is stated at the end of Section 16.4 is that while such a request, and we are talking about a request for the court to decide the challenge, which decision shall not be subject to appeal, and while such request is pending, the arbitration tribunal, including the challenge arbitrator, may continue the arbitral proceedings and make an award. Now, I notice this is a standard feature of the bill before us, because in several instances in this bill, when a matter comes before the court by any party, that provisions in the bill before us allows for the arbitration panel to continue, allows for the arbitration panel to make an award, to make decisions, to issue interim measures, to issue preliminary orders, despite the challenge in the court. And I am questioning, because of non-familiarity with certain drafting of legislation, in this particular case, a matter comes before the court by any of the party, but we are still legislating that the arbitral panel should continue and should, even to the point of making an award. And in a case where an award is made and the court finds that the grounds for the challenge from either of the parties is valid and decides to uphold the challenge from the parties, in such a case, what is the recourse for the party? Because the arbitral panel would have already made an award, and whether or not that really complicates the issue. Now, I'd like to go to Section 19 that deals with the functions of the empire. And Again, my question, Honorable AG, is the selection of the umpire. Because Section 19 deals extensively with the functions of the umpire under this bill. But the selection of the umpire, again, the bill is silent on it. And is it in the intention that it be covered under the regulations? But really and truly, if we are bringing in an umpire with the powers that I'm seeing being provided for in the bill before us, if we are bringing in an umpire with the powers to even veto what has been done by the arbitral panel and make decisions and issue awards solely, whether or not the selection of that umpire, we should have legislation covering that, because it is indeed an exceedingly powerful role that is being given to the umpire. And I have to come back to the point I was making earlier, is why are we imposing this requirement on parties that are not willing to have an umpire? Now, I could understand in a case where the arbitration agreement, when there is one that is catered for in clause 21, in section 19, I could understand that because the parties have agreed to have an umpire in addition to a sole arbitrator or a panel of arbitrators. But when there is no agreement, when there is no provision for umpires in an arbitration agreement prior to any arbitration proceedings, why are we seeking to impose an umpire on the arbitration proceedings? This is like a third tier in the entire thing. And whether or not it really denies the parties, by their selection of their arbitrator, whether or not it infringes, on the rights of those parties to some extent. I would really like to hear from the Honorable Attorney General about the thinking behind the introduction of an umpire. And I think Senator Sipasad in her contribution also mentioned this, the whole question of an umpire. And whether or not, although there are genuine intentions, the introduction of an umpire would complicate the process of arbitration and not help in terms of all the objectives that we have heard about the benefits of arbitration. I come to section 2110, where it is stated that an application, this is concerning competence of arbitral tribunal to rule on jurisdictions. And again, what I'm seeing here is that the arbitral panel tribunal may continue the arbitration proceedings and make an award. So even if under the provisions of the bill, the competence of the arbitral tribunal to rule on jurisdiction is being challenged by either party in a court, here we are saying that the arbitral tribunal can continue on the proceedings and make an award. And again, I ask the question, the arbitral panel continues with the proceedings, they make an award, and then we come and find out that the court has ruled in favor of the party challenging the jurisdiction of the arbitration panel. Now, I also ask it in the context of costs for the parties, because if the costs for parties are being shared, or if the conditions are such if the award goes against either party, they have to stand all of the arbitration costs. We have a situation where a party, an arbitration party, has gone to the court to challenge the jurisdiction, and we are saying it's okay for the arbitration panel to continue incurring costs and continue even to the point of an award. And in the similar vein in which I mentioned earlier about another aspect of challenges in court, why are we giving the arbitral tribunal this privilege to continue with proceedings and make an award when the matter has been raised in court? Now, I can understand that it could be to address mischief, possible mischief. I could understand that, because if somebody wants to put a spoke in the wheel of the arbitration proceedings, they go to the court, they make their plea under the respective sections of this bill, and that can tie up the whole arbitration process for a very long period of time. So, but if there is more to it, I would certainly like to hear from the Honorable Attorney General if there is more to it than just a question of dealing with mischief that is deliberately aimed at delaying the process, but at the same time there are consequences of cost for the respective parties. And Mr.
Senator,
President,
you have 5 more minutes.
Yeah, I am wrapping up. The Honorable Attorney General did make mention of FIDIC. And one of the features of the FIDIC conditions of contract that is utilized, as I said, extensively, is that there are provisions for a dispute adjudication board. And maybe to some extent it is covered in the Mediation Act. But as a forerunner to the arbitration, I mean, whilst we highlight the benefits of arbitration, relieving the burden that is put on the court, allowing professionals and experts in the respective fields to contribute to a matter that is being adjudicated on, that need not have the full intervention of a court, the possibility of getting matters resolved in a quick, in a faster, within a faster time frame, whether or not as a forerunner, there should be some mention of alternative dispute resolution, and which is we are very familiar with it in the construction industry, in that there is a dispute adjudication board catered for in the FIDIC conditions of contract, in which a matter could be settled even before it goes to arbitration. So it's something to think about. And in closing, Mr. President, I come back to Section 65 and the whole question of regulations. I think putting that the Attorney General may issue regulations, I think there's enough in this bill that still has to be worked out, still has to be defined, particularly in terms of qualifications, selections of arbitrators, the umpire, and all of these things. And I would agree. I mean, I would support that this particular section be amended to say that the Attorney General shall issue regulations subject to the affirmative resolution of this Parliament. Now, I've noticed that previous legislations, that particular aspect is being left out. But I'm of the view that it does not always have to be there. But then when we are dealing with legislation in which there are certain gray areas, particularly in some of the areas that I've outlined, that in such cases, regulations should be considered in a way that it has to be placed before the Parliament. Mr. President, I thank you.
Honourable Senators, before I call on the next speaker, at this point, I would just like to remind Senators that should there be any proposed amendments to this bill that is before us, to do circulate it before we begin committee stage. Minister of Tourism.
Thank you very much, Mr. President. Mr. President, it is not unusual or ironic that the UNC, the opposition would have a dispute with a bill to improve dispute resolution in this country. Mr. President, Senator Mark has beat a hasty retreat from the chamber, but his contribution can only be described as disingenuous and dangerous. Mr. President, and the opposition always speaks from two sides of their mouths. We heard from Senator Luchmedial, and one of Senator Luchmedial's major points was the lack of consultation. Consultation. Where is the consultation? The consultation is here. I'll get to that. But where is the consultation? What we have before us is a bill and a policy done by some private stakeholders and put to the government for the improvement and the modernization of arbitration in Trinidad and Tobago. But that does not stop Senator Mark, Mr. President, from trying to scandalize under the cover of parliamentary privilege persons within this chamber and persons outside of this chamber. And here's how he has done it. This Dialogue Solutions Limited. The Attorney General may have been a part of a company called Dialogue Solutions Limited. I don't know. But all attorneys in this chamber and outside of this chamber may have been involved in arbitration at some point in time. Similarly, we may be involved in contract drafting at some point in time. Anybody inside of here can be or hold the position of an arbitrator. And let me tell you why attorneys at law will form themselves into a company. Because arbitration is a commercial, a dispute resolution process in the area of industry and commerce. You form yourself into a company because, as we see from the bill, companies pay for this arbitration process. They pay the arbitrators. You charge VAT, you issue a bill to companies, and that is how it works. So an individual as an attorney at law would be very smart, would be very intelligent to form themselves into a company to be able to deliver and provide this service in commercial transactions for commercial dispute resolution. But what Senator Mark did very, very dangerously is to conflate Dialogue Solutions Limited with Dispute Resolution Center. And the Dispute Resolution Center, Mr. President, they are the ones who had provided the arbitration policy for Trinidad and Tobago, which I hold in my hand. Dispute resolution, and they delivered this, Mr. President, on the 9th day of November 2018, draft policy for the improvement of the arbitration process in Trinidad and Tobago. And Senator Mark has a knack for attacking persons who are his intellectual superiors in this place under the cover of parliamentary privilege. But Mr. President, let me tell you who are the persons, the stakeholders who are involved in this DRC Arbitration Committee. Dennis Gurley of Senior Counsel, Stephanie Daly of Senior Counsel, Humphrey Stallmeyer, Retired Justice of Appeal, Salma Rahman, Attorney at Law, Independent Senator Anthony Vera, Attorney at Law and ADR Practitioner, Robert Sideno, Attorney at Law and ADR Practitioner, Elizabeth Solomon, Executive Director of DRC, Varuna Chatu, Ministry of the Attorney General and Legal Affairs. So it was not just the independent, private stakeholders, also persons from the Ministry of the Attorney General and Legal Affairs. Veronica Sahadeo, Office of the Chief Parliamentary Counsel, Shireen Khan Haider Ali, Law Reform Commission. These are the persons who put forward a draft policy to the government of Trinidad and Tobago for the improvement of arbitration proceedings here in this country via the Arbitration Bill 2023. And in doing so, they adopted draft model legislation by the United Nations, commonly referred to as UNCITRAL. That is what is done. But Senator Mark comes here and conflates these two institutions, the company and this DRC, Dispute Resolution Center, to scandalize the Attorney General. A shame. I know it is election season, you know, but there are some things that should be beneath us, infradig as you may, in this chamber. There are some things that should be beneath us. Senator Mark also made the argument that this government may try to funnel matters of arbitration to members of the ruling party. Not having read the bill, of course, Clause 14 says that both parties must agree to the appointment of arbitrators. Both parties must agree, because that is the nature of the law of contract. That is the nature of contract. Both parties set the terms of their engagement, set the terms and conditions of the contract. And of course now, they set the terms for dispute resolution. I'd respond as well to Senator Dirup Timal, because I think Senator Timal is missing the point that, yes, there may be very large contractual matters where you need a qualified attorney at law in the form of senior counsel or other experts. But then there are small matters, a roofing contract, a box drain contract, where in those small contracts, you would put a term of the contract where both parties agree to submit their disputes to an arbitrator. And therefore, anybody can be an arbitrator. Senator Timal, as an experienced civil engineer, they may decide that he be an arbitrator and agree terms for the arbitration of these matters. Anybody inside of here can be an arbitrator. It's the purpose of the bill. It's not just for very large commercial contracts. Of course, there is a real benefit to that. But it's for any type of contracts, small contracts even. Senator Lochmedial tried to, of course, ravi down the debate because we are in election mode. But as much as Senator Lochmedial tries to ravi down the debate and claim that Mr. Ravi brought the elections upon us, when the results are counted, after the bell tolls, Ravi may have brought the end and the death knell to the member for Sapari and the leader of the UNC. Because the elections were brought, and the UNC caught flat-footed. They are not ready for any elections. And that's why we're having defection after defection from the UNC to the PNL. Senator Lochmedial made a point, and I want to agree wholeheartedly with Senator Lochmedial. Senator Lochmedial made the point that with respect to the confidentiality of arbitral proceedings, there is an argument for those proceedings to remain confidential. But in matters of the public interest, that clause should not ouster other sections in other acts that work in favor of the public interest. And Senator Lashmedial gave an example of the World GTL plant. Yeah. But I agree with her. I agree with Senator Lashmedial. Because had we had contracts where arbitration clauses were listed in those contracts and the concomitant confidentiality clauses that go along with that, we would have never heard, Mr. President, of the matter of a conspiracy between a number of companies, Housing Minister, as he then was, Dr. Rudal Munilal, former EMBD CEO Gary Parmesar, former Divisional Manager Madhu Balrup, and Engineer Andrew Walker, a conspiracy to corruptly obtain contracts. We would not have heard of that. We would not have heard of, just before a general election in 2015, the minister, as he then was, and he still is the member for Oropuch East, conspiring just before the election of 2015 to give out inflated contracts to the disadvantage of we, the taxpayer in Trinidad and Tobago. What may have happened is a dispute for payment may have gone to an arbitration proceeding, and those proceedings sealed. So I am happy for that. I am also happy that no confidentiality clause prevented the public from knowing about the Piarco scandal, where $662 million in cost overruns were corruptly obtained. And I thank Senator John for being a part of busting the mark and opening the thing up. Because had there been confidentiality in the public interest, we would not have known that a $500 door ended up costing the taxpayers $80,000. We would not have known that. So I agree with Senator Lashmedial that these matters should not work to ouster provisions in the public interest. Senator Lashmedial called for consultation. Now, Mr. President, when the UNC oftentimes have nothing to say, they go to consultation, the argument for consultation. Where is the consultation? Where is the consultation? Senator Joint Select Committee. Mr. President, consultation, if they didn't hear it from the Attorney General, I will repeat it and put it on the record. Consultations, the Arbitration Bill 2023, were held with stakeholders in August of 2021, and comments were received from, and here are the stakeholders, the Trinidad and Tobago chapter of Chartered Institute of Arbitrators, the Association of Trinidad and Tobago Insurance Companies, the Ministry of Trade and Industry, the Judiciary of the Republic of Trinidad and Tobago, Trinidad and Tobago Chamber of Industry and Commerce, the Bankers Association of Trinidad and Tobago, the Director of Public Prosecutions, the FIU, the Law Association of Trinidad and Tobago, the Registrar General's Department, the Trinidad and Tobago Contractors Association, and the Trinidad and Tobago Police Service.
They want more than that?
They want more consultation than that. What more consultation you want from that? It's consultations. Consultations, you send the bill, you ask for comments. That is a standard practice in the development of policy. And the consultation was done. But when you have nothing to say, you come to this parliament and you ask for consultation. Senator Joint Select Committee. This is model law. Model law from the United Nations model law further developed into the CARICOM impact justice model that we are now adopting. And to go back to the point of the Attorney General, acting as though the Attorney General has done something sinister, the Attorney General was doing arbitration in accordance with the 1939 Act. There was a present Arbitration Act in place and practicing in arbitration as attorneys at law do. But Senator Mark would stop at nothing to scandalize people in this place. Mr. Vice President, this bill, as I state, is model legislation. In other words, it is a standardized legislative framework that have been adopted by a number of states, a number of countries worldwide. And it's important. It's important for the United Nations to develop this standard framework of legislation because of the globalized nature of trade and commerce. And it is necessary to have a universal system governing the law, practice, and procedure of arbitration. So, of course, it is said before, arbitration is a form of alternative dispute resolution. Alternative dispute resolution. Of course, we know the courts of law is the dominant method for resolving disputes that emerge in society between individuals, corporations, and even states. And it is for this reason, Mr. Vice President, that we have attorneys at law. Anytime, of course, as attorneys at law, we all hear some joke or some derogatory remark about attorneys at law. And my rebuttal is always swift. If persons, corporations, states, but it's all natural people, if persons were able to resolve their own disputes and conflicts, there really would be no need for attorneys at law. But of course, human nature, conflicts arise, there are disputes, and we need the courts and we need the attorneys at law for that. Whether it be divorce, there are conflicts where divorce, family matters, negligence, and of course trade and commercial matters. But this is not new to us in this society. We have known alternative dispute resolution methods, albeit informal methods. We have had the panchayat system of dispute and conflict resolution in this country for a long time. And we also have families, large families, who have informal methods and mechanisms for resolving disputes. But of course, in a society, in modern society, that is very competitive, individualistic, and of course, litigious, in a society where the average standard for pupil knows what a pre-action protocol letter is and what it does, the court systems have, of course, become flooded with litigation. So, alternative dispute resolution mechanisms have become increasingly more important because to reduce the number of cases that occupy the court, and as other senators have said, to save judicial time that these matters take to go through the court process. And there are other advantages that I can come to, which is privacy, there is speed, there's cost, and of course, convenience, and these disputes are resolved in a cooperative environment. There are other dispute resolution matters in other areas of law. And if I should not disturb Senator Mark, so I would identify myself as being a part of some of these other dispute resolution methods. In terms of mediation, in family law, you have an alternative dispute resolution method called mediation, where these matters can be very contentious, very emotionally charged, and the courts have adopted this mechanism to refer parties to mediation so that parties can seek to settle their disputes in a calm environment and understand an assessment of their cases. Because in family law, we know that the child is paramount, and it is in the public interest to ensure that the family matters are proceeded with in a very amicable way. In the Ministry of Labour as well, there are provisions and procedures for conciliation to aggrieved parties as a first step before advancing to the industrial court. You go to the Ministry of Labour, you sit with a conciliator, and you go through the matters before it becomes even more contentious, and the merits of each side of the case are discussed, and persons are often allowed to settle outside of the court matter. Mr. Vice President, of course, in the law of contract, we have arbitration, and the law of contract is distinguished from other areas of law. The law of contract, uniquely, you have both parties setting the terms and conditions of their engagement. Both parties set the terms and conditions of their engagement, and those are the obligations that both parties must discharge. And of course, now, what we have more into the contract law is the insertion of these clauses that deal with the agreement by both parties on how to settle disputes, might those disputes arise. And contract and trade is the lifeblood of any economy. And therefore, it really is in the public interest that trade is efficient, certain, and predictable. And therefore, the quick settlement of disputes in a cooperative environment is extremely important. So, why do we need to update this law? As was stated by other persons in here, it's a 1939 law that we are dealing with. Since 1939, there have been innumerable advances in technology, in the course of dealing, in the course that people do business. And therefore, there is the need to update the law. There's also been globalization, technological evolution, cross-border trade. So it is absolutely necessary that we update this law because of the inadequacies in the prevailing legislation. For example, one of the inadequacies, it leaves too much opportunity for intervention and challenge by the courts, including appeals from the decision of the arbitrators. It also does not contain any provision for the short-form expedited hearing and determination, which is addressed in Clause 41 of the bill, which provides that arbitral tribunals can decide to hold either oral hearings or conduct proceedings simply on the basis of documents and other materials. In terms of implementing a modern approach, we adopt this unilateral model law, and in Clause 5, to respond to Senator Timal, Clause 5 names the unilateral model of law in its objects clause. The modernization of arbitration proceedings in this bill You also have the allowance for virtual hearings in Clause 35. The place of arbitration to be determined by the parties or the arbitral tribunal, again, Clause 35. And Mr. Vice President, those are some of the inadequacies and the reasons for implementing this modern piece of legislation. Of course, where cost is concerned, arbitration versus litigation, arbitration is the clear winner, as litigation, the cost of litigation far outweighs the cost of arbitration, especially in this modern unilateral bill. Speed. This bill will bring a speedy resolution to disputes where the rules contained within the legislation allow for that speed. Again, convenience and cooperation. The process is much simpler and much more convenient for the parties involved. The hearing is held in private, so there is no wrangling of court calendars and court dates, etc. Jurisdiction doesn't apply, and the very rigid rules of court process also do not apply. And of course, we spoke about privacy. It's private, trade secrets can be protected, and privacy is generally beneficial to parties to a contract so that it doesn't get out and parties are not ridiculed and develop bad reputations, etc. So, Mr. Vice President, there is not much more to say. This is model law developed by the United Nations. This is law that improves the way we resolve trade disputes in Trinidad and Tobago. There are opportunities for us to develop ourselves, and Mr. Vice President, I would recall also the move into the waterfront, Tower D. So there are ample space. There is ample space, rather, for these types of arbitral proceedings to proceed. There is space for us to designate it as an arbitration center in the Southern Caribbean, or in the Caribbean, the dominant one. So I would commend this bill to the Senate. I support it. I support the swift resolution to disputes and the improvement to our ease of doing business. With those few words, Mr. Vice President, I thank you.
Senator Gillian John.
Okay. Thank you very much, Mr. Vice President, for the opportunity to contribute to this bill, the Arbitration Bill 2023. Where in the preamble, Mr. Vice President, it states that the bill is to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving dispute. And all the speakers prior to me would have set that out as one of the positive coming out of this bill, should it be implemented in the interest of Trinidad and Tobago. But, Mr. Vice President, Clause 5 of the bill identifies the objective of the proposed act as A, to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a method of resolving dispute. B, facilitate and obtain fair and speedy resolution of disputes by arbitration without unnecessary delay or expense. C, facilitate the use of arbitration arguments in domestic and international matters. And D, to facilitate the recognition and enforcement of arbitral award. And the last speaker, the Minister of Tourism, and I think the Attorney General, in introducing the Minister of Trade, Senator Jayanti, would have spoken about the ease of doing business. And basically, you know, it is noteworthy, Mr. Vice President, and relevant to this bill, that the last time they would have done our ranking on this ease of doing business, the World Bank ranking, we were placed at 105 out of 190 countries who participate in the surveys. And there are 41 indicators. And we are, in terms of dealing with construction permits, we are ranked at 126th. And that is one of the key areas where there will be the need and requirement for the intervention of this policy of arbitration, or this, whatever is laid out in this law as the methodology with respect to arbitration. So if we are to yield the benefits that have been put forward here, certainly in terms of all of these indicators coming out of the ease of doing business, whether it's dealing with construction permits, which is ranked 126, Trinidad and Tobago, starting a business, we are ranked 79, getting electricity, 43, registering property, 150, getting credit, the lifeblood of business, 67, trading across borders, because we are talking about arbitration as a facilitatory tool for resolving dispute. So trading across borders, we are ranked 134. And therefore, this is where sometimes we have to start. We have to start at the fundamentals. It is good to come and have this facilitatory law. It's about what are we going to use it, how are we going to apply it, if indeed our ease of doing business really not so easy. So among other things, Mr. Vice President, we are asked to adopt the unicitral model, which was adopted by the United Nations Commission on Internal Trade Law. And of course, it came into effect in 1985 and amended further on the 7th of July, 2006, at the Commission's 39th session. And just as the Minister of Trade was saying, it's really to apply this model law to our environment. And how do we make it? The idea now is how to make this fit for purpose in this local jurisdiction. You know, are we just going to say one size fits all? You know, certainly it has been used in Jamaica. They have now adopted that law in Jamaica in 2017. And really, as the key features of this model, it includes access, recognition, relief, and cooperation. I think the Attorney General would have indicated that there would have been some kind of consultation with Jamaica, which is probably helpful, given that we are all Caribbean states. Mr. Vice President, in clause 10 of the bill, it speaks of the definition and form of an arbitration agreement. And the arbitration agreements can be in the form of a clause in the contract, which is very commonly seen in commercial contracts or as a separate agreement. And one has to say, it's not only the large companies that are bounded by contracts, but also our small and medium-sized companies. And we have to look at their readiness to accept arbitration, because, you know, sometimes it's very hard to wean ourselves away from what we know. So people have a dispute, they go to the court, the civil courts. And now you're asking them to go to arbitration, and there are rules of engagement, certainly, including what you call it, I think it's in clause 60, confidentiality. And we know in Trinidad everything leaks out. Nothing is sacrosanct, and people don't hold themselves sometimes to a very high standard. Everybody knows everything. And I believe this is where folks would have kind of put a flag with respect to arbitral proceedings shall be private and confidential. So we have to look at who are we applying, are we trying to induce or recommend this system of settling dispute to. And as I said, it's not only the large companies, it's not only international companies, it will also be our small and medium-sized companies. And I don't know to what extent this arbitration is a trusted feature of our resolving contractual disputes or resolving contractual obligation. So, Mr. Vice President, it must be in writing. Well, I mean, we have it in, I think, clause 10.2 and 10.4 allows for electronic communication to be considered as in writing. Does that mean a WhatsApp? You know, or will that be specified further in the when the Attorney General would have written up the other part of the law, the operationalizing the law? I don't know what is considered in writing. I don't think it was really defined in the bill, as it were. However, as the Honorable Attorney General, I'm talking about whether he will have it further described in the regulations later on. However, perhaps the Honorable Attorney General can explain the need for 10.5, which says that an arbitration agreement is also deemed to be in writing if it is contained in an exchange of statements of claim or defense pleadings in which the existence of an agreement is alleged by one party. Does that mean that this thing is going to be asymmetrical? Who will determine that this now, whatever it is, whatever is in the statement of claim, could then lend itself to be called an arbitration, an agreement? You know, I think these things are a little murky and not so clear, because if one can say, well, okay, I wrote something to you, and because of that, this now becomes, or we can convert this or leverage it as some element of what an arbitration agreement. So respectfully, Mr. Vice President, this standard, I think it is too weak. Pleadings, because pleadings can range from a small bundle to a large bundle with hundreds of pages, because it depends on if it's a large firm with a robust legal department, or they have money to pay for legal support competence. Then, because people engage, when you are engaged in a contract, especially large complex contracts, you are contracted with people for maybe hundreds of millions of dollars, and then people for maybe just millions of dollars and lower down, depending on what the service is. So, you know, we have to look at that to ensure that our contractors, wherever micro, medium, small, large, they are not disadvantaged if this method of settling dispute really catches on. And as we said, we have no fundamental issue with the idea of updating our arbitration infrastructure. But certainly we want to ensure that everybody really, there's no one who is left behind or disadvantaged. So some clarity will be welcomed here. Under Part 3, Clause 13 of the bill, composition of arbitral tribunal, parties are free to determine the number of arbitrators, but where there is no such determination, the number selected shall be free. Well, all right. I suppose that now is the law if this bill is passed. And Clause 14 allows for persons of any nationality to act as an arbitrator, which is helpful in doing business internationally, because I suppose one can, based on where, if it's an international company, one can perhaps choose an arbitrator from the country where one of the contractee has originates. And as I said, where there is Clause 14 allows for persons of any nationality to act as an arbitrator, which is helpful in doing business internationally, and where international arbitrators may be utilized. By doing this, one must ask or consider the international requirements by jurisdiction to act as an arbitrator. Must be looked at perhaps including that person or those persons who have been deemed to be insolvent, charged or convicted previously on financial or white-collar crime or corruption. And, you know, are these people supposed to be barred as arbitrators? Are we going to put some kind of definition in terms of who are the folks who can engage in this exercise and who will be deemed to be persona non grata? Now, Mr. Vice President, Clause 15 deals with grounds for challenge where an arbitrator's independence or impartiality comes into question. And again, this does not deal with other issues such as whether they are insolvent, etc. Mr. Vice President, bar from appeal, I note that with regard to appointment of arbitrators, the court's initial intervention will be deemed as final. In a sense, I can see that persons with means could possibly appeal for years upon years to hold off an arbitration award and delay an inevitable outcome. And I think this was addressed in some manner by the Attorney General, but it will be helpful if, again, we can hear about that, because, however, with respect to Clause 16.4, where the independence and impartiality of an arbitrator is challenged, I believe that the right of appeal should exist, as this can have a significant impact on the outcome. In any case, appeals are not automatic and must qualify before being heard. Mr. Vice President, under Part 4.9, where the arbitral tribunal rules on a plea as a preliminary question that it has jurisdiction, any party may, within 30 days after having received notice of that ruling, request the court to decide the matter, and the decision of the court shall not be subject to appeal. Once again, the right to appeal is removed here, where some further consideration ought to be given. Can the Attorney General elaborate on the need to remove the right to appeal to more of the substantial aspect of the bill? Mr. Vice President, there is, this bill impacts on a few pieces of existing legislation. For example, the challenge proceedings contained in the Public Procurement and Disposal of Public Property Act at Section 63. There are existing arbitral rules, as in construction contracts, standard adjudication proceedings that are more transparent in its approach than the law presenting before us. If you take the standard construction contract use as a matter of policy, in all public sector construction projects, FIDIC is the form of contract use. And you examine the current approach to challenger determination, it is clearly stated in these FIDIC documents. For example, the joint selection of a competent adjudicator by contracting parties who invest in law and construction. That's the rule. The timelines for submission of documents and decision-making and the process for review is also very specific. And the process can be mapped out, and each step has a specific duration. Perhaps these elements of the law will be, again, we will hear more about it from the Attorney General. So these challenge proceedings in the Public Procurement and Disposal of Public Property Act, they overlap and can actually weaken the existing framework on construction contracts during the implementation period, as it takes precedent over the FIDIC conditions. And one has to look at that, because it is a policy that the public sector uses the FIDIC form of contract, and this form of contract is a French language. The FIDIC is a French language acronym. I wouldn't say it in my poor French, but in English it is the International Federation of Consulting Engineers, which was started in 1930 by the trio of France, Belgium, Switzerland, and now England. The UK is part of that. So, Mr. Vice President, that is the form of contract that we use. So I'm asking, is it that there will be written into new contracts that, notwithstanding the existence of the FIDIC well-read book at clause 20, where it says arbitration shall be conducted in a manner set out in and in accordance with the Arbitration Act of Trinidad. Is it that they're going to use that now to say, well, instead of this, what is laid out in the FIDIC Red Book at clause 20, that they will have a clause that says that arbitration shall be conducted in a manner set out in and in accordance with the Arbitration Act of Trinidad and Tobago? Because if this is so, has there been the Attorney General will have spoken about consultation, and some of the other speakers before would also have flagged that. But I'm sure I did not hear him, maybe I'm wrong, talk about consulting with the Joint Consultative Council. I mean, there are some of the organizations that falls under them, like the Association of Professional Engineers. I think I heard that of Trinidad and Tobago. Trinidad and Tobago Contractors Association, Trinidad and Tobago Institute of Architects, Trinidad and Tobago Society of Planners. Because the JCC has entered into a tripartite agreement with the FIDIC Confederation and one of its providers called the European Construction Ventures Limited. And they provide training in the Caribbean on all FIDIC forms of contract. I'm saying this in relation to the arbitration clause within the FIDIC contract. And so far, based on the website of the JCC, they have trained over 1,800 people, persons. So I'm sure there must be consultation with the JCC in the implementation of this updated arbitration law. Mr. Vice President, if I am to kind of read into the record within the Senate, an essay, well, not the whole essay, of course, by Mr. Peter O'Malley, an essay dated November 2020. And he wrote, the heading is A New Uncitrol Model Law on International Commercial Adjudication. How beneficial could it be? And he said, for those jurisdictions that have yet to implement adjudication, a new unicitral model law on international adjudication, adopted either in part or in whole, this will assist in providing a template for national legislation. I said, not unlike what we are doing here. He said it is likely that any new model law on international commercial adjudication, which makes no distinction between foreign or domestic procedures, the model law on arbitration states that recognition and enforcement on international awards, whether foreign or domestic, shall be governed by the same provisions, thus being beneficial in both consistency and clarity. So, Mr. Vice President, there's a lot of commentary on enforceability, because even if we make a determination in a local court and we have a contractor, which they come with a company registered in the USA, the UK, China, wherever. The point is we have to look at where whether we can, there's the enforceability of the adjudication decision. You know, are we going to, is it going to be easy to enforce this decision in different jurisdictions? And FIDIC, this would have come to FIDIC, and they have, in response, they have issued a guidance memorandum, and that was done in April of 2013, with an amended clause to the clause 20, called clause 20.7, that expressly provides for not final dispute adjudication board decisions to be enforced through arbitration, being consistent with temporary binding decision of adjudication. So, Mr. Vice President, I must indicate that arbitration is now, as we have said, we've all agreed in this Senate, that is a method or methodology, a dispute resolution methodology that has become, sometimes it is something to consider certainly, but it has become more distant from those parties with small or modest claim. And I think that point was also made in the chamber earlier. For many users of international commercial arbitration, the preference is to utilize arbitration in conjunction with another dispute method. This approach is promoted in the FIDIC suite, and they have a kind of step-down dispute resolution, where in the clauses where the objective is to secure resolution without the necessity of arbitration. Because I suppose using this method of arbitration as a tool that is widely used and sought after, this is something that one will have to kind of wean folks who are not used to it, one with true education and communication, to ensure that when this bill is passed, it is really used and one can get the benefit that is being proposed here in terms of cost savings and time savings, because in some of the readings, you are not seeing that there is any savings in cost or time, as it were. So, Mr. Vice President, I think another thing I was asking, whether the adjudicators or whether the functions and the process is governed by this adjudication bill will fall under the procurement administrator. I think that's another question that we will want answered. And so we have no fundamental disagreement, but we are a little bit wary that the practice of this adjudication, putting it forward within our community, will require some more work, some more consultation with the parties who will be mainly impacted upon, and certainly a little more engagement. And that is not to frustrate anything. It is to ensure that when we pass laws, it is good and useful laws and not laws just to benefit a few. Because, you know, I recall, Mr. Vice President, before we come to this Parliament, the opposition senators, we usually have a caucus, just go through what is before us and who will speak on what. And each time, unfortunately, people will be looking at it with suspicion, wondering who will benefit. Is this piece of legislation ad hominem? Always, and listening to Senator Mark today, it was really a remarkable contribution. Mr. Vice President, I want to thank you for the opportunity.
Senator Hazel Thompson, aye.
Thank you, Mr. Vice President, for the opportunity to speak on the Arbitration Bill 2023. Mr. Vice President, this bill transported me back to the 1980s. I was feeling as though I were in a maelstrom or in the eye wall of a hurricane, wishing instead to be in the eye of the hurricane, where it was calmer and I would feel safe. Having lived through hurricanes in the Bahamas, I know of what I speak. So here I am in the 1980s, representing a corporate client, a finance company, that had caused many to come to grief. As the face of the company, its lawyer in the courts, I became the target for all the hate generated by the losses suffered by investors. I received death threats. Colleagues at the bar, whose clients and even family members had lost money they had invested, had choice words for me. One senior lawyer, not an SC, but from a big law firm that produced two of the newly minted senior counsel, sought to chastise me after I had successfully resisted his garnishee order, saying that that hardware he was represented was supposed to build his house for him. I had put that in jeopardy. Another lawyer friend told me angrily as we were leaving court, after I had a winding up petition dismissed, the judge was overly helpful to you. I was experiencing the worst of litigation and longed to be away from the court. Did it have to be like that? I asked myself. I was exhausted by all the fighting. It did not help that I also had a number of domestic violence injunctions. One of my clients had been murdered by her husband. There was yet no domestic violence standalone laws. I just wanted to leave. As an answer to a prayer, they landed on my desk an arbitration matter. What a difference alternative to litigation makes. It was like a breath of fresh air. The sheer volume of written material was intimidating, but after the initial shock seemed manageable. I was able to wade through the pile of documents, meet with counsel before the date for hearing of the appointment. First, both parties went to court, agreed on the arbitrator and other administrative matters, and to abide by the decision of the arbitrator. The subject matter of the contract was one that was near to my heart. It was for the construction of the Hugh Wooding Law School. Our clients were NIPDEC, and the other side was a construction company. I will not name it. Nels Christie, foremost criminologist, wrote in the British Journal of Criminology in January 1977 of conflicts as property. He taught that conflicts belong to the parties involved. Who gave them to the state? Arbitration is a means by which parties retain control of that conflict. It has been described as a centuries-old method of alternative dispute resolution, predating colonization. Like other time-worn dispute mechanisms, like mediation and restorative justice, which are two things that are very close to my heart, arbitration is becoming increasingly popular as the way forward to resolving dispute without the court's intervention and in the process unclogging the overburdened court. And incidentally, it is not only the criminal justice system that is clogged, it's also the civil justice system, where, save some high-profile matters, litigants are in limbo, waiting for matters to be heard, waiting for judgments to be delivered, and when judgments are delivered, waiting for over 2 years, in one case, for a 3-line order to be written up. Civil lawyers and their clients are suffering, mainly in silence. But we need to raise our voices to the rooftops instead of grumbling among each other. What is happening with estates that are on desk waiting for reviews for years? Very senior lawyer has told me that there is need to incentivize certain things. It's a sad indictment on our justice system. This Arbitration Act is another response to Nappy Mayor's cry to bring back the old-time days, bring back them old-time ways. And it has been said that the first arbitration was done by Solomon when the 2 mothers were claiming that the baby was theirs. The arbitration that I spoke of was concluded in short order. I do not recall attending more than 2 or 3 sessions. Unlike in the court system, where forum shopping is well-nigh impossible, we were able to choose an arbitrator to advocate on the dispute based on that person's expertise and general suitability. We were able to set the agenda for the meetings, to freely decide on the venue and discovery of documents. At the end of the day, the matter was adjudicated on the basis of the construction of and fulfillment of the terms of the contract. Considerable costs were saved because of the speed with which the matter was first determined, and the reason for the decision was clear to all. So I have had first-hand view of the benefits of the arbitration process. Not only the speed with which the matter was determined, less time meant lower costs. It was not subject to complex civil proceedings rules. Privacy of proceedings was welcome and provided a more relaxed atmosphere. It was a decided advantage to have the matter adjudicated by a subject matter expert chosen by us and in whose ability we had full confidence. So today, we debate the Arbitration Bill. I cannot say, as in the recent past, that this is a short bill. It's very comprehensive. A great deal of work has gone into its formulation. Legal drafting is one area of work where you are allowed to copy with impunity. In his last message to me, the late Peter Telfer shared with me he used to get licks in school for copying. It was because he could not see the board and had to look in the book of the boy next to him. His vision impairment was recognized very late. Legal draftsmen's valid excuse is that they want the best law and there is no need to reinvent the wheel. The bill's stated objective is clearly spelled out in the long title: an act to repeal and replace the Arbitration Act, Chapter 501, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters. Clause 1 contains a short title, the Arbitration Act 2023. Clause 2 is the interpretation section. Mr. Vice President, this section illustrates my point of our draftsperson improving the law. When you examine the definition of arbitration in the interpretation section of the United Nations Commission on International Trade Model Law on International Commercial Arbitration, which is Article 2, and in the Impact Justice Model Arbitration Bill 2022, which is Section 3, you will observe that they are in identical terms. They both state arbitration means any arbitration, whether or not administered by a permanent arbitral institution. That is circumlocution of the highest order. Are you any wiser having read that definition? I think not. Compare that definition to the one in our draft bill, which reads, arbitration means a process of settling a dispute between parties before an arbitral tribunal, whether or not that process is administered by a permanent arbitral institution. So we do have the ability to make things better than the regional and the international institutions. A fine example of that. Clause 3 states that the Act binds the state, and this implies the state is to abide by the terms of the Act, and Clause 4 talks about the applicability of the proposed Act. Clause 5 sets out its objects, which are very clear and relevant. We've heard of them before. Clause 6 deals with receipt of written and electronic communication, which brings us into the 21st century. And what is deemed to be actual and what is deemed receipt. Clause 7 speaks to a waiver of a party's right to object to the other party's derogation from the arbitration agreement if the first party fails to object in a timely manner. So you have to be on your toes. Clause 8 removes the arbitration from the purview of the court, save in circumstances specified in the Act. Clause 9 details the functions to be performed by the court. Clause 10 specifies the form of the arbitration agreement, which is fairly flexible. Again, it deals not only with written, but also electronic form. Clause 11 speaks to the court's referral of a matter for arbitration, which is the subject of an arbitration agreement, unless it finds the agreement null and void, inoperative, or incapable of being performed. Now, this clause shows that although there is freedom of contract, that does not mean that the court's jurisdiction is ousted when there is need to do justice between the parties. However, there is provision for the arbitration to begin and be concluded while a matter is pending before the court. Clause 12 provides for a party to request and the court to grant interim measures of protection. And I think some people would have missed the point that the parties approach the court and request the interim measure, so it's not imposed on them. Clauses 13 to 20 deal with the composition of the arbitration tribunal, which the parties can freely determine, and if they are not able to agree, the court can determine based on qualifications, impartiality, and independence. They detail grounds for challenge of the arbitrator and methods of doing so, the circumstances for removal of the arbitrator, the appointment of a substitute arbitrator, and the role of an umpire when the arbitrators fail to agree and an application is made to the court that an umpire replace the arbitrator. And if you look at clause 19, you see that the parties invite, so the umpire is not imposed on them. When you look at the provision, you see that. Clause 21 details the jurisdiction of the arbitral tribunal, and check that. You spell arbitral one place, and just below you have it spelled in the correct way. All right, so you have the R where it shouldn't be, and someplace you leave it out. I will pick up those things, much to your chagrin. 22 the interim measures and preliminary orders, and includes the conditions under which they can be granted. Clause 33 to 45 set out the principles, the practices, and procedure for the conduct of arbitral proceedings, and one can discern that these are governed by the need to give guidance while allowing the parties freedom of contract. So the phrase, you will see, unless otherwise agreed by the parties, and like phrases which appear frequently as a recurring decimal. Clauses 46 to 54 deal with the making of award and termination of proceedings and detail matters such as governing law, terms of award, form of award, payment of costs, interest, and termination. So I am afraid that sometimes where others may see obstacles and impositions, I see a willingness to assist. Clause 55 sets out circumstances for having the award set aside, such as incapacity of a party, invalidity due to law applied, the time period for doing so, the lack of proper notice outside the scope of arbitration agreement, in conflict with the law or public policy. And 56 and 57 relate to recognition and enforcement of awards, including the circumstances in which the award may be binding, which are largely reflective of the circumstances under which the award may be set aside by a party under Clause 55. When you look at 58 to 68, there are general provisions dealing with foreign representation, immunity of the arbitrator, privacy and confidentiality of proceedings, privacy of proceedings, restrictions on reporting, and the effect of proceeding on the death of the arbitrator and the death of the person appointing the arbitrator. Now, there was mention about disclosure in the legislation, which is 60 by a previous speaker who had some concerns. And in that regard, I would like to refer to the Arbitration Act 2009 of the Bahamas. I don't think it was in our pile of legislation. And it's Section 20 of the Bahamas Act says, the heading is Arbitral Tribunal may allow disclosure. This section applies if a question arises in any arbitral proceedings as to whether confidential information should be disclosed other than as authorized under Section 19A to D, and B, at least one of the parties agrees to refer that question to the arbitral tribunal concerned. The arbitral tribunal, after giving each of the parties an opportunity to be heard, may make or refuse to make an order allowing all or any of the parties to disclose confidential information. When you look at Section 21, it says when the Supreme Court may allow or prohibit disclosure. And it states the Supreme Court may make an order allowing a party to disclose any confidential information, A, on the application of that party, which application may be made only if the mandate of the arbitral tribunal has been terminated, or B, on appeal by that party after an order under Section 22 allowing that party to disclose the confidential information has been refused by an arbitral tribunal. 2, the Supreme Court may make an order under subsection 1 only if A, it is satisfied in the circumstances of the particular case that the public interest in preserving the confidentiality of arbitral proceedings is outweighed by other considerations that render it desirable in the public interest for the confidential information to be disclosed, and the disclosure is no more than what is reasonably required to serve the other consideration referred to in paragraph A. 3, the Supreme Court may make an order prohibiting a party, party A, from disclosing confidential information on appeal by another party, party B, who unsuccessfully oppose an application by party A for an order under Section 22 allowing party A to disclose confidential information. And 4, the Supreme Court may make an order under this section only if it has given each of the parties an opportunity to be heard. 5, the Supreme Court may make an order under this section unconditionally or subject to any condition it thinks fit. To avoid doubt, 6, the Supreme Court may, in imposing any conditions under subsection 5B, include a condition that the order ceases to have effect at a specified stage of the appeal proceedings, and decision of the Supreme Court under the section is final. So, Mr. Vice President, there's flexibility in going the route of arbitration. There is confidentiality. There is saving of time. There is saving of costs. And I began by talking about the stressful situation that I was in. It certainly saves lawyers stress when you can have a matter determined without too much delay. On my way here, I made a call to the Bahamas, and I spoke to Justice Nottage, who is a retired judge very much involved in arbitration. And she informed me that Bahamas just passed a law, they just amended their law to make the Bahamas an international commercial center. So a lot is happening in the Bahamas. They are very enthusiastic. She says, a lot of people are using the arbitration process so that we can see what is happening in the various jurisdictions as far as arbitration is concerned. In an article, The History of Arbitration, Practice and Law by Frank Emerson, he says that in one of the national presidential elections, the major parties signed a code of fair campaign practices and they agreed to arbitrate claims of violations. There was a news story indicating that the Fair Campaign Practices Code had been signed by both the chairman of the Democratic National Committee and by the Republican counterpart. And he ends, it therefore can be seen that arbitration is today, as it was in yesteryear, a dynamic institution for the peaceful settlement of discord, differences, and dispute. In this society today, there is much discord. There is many disputes. And there is a lot of distrust, a lot of differences. We can use arbitration to resolve a lot of the problems that keep us awake at night. We do not have to follow the laws slavishly. We can, in fact, look at what we have, look at what we can do, and make the best law possible. But, you know, we can't stop the clock. Alternative dispute resolution is not going to recede. It's going to continue to grow. We who practice also in the family and other courts, we know about the settlement of disputes. We know a number of things are happening in mediation. And we have to use these practices, we have to use these ways of dealing with disputes so that we can resolve our matters in fairness to all concerned, amicably, quickly, cheaply, and for the good of not just the parties, but the entire country. I thank you, Mr. Vice President.
Senator Dr. Varma Singh.
Thank you, Mr. Vice President, for the privilege to be taking part in this discussion. And as I start, I must say that the Attorney General mentioned it was a privilege to bring this bill to Parliament because he made mention it's so long that we were overdue to this. I mean, for this piece of legislation to be updated, that it was a privilege. And I also must say I feel an honor and a privilege to be part of this. It's long overdue. So in one hand, I have to say thank you, Mr. Attorney General, for bringing it. I mean, we have heard about since the 1937, we had the whole idea of arbitration come to force, and persons mentioned that this started in 1937, and we must remember it is not just the UN. It was before the UN, the League of Nations, I think in 1924, after the First World War. They actually got together and decided we had to do something in terms of arbitration, in terms of settling dispute. So therefore, it really caught on where we found in 1937, when the legislators looked at this, and then different countries started to come on board with this. And I think in 1939, we came on board with this also here. So therefore, definitely I heard they mention that the bill today serves to modernize, and it does serve to modernize, because how could we be thinking about a world with artificial intelligence, with new modalities in terms of getting contracts, computerized world. So therefore, definitely, it is a time that we needed to catch up, and here we are today to give our blessings to this. So I've heard also that there was the harmonization that is needed in terms of looking at other pieces of arbitration acts that are existing elsewhere. And the whole function of this is that persons, international traders, would be able to come into our country and have a greater sense of purpose, in the sense they would now be able to fit in to the global pieces of legislation. So therefore, The Minister of Trade was very, I think she showed her some excitement in the fact that this is being passed here. She mentioned the fact that there were 9 positive things that can come out of this. And again, definitely it will help the small business. It will help the small business to be able to solve their issues, to be able to manage their disputes in a better manner. And hopefully it will encourage businesses to come here and fulfill the dream, as I heard mention of our late Prime Minister Patrick Baden, who actually wanted the waterfront to be the hub of a business hub. But you see, even though this is a dream and this is something that we would hope that we could attract business, we need to attract business, we have to understand that why would persons come here? I mean, we heard that Jamaica has a well-functioning body now. We heard from the Senator Lodge-Medial that there's an attorney who had set up an online aspect where you can now have this arbitration occur totally. So the modernization, we have to keep up with this here. We have heard that Bahamas is also now going to be setting up as a hub. So we now will have competition. You know, even though we have this hope, we can come in here. The competition that exists out there, we will have to figure out, would people want to come here? Will they, stay with what exists there out there before? So the other point I want to make mention to is that we heard that Trinidad is the gateway of the Americas. So definitely, where we are positioned, we might be an advantage to hear disputes from Latin America, South America, to hear the disputes along the CARICOM region. And this may be something that we may take comfort in, that we are positioned in an area. But remember, 2 things will go against us. Yeah? If people have to come down here, crime is one, where people may be hesitant to come down here to do any sort of arbitration. And the second thing, too, besides the crime, the fact is, if we are looking at trying to go into the Latin American market, the Latin American market, they have been well established. They have been moving ahead, and they have been in the game where they are actually, they have adopted the New York style convention, and they actually have ratified. Some persons had 18 countries in Latin America have actually ratified in New York as signatories also to the Panama Convention. And the International Chamber of Commerce, the ICC, seems to be the most preferred site where they still go to. So therefore, we have to look at it in a realistic way. Would Latin America countries come here? I am not so convinced. I mean, there are other preferred sites: London, Singapore, Hong Kong, Paris, Geneva. Those were the most preferred sites where, when globally, persons would say they would rather go to those established sites. So we would have some competition. We'd have some reasons why we may want, why persons may want to come here. So that might be a little challenging for us, because you see, Latin America is really, as I say, developing as an ambitious hub now for this arbitration. And when you look at the fact that Latin America has been, and even Brazil is a country that, it's now in the economic front. It's deciding to do business. We are looking at the BRICS community coming together, and they may be doing business with other agencies. Therefore, you find that when they have their business problems, they may have to decide who they are going to. Will they come to Little Trinidad? Would they, unless we can get the arbitrators, international arbitrators down here to be part of our establishment, will they now have a language barrier? Because if you're doing business with Russia, China, etc., business places are opening up, and you find that you have that level of arbitration to be handled, you may think that other countries may benefit more from us. So therefore, I look at the fact that I think it's an ambitious venture mentioned to try to get us to be that international hub. But even so, even though we want it so, and we want our country to be up there, we are doing the right thing here by modernizing, by keeping it, making it up to date. We are doing the right thing here by, with this piece of legislation to at least help the local persons who would want it, the companies who would choose arbitration, as well as international companies. So we are putting things in place. We have been long overdue, and I'm saying Jamaica has beat us state, and at least we are now coming up to standard. But so when I look, we definitely, I think it was made mention that we may actually save foreign exchange if we could, we can get foreign exchange if we can get here as an international hub. But two things we may have to look against this. I mean, besides one, we may not be that attractive, but two, there's now the online arbitration that is set up, and we heard Jamaica had something going good, and we are hearing that there are different avenues, different countries also will be adopting this online method where it's more convenient. So you may not really get persons coming in to the country in terms of that influx of persons there. I must mention the New York Convention did give guidelines that worldwide these arbitrators and those councils look to some sort of guidelines. And then that was in 1958. And that was the Convention on the Recognition and the Enforcement of Foreign Arbitrators Abroad. And then in 1975, there was the Panama Convention, where the Inter-American Convention on International Commercial Arbitration came. So it's there. It has been part of our law even before that, in 1939, as we know. So just a matter of updating it. So two things that I looked at when I was preparing for this. I made mention to the fact that there's the advantages, and we heard the advantages, but I just want to look at certain disadvantages that may occur. And I heard from the Senator Lodge-Pedial and I also Senator Mark that, somehow you may have arbitration could be actually involved in some matters that may not be transparent. So it could act as a cloak to transparency. And we have to appreciate, Mr. Vice President, Trinidad and Tobago and worldwide, there's the businesses that occur, the construction industry, and all over, there's always that level of persons pointing fingers, the allegations of corruption. So therefore, we have to look at the fact that do we now create this sort of arbitration where contracts, you are not able to look at these contracts. We are not able to monitor them. Senator Sipasad did mention. So in a sense, it would be depriving individuals to be able to look at a contract to see if there's anything that occurred. And I'm not talking about private contracts. If it's private contracts, I'm saying that I see no objections with two companies wanting to go in and have their discussions in secret. But I take offense if it's a contract where you're using taxpayers' money. And it was made mention that sometimes the state enterprises we had, their business run-ins in the past, left a lot to be desired. So if now we have arbitration as a form, And Senator Mitchell did mention the fact that some things were exposed. So if arbitration as a form comes into being, we may be at a disadvantage to not have any clear and transparent sort of purview of what went on. And I would like, sir, with your permission, to look at an article where it's from Insights, May 11, 2016, Bribery and Corruption in International Arbitration. And I mentioned this is, here we are treading on good legislation. I have no problem with it. We are going in some legislation, we are modernizing legislation. But then we have to know there are warnings out there in the international scene where we have to know that whatever we are doing, we can put certain guidelines, certain safeguards in place. And I would just like to briefly read through this article. It's May 11, 2016. Corruption in international business is becoming endemic. Transparency International's latest global corruption reports highlights that nearly 2 in 5 business executives say they have been asked to pay a bribe when dealing with public institutions. 1 in 5 claim to have lost business because of bribes by a competitor. More than a third feel that corruption is getting worse. Corruption stifles free and fair competition and undermines democracy. Little surprise that it should be the subject of universal condemnation. So this article went on to say that there are concerns that parties to contracts procured through corruption may choose arbitration as the preferred form of dispute resolution, because the process is confidential and consensual, and because arbitrators are traditionally reluctant to investigate corruption on their own initiative. So this is where we have to be guided, how we are going to look at those bodies. And if allegations, runs that it is state enterprises have been, not coming up to mark, probably we may have to say that arbitration with other firms without, if it's a state enterprise, we may have to put something in place there. So the allegation wouldn't be made that something went on there, it's an arbitration because they're going to hide it. The public wouldn't know, and it's taxpayers' money that would be misused. The articles say, so if it is true that this happens now, that these companies choose this form, that creates a very real risk that corrupt contracts can be legitimized and enforced through arbitration. So this is something I think we have to be aware of. Because, again, it mentioned, historically, there have been a general reluctance by arbitration tribunals to deal with bribery and corruption issues where they do not form a substantive part of a case before them. Arbitrators do not always feel comfortable investigating signs of corruption, particularly where, as will frequently be the case where both parties to the arbitration have been involved in the corruption. Neither of the parties raises the issue. So arbitrators are often concerned that the consensual nature of the process and of the appointment means that they cannot self-initiate investigators. So therefore, it may be a disservice sometimes. Arbitration could be a disservice if you have this sort of thinking. And it made mention arbitrators sometimes feel that they lack the powers to enforce parties to hand over incriminating material, unlike domestic courts, and are therefore limited to simply drawing adverse inferences from a failure to produce documents where a party is requested to do so. So there are dangers that I wanted to mention out. They mention 2 situations where red flags, where the tribunals themselves become suspicious, and the tribunals themselves may wish to initiate investigations, to try to look at it. So when they see red flags happening, but their concerns will include whether they have the necessary procedural power to do so, and what evidence and standard of proof they should require before making any factual findings on corruption. So red flags raised in the proceedings. Also, when one of the parties themselves usually somehow alleges corruption, and allegations of corruption are generally either made during the arbitration proceedings or at the enforcement stage. So therefore, we have to be careful that somehow that arbitration is not seen as a shelter for corruption. So this is all we have to look at. And let us say you have instances where you, how could we mitigate against this? Well, simply, in Canada, Mr. Vice President, you know, they had a trend where they were once considered one of the least corrupt countries, and there was an open tendering for any contracts over $100,000. So therefore, if we are thinking we're going to have arbitration, but we are worried that something amiss may be there, why not have it in any sort of state contract or any sort of contract? We have open bidding, open contracts. It's taxpayers' money. We need to know where it's being spent, how it's being spent. Forget the idea about people say, well, they may have business deals. No, at this stage, I think transparency is much more important. So open contract, open biddings that probably you may have, as I say, published, online, so persons can say, look, this contractor is going to get this, this is what they're bidding, this is what part of it is. So this is a stage we have to reach. And therefore, remember, the problem we had to is as I said, the problem could be solved by this open bidding contract that I mentioned. And except, you know, if you have the disadvantage I heard mentioned is trade secrets in certain cases. You don't want that trade secrets in open court. So I think persons with trade secrets is an exception where arbitration should be there. But in terms of starving off the corruption, the open contracts I think could help that, as well as the fact that why not have, if perchance we don't decide to go that way with an open contract, we know the state body is entering into contract with some persons or some contractual firm. It's there. We see the contract. We see how the fine details. So if we decide not to go with open contract, the other thing we could look at is, since it is a closed arbitration sort of court, it's closed. Nobody can know what's going on. Nobody can know if any deals were made. Nobody can know if there were any sort of allegations of bribery. And which again is a disadvantage, I'm saying, to transparency. Why not have a time limit? A time limit in the sense that if you look at, in the States, there are official documents where you have official documents, secret documents. You know, they have like a 10-year period where state documents may be classified. If we are going to arbitration and there's a possibility that it is a court matter, and you have a suspicion something may occur, then why not have a limitation, say 3 years after, 5 years after, where that whatever was discussed there, what came to light there, what was put across there, could be now declassified or actually put out there 3-5 years after, where persons could now judge, hey, that company that came here, that did business, look what was said about them. So therefore, we raise a red flag to that company who are in the global market. So you may get a Brazilian company coming here, you may hear things about them, 5 years after the fact, granted, if we go this way, or 3 years after the fact, but then it will now alert others globally that if the same company is doing business elsewhere, has done business elsewhere, we need to look out at that company. We need to red flag that company. We need to go into the business of that company and scrutinize them more. You remember, we also have to appreciate the fact that the OECD, the Organization for Economic Cooperation and Development, that body, signatories to that body actually look to see if there are any corrupt practices, if there are any sort of bribery or corruption. And all signatories to that body would probably frown on secret contracts that are not being, that are sheltering, I'm saying, some persons who are involved in bribery. So even for a time frame, I am suggesting we should have to look at that avenue. So I must say, when I looked at the fact that this piece of law came to us, I realized, okay, what is the discussion in the global scene? What are they thinking about this? Because this has been raised before about the arbitration could be hiding corrupt practices. And this is where we need to explore, because the World Bank, in collaboration with the UN, has put forward the idea of an international anti-corruption forum, which would provide an international arbitration mechanism, allowing for decisions on the commercial effects of corruption and bribery. So this is one aspect in the future that is already in discussion, where we are looking at arbitration as a good way forward, because as we've seen all the 9 advantages that was mentioned by the Minister of Trade. But again, we have to realize that in that system that we are creating, that has freed up the court from the backlog, it's actually faster track, all the advantages we fast track. The element of corruption is how we need to look at what the World Bank is thinking. And also some academics have also recommended forming either a court or an arbitral tribunal that would review public sector contracts and international commercial transactions to identify corruption. So the issue of corruption definitely is something that we need to look at. Also, I must say, when I looked at this, I wanted to figure out what was the advantage of arbitration. Is there any sort of advantages to it? And as I looked, I actually saw a survey that was done to speak on it. Because if I'm going to say, well, I'm backing this legislation, I'm backing it because of the modernization that is required due to the fact that you have to modernize to keep up with the technology. But there's an article, the School of International Arbitration of Queensberry University of London, they did a 2021 International Arbitration Survey. And they were looking at arbitration in a changing world. And in it, they did mention, hey, this is the way to go forward. And they explore how international arbitration has adapted to demands. So they interviewed a pool of persons internationally, arbitrators, in-house counsel from both public and private sectors, and private practitioners. And the conclusion that they came to was really, they actually said, and this is where I looked at the advantages. They said that the current choices and future adaptations, when they looked at it, they actually realized that international arbitration is the preferred method of resolving cross-border disputes for 90% of the respondents, either on a standalone basis, 31%, or in conjunction with ADR, 59%. The 5 most preferred seats for arbitration are London, Singapore, Hong Kong, Paris, and Geneva. So we'll be having a hard time to find our way in there. And they say greater support for arbitration by local courts and the judiciary, increased neutrality and impartiality of the local legal system, and better track record in enforcing agreements to arbitrate and arbitral awards are the key adaptation that would make other arbitral seats more attractive. So basically, we have to win over the attorneys, we have to win over the courts, we have to let persons know that this may be something that we could go at. And, if we are now fighting for a place in the world, one of their fallbacks that they saw, and this is where I think we can do it. So this survey actually named a fallback that they saw, and they mentioned that there is a problem where the use of technology, the virtual reality. So not all countries may have that availability, but we have to thank our Minister of Information Technology for his work he's doing, but more so, we have to develop our cybercrime laws. Because you see, with persons now being able, if you have, as I say, a patent that you have under review, you're disputing it, you definitely would have to have the cybersecurity come into place here. So this is something that the Attorney General may have to now come in with some cybersecurity legislation, which is on the agenda, but to put it in such a way that we know that persons would not be able to hack into these meetings. Because if you're having a meeting with arbitrators here and then one in London, one wherever else in the world, we need to know that we have that security. So coming hand in hand with this legislation, we have to develop that IT professional secure factor. Because even in this survey, it was mentioned only around a quarter of respondents said they have frequently or always seen cybersecurity measures being put in place in their international arbitrations. The majority, which is 57%, encountered such measures in less than a half of their cases. So even in all those arbitration bodies worldwide, there still is a lack of the cybersecurity. So therefore, we have to, they need to also buck up their game. Now, again, this survey also looked at, it made mention here too, that more than, strange enough, they looked at diversity, where they said that more than half of the respondents, so this is really a survey among persons who use these international bodies, but more than half of the respondents agree that progress has been made in terms of gender diversity on arbitral tribunals. So there were lack of women, but over the past 3 years, there has been some progress. However, less than a third of respondents believe there has been a progress in respect of geography, age, culture, and particularly ethnic diversity. So we are looking at questions now on the tribunals, on their makeup of their, probably where they come from, their culture, their diversity. Because if you have an arbitration with some Chinese company and some other company, who knows, the Chinese company may feel the court might be in favor of the tribunal might be in favor of a pro-American or pro-British, because if it's the ICC. So who knows, to make the participants more at ease, we may have to look at this fact that was mentioned in the survey that persons saw was something to improve. And here's where we could improve, because we now could offer our university graduates in the law faculty, we should have an arbitration element attached to that. We should have, and the University of the West Indies is one of the top universities in the world. We are top there. So if we now can have an arbitration school for those persons that come all over the world to be trained here, this is one up, I think, for the University of the West Indies. Plus, if we have a trained cadre of our own arbitrators, where we now see a lack of persons saying that there may be a lack in ethnic diversity, we may be that channel, we could supply persons there. So therefore, this deficiency that was noted in this survey done by this international arbitration survey, we could use it to our advantage. We could now, as I'm saying, train persons. We could now have those cadre of persons who we could now be able to supply. We also see, as I mentioned, we need to increase the use of virtual hearing rooms, because this was something, again, was found lacking in this survey that was done. Another mention, another thing I want to mention, though, is the fact that the fact is, if you are having the arbitration and persons willingly go towards that format, right? So parties agree. I have to make mention, though, that there were concerns in some parts of the United States where they found that when persons were actually going to get contracts, you had mandatory arbitration forced on them. So therefore, let us say I'm unemployed, but I'm going with a company. You found that I now would be forced to say, well, my level of any sort of a grievance, it has to be through arbitrator rather than the courts. And they found that this went against the grain of good good labor relations. And what was made mention, though, is the fact that I think it was Michigan, one of those states, decided that that forced arbitration cannot be part of the employment contract. And this is something we have to think clearly. Would this open the doorway where people could now take advantage of workers? Workers, they're trying hard to get a job, they can't get a job, and somehow we would be able to try and force them into this. So this is where the United States had reached, and this is where there was now a pushback in terms of the rights of the workers to see if we could somehow prevent any sort of force sort of arbitration put on any sort of contracts. So this is something that I'm hoping that I can, that we may have to look at this, because in-house arbitration mandatory may not be something that will somehow go down well with workers, with the unions. So this is something we may need more discussion on. So at this stage, I must say that I was also thrilled in the fact that today we are moving with this model legislation. I am also saying that in the public interest, we have to get that level of transparency somehow in there. And I am thinking it's time to update this. And the fact is, we have to know that even though it's there, even though we plan to be a hub, an international hub, there may be limitations, there may be challenges, there may be as competition, as Bahamas we heard Senator Thompson Ahi mention. So we heard that being in our geographic location may give us that opening to Latin America, but Latin America has really already shown a preference for the ICC, and I strongly doubt they may want to come here, but we can benefit by, again, being a hub to train those persons. I mentioned about the deprivation of civil rights that I'm hoping that...
Senator, you have 5 more minutes.
Thank you, Mr. President. And I mentioned, the state that I had mentioned is the fact is the Detroit Law Review in the fall of 1983 had an article, Arbitration and the Public Employee, an Alternative to Strike. So while some may see as an example, it's a way to prevent unrest. Compulsory and binding arbitration may also be looked in a way that the workers and the labor rights may be frowning on, and therefore persons may decide, look, we need to go into this a little more. There was also an article, the EPI, the arbitration epidemic, mandatory arbitration deprives workers and consumers of their rights, 2015 report, and it was a briefing 414 where they actually made mention. So California was the state actually where they said that employers can no longer require employees on job application to sign arbitration agreement. And I think we may have to come strong with this if we want to prevent a sort of abuse. And the mandatory consumer and employment arbitration is different from consensual and commercial arbitration. So this is something I think we may need to watch out for. And I must say that all in all, I would think that I have to support this. I think that in conclusion, I want to say that it takes not more than this law to do this, because it actually takes the Foreign Affairs Ministry to go in and market us. It actually takes the Education Ministry to produce arbitrators. It actually takes the Ministry of Trade to come in and tell persons we are now better to do business. It takes an effort. It takes the information technology to ensure that we could be in line with Jamaica even better than some of those arbitration bodies that already exist. And then, so therefore, I think that all in all, I am supporting this legislation. I commend the government for bringing it here today. And I just put I think it's time, and I just had to make mention my few little cautions that I would have given. Thank you, Mr. President.
Senator Richards.
Thank you very much, Mr. President, for allowing me to join the debate. I will not be 40 minutes or 30 minutes. Hopefully just under 20 minutes. Because a lot has been said already since I think we started the actual debate about 2 minutes after 11. Mr. President, I consider this progressive legislation, progressive law. Given the fact that we about 10 years shy of the 100-year-old 1939 bill that we are operating under, which is unacceptable in any realm if we want to be a modern society and taken seriously. I also commend the approach, and it's not the first time I've seen it, but I think it's becoming a trend by the government to include stated objectives in the bill, which I think is very admirable going forward. I think that's the way we should go. So we know exactly what the bill, the law, in large respect is intended to accomplish in this state. In Part 1, Clause 5, the objectives of the Act are to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a method of resolving disputes. B, facilitate and obtain the fair and speedy resolution of disputes by arbitration without unnecessary delay or expense. Two of the stated issues before with time and costs. And C, facilitate the use of arbitration agreements in domestic and international matters, also very important. D, facilitate the recognition and enforcement of arbitral awards, and to adopt what is the gold standard UNCITRAL model law, which is what is used around the globe, and certainly in use already in other Caribbean countries. The opportunity also to improve the ease of doing business and to expedite these negotiations in complex commercial negotiations with both, as we said before in the objectives, domestic and international partners. My understanding is that someone told me not too long ago, there was a matter in Trinidad and Tobago with an international partner that cost the local partner 4 million TT a day because it had to be sent to London and it was quoted in pounds in terms of the cost. So you can imagine that going on for 10 days or a month, the cost to the local entity. And that sort of expense can be saved in Trinidad and Tobago, in addition to unclogging the local courts, which we know have challenges already. It has the potential also to improve our competitiveness as a business center, our ease of doing business, and we have the potential, if we get it right, as many have said before, to become the center of arbitration, for arbitration in the region. Mr. President, the AG identified some broad parameters within which the partners will engage in this proposed law, including consent and participation, which is voluntary, selection of arbitrators, including experts, which is also very important because many times matters go to the courts and the judges are not experts in the particular subject area. And the cost to bring in experts in those situations end up being exorbitant, and the trial is sometimes delayed in quite an extensive manner to try to find these experts in the context of the criminal justice system as it exists now, in the civil arena. Consensual and neutral proceedings, private and confidential, and fidelity to decisions or finality of decisions. The potential for virtual proceedings also is in alignment with modern thinking for business practices in Trinidad and Tobago, and certainly in establishing us as a center for arbitration and business, which has been a long-touted objective of various different administrations in Trinidad and Tobago. And this can help us move closer to that, and by extension, in extension to being a business center and an arbitration center, bringing investment into Trinidad and Tobago in a big way, sustainable investment into Trinidad and Tobago. So there are also other tangible offshoots of this for the Trinidad and Tobago economy. The issue of alternative dispute resolution, ADR, may very well also set an example across other domains in the country. We're a very litigious society. And if, by example, we see the business community taking this step in Trinidad and Tobago, maybe it can trickle to other areas where we have a lot of conflict in the country. And we use that sort of alternative dispute resolution approach in many of the contentious issues facing Trinidad and Tobago. So I think we can also gain in that way by setting an example in one sector, but it being an example to other sectors, not to be confrontational. Maybe we could even employ it in this honorable chamber at some point. And we're also aware in Trinidad and Tobago that the judiciary has been championing ADR and mediation in many matters, as opposed to litigation, which bodes well for us as a country. Many have identified, and when I first, and this was a lot of homework, I have to tell you, Mr. President, this, going through this and trying to identify, because part of our job, or the main part of our job, though it may be straightforward to many, is to scrutinize the legislation, the bill, to make sure that there are no gaps, to make sure that the objectives are being attained, to make sure that no one benefits inordinately more than another. So, in terms of doing due diligence, you really have to go through and read and reread and understand. So, on first reading, I had grave concerns about Part 10, which many others have raised. Senator C. Prasad, Senator Lakshmi Diyal, the Minister of Tourism also referenced it, with Clause 60, and the potential for, well, nefarious activity, and you may call me a cynic, but we've seen the issue of state enterprises and entities in several different administrations siphon off billions of dollars corruptly in this country. Let's not pretend we all know it. And so, being very meticulous about potential for that, I think it's also part of our jobs here as legislators. It may slip the government, it may slip any other person, but I pay particular attention to potential. I'm not imputing improper motive or intention, but you never know who may be in a position to exploit a gap in legislation. And I think we have to be careful with that. So I had concerns about Clause 60, like many others, but when you read it in its entirety, you know, and it reads, arbitral proceedings shall be private and confidential. That's part one. Disclosure by the arbitral tribunal or a party of confidential information relating to the arbitration shall be actionable as a breach of an obligation of confidence unless the disclosure, and they are the provisos, so that there are openings for disclosure under specific circumstances. A, is authorized expressly or impliedly by the parties, or can be reasonably be considered as having so been authorized. B, is required by the arbitral tribunal or is otherwise made to assist or enable the arbitral tribunal to conduct the arbitration. Because you don't want, they need to tell another party for expertise, and they end up in a breach because of that. So it's allowed under that condition. C, is required, one, in order to comply with any other enactment or rule of law. Very important. So a party is cleaved or there for other aspects of the legislative framework to intervene if a breach is required under that specific condition. Two, for the proper performance of the public functions of the disclosure or 3, in order to enable any public body or office holder to perform public functions properly. And I'll go down past the others to E, is in the public interest. Now, or F is necessary in the interest of justice. Now, those are openings for breach of the disclosure and confidentiality provisions in the Act. And while they're there, and admirable that they're there, we all know how litigious this society has become, because somebody will have to actually test it. Because who will determine what's in the public interest when two parties are negotiating? Someone may say, I suspect something onerous is going on. For example, if we have a state enterprise negotiating with an international partner in a particular circumstance and they both have nefarious intentions. One side chooses one arbitrator, the other side chooses the other arbitrator, and they collude to choose a third arbitrator who will further their interests. That's a possibility. In that circumstance, an outside entity or person who may have information that something is terribly wrong and may put the state at a disadvantage needs to be able to intervene in the public interest. But who makes that intervention? And who decides that that is in the public interest to intervene according to the provisions of the law? And that is where the little nebulous area comes in. And that is where some people may still have concerns, because we all know how creative we are in Trinidad and Tobago, or how creative we have been in stealing from the public. And I'll say it plainly, it is stealing. And while this, as I said before, is progressive law, we have to be au courant with our history. It has been our history. And we cannot pretend it hasn't happened before and it may not happen again. So we have to protect the public interest. So my suggestion is that for negotiations that involve state entities or state enterprises or the state in any way, that we insert some sort of provision that one of the arbitrators or more, in terms of the third one, may be nominated by an independent professional organization or civil society organization that has the public trust at heart. That way, at least one individual in the room cannot be swayed, or hopefully cannot be swayed, to engage or facilitate dishonest action. And I think that may be something that we may want to consider so that we don't end up having to litigate this with someone bringing a charge of impropriety and then having to take it to court and the High Court and the Privy Council to determine if the public interest has been served and if an intervention through the public interest clause should be triggered. Because I can see where we are in society and that people have legitimate concerns about propriety in public affairs, particularly, as I think it is Senator Mark would have indicated, $25, $30 billion in state services procured by the state every year. So we have to protect the public interest, and we have to put as many safeguards as possible to protect that. And as I indicated, I think I went through quite a bit of detail to indicate in good faith that a lot has been put in here to mitigate that. But I think we can possibly go one step further in terms of ensuring the public interest, given our history in Trinidad and Tobago. Mr. President, also, one of the issues that I have not seen addressed is the issue of conflict of interest. And maybe I missed it. As I said, it's a voluminous 67-clause bill. But when you look at the bill, I don't see provisions for declaration of conflict of interest beforehand or during proceedings, or conflicts of interest that may arise during the proceedings related to an arbitrator. So someone may fail to disclose, and what is the penalty for that? Because it's one thing to put the provision for conflict of interest in the law. It's another thing to discourage it with a hefty penalty or fine. Because a conflict of interest with multi-million-dollar deals is a serious issue. It also opens the door for potential corruption. And we have to guard against that fervently in the public interest once again. So I think some type of clarity, if through you to the Honourable Attorney General when he's wrapping up, if we could get some sort of clarity on that conflict of interest issue where arbitrators, chosen arbitrators, are concerned from each of the parties, and also the potential third arbitrator, which is supposed to be agreed upon, or more arbitrators, by the parties engaged in the negotiation. So, as I said, I was not going to be particularly long. I just wanted to identify and put on record that I think this is progressive legislation. It is needed in Trinidad and Tobago, not only to modernize the framework and to update the 1939 law, but to put us on competitive footing with other players in the region in terms of our business environment in Trinidad and Tobago. I've identified the areas of concern, as others have, and potential remedies for those. And with those few words, Mr. President, I thank you.
Attorney General.
Thank you. Go get him.
Thank you very much, Mr. President. And thank you to my colleagues who have contributed to this debate today. I would first wish to express my appreciation, as I seem to be getting into the habit of doing, to my colleagues on the independent bench for the thoughtful, careful, studied commitment to nation contributions. And so I would like first of all to address some of the remarks that have been made today by my independent colleagues, to reassure them that some of the concerns which have been addressed are already taken care of in the bill which the government wishes this House to pass, and to reassure them further that in one particular instance, which I will come to, I have listened carefully to the comments and I will make a further contribution. First of all, if I may, Mr. President, address, beg your pardon, some of the comments of learned Senator Sipasad, who went into some detail on some of her concerns, which I think happily I am able to address by a careful review of sections of the bill which is before us today. She listed, as I took note, 7 or 8 concerns, some of which were subdivided. And I will attempt to deal with concerns 2 to 7 first. I will deal with concern number 1 last, because when I come to deal with concern number 1, I will want to address one of the concerns that has also been addressed by her independent colleague and Senator Timal. So turning first to the concern raised with respect to lack of formal discovery provided for in the bill, which was the second of the concerns addressed by Senator Timal. I think those concerns, if I may say through you, Mr. President, can be addressed when we read sections 44, 45, and 28 of the bill together. Because if what we are concerned with is a lack of process for formal discovery in the arbitration procedure, when we look at section 44 and 45, first of all, it's very interesting that the draftspersons, UNCITRAL, who at the end of the day are the principal draftspersons, it's very interesting what is said in the bill. So clause 44 tells us an arbitral tribunal, or importantly, a party, remembering always that we are concerned here with giving effect to the contractual intention of the parties to the agreement. An arbitral tribunal or a party, with the approval of the arbitral tribunal, may request from the court assistance in taking evidence, and the court may execute the request within its competence and according to its rules, that is to say, the court's rules on taking evidence. 45(1). A party to arbitral proceedings may use the same court procedures as are available in relation to legal proceedings to secure the attendance before the tribunal of a witness in order to give oral testimony or to produce documents or other material evidence. Subsection 2, the court procedures under subsection 1 may only be done with the permission of the tribunal or the agreement of the other parties. And the court proceedings, subsection 3, may only be used if A, the witness is in Trinidad and Tobago, and B, the arbitral proceedings are being conducted in Trinidad and Tobago. Subsection 4, a person shall not be compelled by virtue of this section to produce any document or other material evidence which he could not be compelled to produce in legal proceedings. We remind ourselves, Mr. President, that court, used as that word only, court, because there are other passages that refer to state court or competent court. We'll come to that. But we remind ourselves from the definition section of the bill that court is defined to mean the Supreme Court of Judicature. So when we read sections 44 and 45, we are reassured for purposes of formal disclosure and formal discovery purposes that either at the instance of the arbitral tribunal or at the request of one or other of the parties to the arbitration, can ask the court, the Supreme Court of Trinidad and Tobago, to invoke all of its procedural force to ensure, relevantly within the context of the dispute that is taking place, that there is formal discovery of process in the course of the arbitration. And there is also section 28 of this bill which deals with disclosure. 28 reads, subsection 1, an arbitral tribunal may require any party to promptly disclose any material change in the circumstances on the basis of which an interim measure was requested or granted. And it continues at subsection 2. That deals with the interim measures and the preliminary orders. But the point there, without belaboring it unduly, is that both the tribunal and the court, at the request of a party, are able to invoke disclosure procedures, full and ample formal discovery within the rules of the court's evidentiary proceedings. So that, I hope, addresses the first concern, number 2, of Senator C. Prasad. Her second concern was that it will not always be cost-effective for parties to agreements to be able to undertake the cost of arbitral proceedings. Well, that is a truism, that is a reality. It is often not the case that parties can earn enough money to afford expensive lawyers to go to court. We will have to deal with that as best as we can, but ultimately, at the end of the day, the legislation that we are asking this Senate to pass is not to exclude access to justice, but to improve access to justice. And we will have to deal with the availability of parties to be able to afford to access the arbitral proceedings within the framework of the agreements which they have signed. One would assume when they enter into the agreements, they have some means by which they would expect to be able to enforce the agreements which they have voluntarily and consensually entered into. Senator Timal made the point as well, point number 4, that there is limited precedent value in arbitral proceedings because the awards of the arbitrators, unlike a court decision, isn't a precedent which can be relied on. And that is correct. But there are two sides to every coin. And the flip side to the coin of the absence of precedent is the encouragement of the arbitral process to allow for flexibility from case to case on every occasion that parties to an agreement invoke the arbitration clause in their agreement and seek to appoint arbitrators who will be regulated by the provisions of this legislation when we pass it into law. And of course, respecting the fact that the precedent value of an award of an arbitrator in principle is limited by the fact that the parties to the agreement also, ex necessity, have agreed that the proceedings of the arbitral tribunal will be confidential. So it's both sides of the coin, and we accept that the awards of the arbitrator will not be published so as to be precedent, but we have every confidence that given the fact that the parties to the contract have agreed to this process, given the fact that they have the flexibility outside of the norm which is available in a court of judicature to select arbitrators with reference to their specialized expertise, that we can expect in the norm, there will always be exceptions to the norm, we can expect in the norm that the parties to the arbitration agreements who have invoked the arbitral procedures will result in getting what they consider to have been justice done to them. The lack of the fifth point that was raised by Senator Sipasad was the lack of public scrutiny and transparency. And I would suggest that the very sections that I have referred to in the context of confidentiality, because the process will remain ultimately confidential, but in the course of the process, while the parties are engaging the jurisdiction of the arbitrator and engaging the procedures to allow them access to justice, I would confidently expect that the sections that I just spent some time on in respect of formal discovery, sections 28, 44, and 45, will conduce to a degree of public scrutiny and transparency inter partes, those parties who are before the arbitration tribunal in order to get justice. And of course, we'll have to rely on, which is a point that I will come to when I address one of the points raised by Senators Dial Singh and Richards, we will have to rely on the integrity of the arbitrators who are chosen by the parties, and therefore, in consequence, the integrity of the process. We live in, regrettably, an age where mistrust has almost become a norm of our existence, but I'm not one of those who sees doom at the end of the corridor, and I think that we have to continue to work towards improving our conditions and therefore enabling this legislation, which will be passed into law, to allow for greater access to justice. In spite of our imperfections, we are improving the whole lot. And one of the other points that was made by Senator Sipasad had to do with the concern that she raised about the confidentiality of the process. And that is a flag post of the process, so that I can understand the concern that emanates from the confidentiality provision, because in our society it could be used as a synonym for secrecy and all that is ill with secrecy. But ultimately, at the end of the day, on the basis that I have just articulated, I think that it conduces to a process that will allow an honest exchange of positions with a commitment to moving forward. And that takes me directly to a point which was made by my colleague, the Minister of Trade and Industry, which I applaud. And it is the simple point that she made when she was making, my colleague Senator Gopi Skoon, when she was making her contribution, that the parties will engage in the arbitral process while preserving their relationship. And that is one of the unique features of the alternative dispute resolution process, because in an alternative dispute resolution process, what we seek to discourage is gloves off, fight at all costs, and walk away the victor and leave the vanquished sprawled on the floor with not a breath of life left in her or his body. That is not the process of alternative dispute resolution. The process of alternative dispute resolution is to recognize and respect the fact that people will have differences, but their differences need not destroy them, nor be used as tools to destroy each other. You can engage your differences, resolve them, and in the commercial business environment, you can continue to do business with each other. So I applaud Senator Gopi Skoon, my colleague, Minister of Trade and Industry, for reminding us of that parties will engage in the arbitral process while preserving their relationship. And that speaks to the essential need for the process to be preserved in a condition of confidentiality, so that howsoever the dispute is resolved, at the end of the process, the parties can shake hands and hopefully can continue to engage with each other in their commercial relations for the betterment of their individual enterprise and for the national societal betterment. Senator Sipasad spoke to a couple other things that I will just wish to address briefly. The potential disadvantages, the limited appeal was one of the concerns that she raised. And that raises an important point in the frame and the ethos of this legislation, because we recognize that in this legislation, when we pass it, as I hope we will, the court is given a limited role by way of appeals. And that is deliberate, and that is the choice of the parties who ultimately have chosen an alternative option of the arbitral process. Because what we recognize is that the court process can be time-consuming, and it can give an unfair advantage to parties who are engaged in the litigation process. I have been an advocate for 40 years. You can get quite involved in the dispute without the resolution in sight and yet walk away the victor, because ultimately the adversarial process does not necessarily reward truth. It rewards strategic and skillful maneuvering. And that is what we are seeking to avoid by encouraging frank and candid exchanges in the interest of persons continuing to do business. And that is why the appeals are limited. But it does not mean that you do not have access to court. Throughout this bill, and I dealt with it in my opening, there are any number of instances in which the bill makes explicit provision for the parties to have access to the supervisory jurisdiction of the court, but limiting it to the first instance level of the High Court and not taking it to the level of the Court of Appeal. So that is the limitation, but it is not that the discretion and the jurisdiction of the High Court to correct patent errors is being excluded. And therefore, when we talk about limited appeal, we have to accept that the courts can be availed, but not to the extent of appeals all the way to the Court of Appeal and the Privy Council or the Caribbean Court of Justice, depending on which jurisdiction we come from within CARICOM, because ultimately we want an early resolution of the dispute so that parties can continue to do business. It is, for instance, significant that in the encouragement that is given, and I've dealt with it already, I won't repeat myself, in the encouragement that is given for arbitrators and foreign representatives to come into Trinidad, the seat of the arbitration under this bill, you are allowed to get the result in within 30 days. And if you get the result in on a fair process within 30 days, you get tax exemptions for getting the work done briskly. Because ultimately, what we want is for people to continue to do business with each other. There were other very telling contributions from some of my other colleagues on the bench, and I will turn to those now with the limited time that I have left. Senator Paul Richards made, as is a habit of his that I look forward to being privy to, telling contributions. So that he made a point that is of interest when he spoke to the fact that he hoped that the advancement that we will be making in Trinidad and Tobago by adopting the alternative dispute resolution route will trickle down and will persuade others in our society to recognize that progress is going to be made by those of us who are able to resolve our differences with amicable embrace as opposed to adversarial disgrace. And it reminded me to remind this House, Senator Richards's contribution on the advantage of alternative dispute resolution, that there is a pedigree that this society can be proud of in terms of alternative dispute resolution. And that pedigree, Mr. President, is taken from as far back as 1966, the Industrial Relations Act of Trinidad and Tobago. That was Trinidad and Tobago's early embrace of alternative dispute resolution, because you will see in Section 12 of the Industrial Relations Act that parties are encouraged, even in the face of acrid disputes between employers and trade unions, to seek conciliation before the Industrial Court of Trinidad and Tobago. And that is legislation that has been on our law book since 1965. And there is actually a division in the Ministry of Labor, the Conciliation, Advisory and Advocacy Division, that is responsible for managing the resolution of labor conflict in the society, including the private sector, state enterprises sector, and specific public sector entities. And one of the services offered by that division is dispute resolution, where conciliation proceedings are conducted between employers and unions in rights disputes, examples, dismissals, suspensions, warning letters, etc., and interest disputes. So our resort to alternative dispute resolution in this country has been trickling up since 1965, and what we are doing today with the passage of this bill into law will be to give flower and blossom to an early desire of this society to be better able to resolve its disputes without unnecessary conflict. Senator Richards also spoke to Section 60 of the bill, and I was pleased to hear him, as he did, interpret the section in the way that he did. And it is very interesting because the disclosure that is spoken to in Section 62, when it is read carefully, 60 subsection 2 that is, when it is read carefully, is not a prohibition against disclosure, because subsection 2 ends or begins unless the disclosure, and then certain things are authorized. So one could almost read it in the converse to mean notwithstanding subsection 1, that is to say, arbitral proceedings shall be private and confidential, notwithstanding that, disclosure may be permitted in the circumstances outlined at sub A through to sub G of subsection 2 in the discretion of the arbitral party or a party to the dispute. So again, that is significant, and I was heartened to hear Senator Richards speak to his interpretation of Section 62 correctly as he did. And that brings me to one of the points that was made by Senator Diyal Singh, because he, with justification, raised the concern about corruption. And I want to reassure Senator Diyal Singh, as I reassure Senator Richards and all of the senators who have the true interests of this country at heart and are interested in legislation that will promote the national interest, that even in the evolving reality of the arbitral tribunal, there is the recognition that the all-pervasive corruption about which we are all concerned cannot be taken for granted nor ignored by a fair justice system of which the arbitral proceedings will be part. And with your leave, Mr. President, I would refer this House to an article out of the International Bar Association. That article is headed, if I may, it is headed, Addressing Corruption Allegations in International Commercial Arbitration and Investment Arbitration, dated February 21st, October 2022, by Stéphane de Nafacel of Nafacel Paris, Salom Garnier of Paris, and David Duran-Hernandez of Paris. Paragraph 1, with your leave, states, corruption is as disapproved as it is widespread, both in the public and private sectors. It's a long article, and there are two other articles. I commend it in its entirety to my colleagues. There are two other articles that are of interest by way of reassurance to the senators who are concerned to ensure that the confidentiality of the arbitration process shall not derail the transparency and accountability which all persons concerned to expose corruption must remain focused on. Paragraph 15. Another possibility for arbitral tribunals to bar investors' claims has been to apply the clean hands doctrine, which requires that the claimant should have a proper conduct. Indeed, if some form of illegal or improper conduct is found on the part of the investor, his or her hands will be unclean. His claims will be barred, and any loss suffered will lie where it falls. This doctrine has been used by arbitrators to avoid granting access to international arbitration to resolve disputes because it is evident that its act had a fraudulent origin, and as provided by the legal maxim, nobody can benefit from his own fraud to absence of fraud in his conduct at the time of formulating his claims. and paragraph 28. Effectively, as arbitrators have become increasingly active in the fight against corruption, I repeat that, effectively, as arbitrators have become increasingly active in the fight against corruption, they need to be careful in rendering enforceable awards that do not violate international public policy. Therefore, an award in which allegations of corruption are ignored or in which an unlawful act is legitimized in contravention of these principles run the risk of being overturned. So we have an international consciousness in the learning that is being applied to judge, assure, and interrogate the conduct of arbitrators, that they are on notice not to permit corruption to derail the process which they are engaged in. I dare say that as we pass this legislation into law, we will, as I have already committed, keep it under review. And if there are further amendments that need to be brought to the table, we will be returning to the Parliament. We will keep it under review. But for the time being, I would urge the members of this Senate to support the government's efforts to pass this legislation into law. With respect to Senator Timal, how much more time do I have, Mr. President, if I may ask?
5:38.
Thank you very much. With respect to Senator Timal, I want to spend a little time reassuring Senator Timal with respect to the concerns that he addressed, all legitimate concerns, starting with Section 4, which he was concerned about, 4.2 in particular. I would recommend that we read Section 4 in its entirety, because I understood Senator Timal's concern to be that Section 4.2 was placing domestic arbitration at something of a disadvantage in terms of the unenforceability of the Act in relation to domestic arbitration. I hope that I did not misunderstand the learned senator, and if I did, I will give way to be clarified. Section 4 reads in its entirety, 4.1, this Act applies to domestic arbitration and international arbitration, subject to any agreement in force between Trinidad and Tobago and any other state or states. So we begin with the clear, articulate, express provision that says this Act applies to domestic arbitration and international arbitration. We remind ourselves that the immediate preceding section, Section 3, tells us this Act binds the state. So the Act is all-encompassing. It does not seek to apply to any particular class or body of persons to the exclusion of others, except where it makes particular exception. And that is where subsection 2 then takes us, the subsection which caused Senator Timal some concern. It reads, the provisions of this Act, except sections 11, 12, 30, 31, 32, 56, and 57, apply only if the place of arbitration is in Trinidad and Tobago. And subsection 3 goes on to say this Act shall not affect any other written law of Trinidad and Tobago by virtue of which certain disputes may not be submitted to arbitration or may be submitted to arbitration only in accordance with provisions other than those of this Act. Read in its entirety, we begin with the understanding that the court to which we are going to turn when we look at sections 11 through to those sections which are accepted is not the Supreme Court of Judicature, which is defined as the court in the definition section of the legislation. So what subsection 2 is saying is, bearing in mind that this is a piece of legislation that is going to apply in Trinidad and Tobago, where Trinidad and Tobago is the seat of the arbitration, in limited circumstances where it will be called on for application to circumstances arising out of Trinidad and Tobago, the Act may not apply because the national law of the countries outside of Trinidad and Tobago will have to be allowed to apply according to those national laws. So if we go immediately to Section 11, we see that Section 11, one of the accepted sections, says, a court before which an action is brought in a matter which is the subject of arbitration agreement shall, if a party so requests, etc. And we see that that section, read in its entirety, refers in the first instance to a court in which an action is brought on an agreement. The agreement could be an agreement struck anywhere. It could be an agreement struck in Paris, which is subject to the national laws of Paris, or it could be an agreement struck in Venezuela, according to the laws of Venezuela, wherever. It begins, a court before which an action is brought in which in a matter which is the subject of an arbitration shall, if a party so requests, refer the dispute to arbitration. So what happens is that if it applies in Trinidad, this act will apply to regulate the dispute according to the court's jurisdiction, the Supreme Court of Judicature. But if it is in a court outside of Trinidad, well, then the court outside of Trinidad will have the appropriate jurisdiction. When we turn to the other subsections, Section 12, it is not incompatible with an arbitration agreement for a party to request before or during arbitral proceedings from a court on an interim measure of protection and for a court to grant such measure. And that is again consistent with the fact that you are dealing there generally with an arbitration agreement, which could be an arbitration agreement subject to the national laws of Trinidad and Tobago, enforceable in Trinidad by our courts or in a country other than Trinidad and Tobago. That point is made even clearer when we go to Section 30, the section next accepted by the Section 4, subsection 2. It says, beg your pardon, Mr. President, recognition and enforcement. Subject to Section 31, an interim measure, etc., issued by an arbitral tribunal shall, irrespective of the country in which it was issued, be recognized as binding and, unless otherwise provided by the arbitral tribunal, upon application to the competent court. So the draftsman here is using a turn of phrase to delineate and underscore the fact that he is not referring to court in the normal course as defined in the Supreme Court of Judicature definition section of this legislation, but to the competent court. That is to say, the competent court of the state in which the arbitration agreement is going to be capable of enforcement. And that is why those sections are accepted by Section 4.2. If we were to look at Section 30, subsection 3, the court of the state where recognition or enforcement is sought may, if it considers it proper, order the requesting party to provide appropriate security. So there is a distinction made between the Supreme Court of Judicature enforcing its jurisdiction in the jurisdiction of Trinidad and Tobago, that's the general application of Section 4, subsection 2, except when applicability of court's jurisdiction arises in other national laws to be enforced by those other national courts. So I hope I have addressed in some small measure the concern which Senator Timal had on Section 4.2. It can't be read on its own. It must be read in its entirety, not only in relation to the section in its entirety, but on the canons of construction. It must be read within the framework of the Act as a whole. Senator Timal also had a concern about Section 5E, the Objects Clause, which says it incorporates the UNCITRAL law, and he was expressing the concern that perhaps it should go on to say, subject to the provisions of this Act. Well, I can understand the concern, and it is a legitimate concern, because you can't have a national law that incorporates a model law outside of the country and make the national law subject to the changes and the exigencies of that international law. But that is not what is happening here, because at the date at which we pass this bill and it becomes the law of the state of Trinidad and Tobago, so much of the UNCITRAL model as we adopted is what becomes the law of this state. And always, going into the future, the law will be always speaking to continue to apply for purposes of enforcement in Trinidad and Tobago according to that law. If UNCITRAL were to change their model in 2025, we would have to come back to this Parliament to ask the Parliament to allow us to amend our national law, the Arbitration Bill 2023, to keep pace with the amendments that UNCITRAL may be promoting in the future. So we start with the fact that this is the law, it binds the state, it applies to all domestic and international arbitration within Trinidad and Tobago and without, and it is to be applied at the date of its passage, going into the future, to apply that which we inherited from UNCITRAL at the date of its passage. And the sections that Senator Timal expressed concerns about are also addressed, sections 8 and 9, by understanding that the Supreme Court of Judicature of Trinidad and Tobago is the court that will continue to have the limited jurisdiction in its supervisory jurisdiction to compel adherence to the laws of Trinidad and Tobago. And there's an interesting judgment, with your leave, Mr. President, which has emerged out of this jurisdiction dated the 14th of December 2022 on the existing Act, Arbitration Act, Chapter 5, Number 2, which we will expect when we pass this bill into law will be repealed. And it is the decision, the OAS decision, Civil Action 2022, number 01832, a judgment of Mr. Justice Frank C. Prasad, dated the 14th of December 2022. And he was called on to apply Section 19. Senator Lakshmidial spoke to Section 19 of the Arbitration Act. Even in the very limited circumstances of Section 19 of the Arbitration Act as it presently obtains, this is what the judge, Mr. Justice Frank C. Prasad, had to say as a matter of proper statutory construction, to paragraph 24, in construing the provisions of the arbitration agreement regulated by that law. The court also has an inherent jurisdiction to set aside an award when the following factors apply, namely if it is A, subject to an error on the face of the award, B, wholly or in part in excess of jurisdiction, C, subject to a patent substantive defect, or D, subject to an admitted mistake. 2 points emerge from that dictum in the judgment of Justice C. Prasad. A Supreme Court has and is endowed with the amplitude of what is known as the powers inherent in a Supreme Court, and will always have the jurisdiction to apply the law as it stands, either at common law or statute.
AG, you have 3 more minutes.
Thank you, Mr. President. The significance of that is that in the absence of a complete ouster clause, and sections 8 and 9 of this bill are not complete ouster clauses, they expressly speak to and continue to apply the jurisdiction of the Supreme Court of Judicature, the jurisdiction as an inherent court of jurisdiction will continue to apply. So that in answer to Senator Timal's concerns about sections 8 and 9, I affirm the fact that our court will continue to be able to exercise the amplitude of its jurisdiction. Mr. President, I am an optimistic, positively minded person, and I am loath ever to rise unless I am given good cause to rise to take objection to anything that is available to be said by any of our citizenry in the freedom of speech which we are blessed to express in this country, and particularly protected in this hallowed hall in exercising. But as I end and I ask this House to embrace the bill that is before it, the Arbitration Bill 2023, on Standing Order 46-8, in which judges of the Supreme Court or other persons performing judicial functions shall not be raised except upon a substantive motion moved for the purpose, I want to go on record to say I abhor the irresponsible and dangerous comments of Senator Mark today. Leave my wife out of it. Do not call my wife's name as a judge of the Industrial Court of Trinidad and Tobago in this chamber in your political guile. Mr. President, I beg to move. Thank you very much.
Honourable Senators, the question is that a bill entitled An Act to Repeal and Replace the Arbitration Act, Chapter 501, to provide a modern legal framework to facilitate domestic and international trade, I'll start again. Honourable Senators, the question is that a bill entitled An Act to Repeal and Replace the Arbitration Act, Chapter 501, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
To repeal and replace the Arbitration Act, Chapter 501, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters.
Attorney General.
Yeah. Mr. President, in accordance with Standing Order 66-1, I beg to move that the Arbitration Bill 2023 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the Arbitration Bill 2023 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Honourable Senators, there are 68 clauses in this bill, and we have amendments from the Attorney General, from Senator Timal, as well as Senator Lakshmi. And just as a point of reminder, when senators are putting their amendments in writing, it is to be forwarded to the Clerk of the Senate first, who would then forward it to all senators, just to make sure that all senators are in receipt of it. So I'll ask the question, are all senators in receipt of the 3 sets of amendments as put forward by the senators I've just called out? Yes? We don't have Senator Timal. Okay, so all amendments have been circulated electronically. I would now ask Senator Mark and team to just verify that you have it in your email. Yes? Okay, great. So we can begin.
Clause 1.
Honourable Senators, the question is that Clause 1 stand part of the bill. Honourable Senators, the question is that Clause 1 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
Honourable Senators, the question is that Clause 2 stand part of the bill. Attorney General.
Yes, thank you very much, Mr. President, Mr. Chairman. I would like to propose that the definition arbitrator in Clause 2 be deleted, please.
Okay. Senator Mark.
I just want to get clarification, Mr. Chair, and that has to do with the confidence that we like to build our international relations, particularly when foreigners are coming to TNT. And I make specific reference to data, message, and electronic communication under definition, because I think you're under Clause 2. So what I'm proposing, and I'd like the Attorney General to clarify, is that in the absence of the proclamation of the Data Protection Act and the Electronic Transaction Act, how would our foreign colleagues who are coming here to be engaged in arbitral matters or arbitration matters, how are they going to feel if, for instance, you are dealing with data messages as well as matters of communication of an electronic communication nature, but the law that govern these things have not been proclaimed in Trinidad and Tobago? So I just wanted to ask, through you, Mr. Chairman, to the Attorney General, whether in the absence of the proclamation of these two pieces of legislation, would that contribute to a lack of confidence?
Okay, so Senator Mark, you are asking for clarification from...
No, just clarification from the Attorney General.
Attorney General.
The clarification that I can give to Senator Mark is that persons who enter Trinidad and Tobago, whether they be foreign investors or otherwise, will be expected to comply with the law as proclaimed at the point of their entry. If the law has been proclaimed, that is the law. If it has not yet been proclaimed, then it is not the law, and they will no doubt get proper advice on their requirement to comply with our national laws.
Okay. Any other comments or questions as it relates to Clause 2 and the proposed amendment by the Attorney General? Okay, so Honourable Senators, the question is that Clause 2 be amended as circulated by the Attorney General. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that Clause 2 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 2 as amended now stands part of the bill.
Clause 3.
Honourable Senators, the question is that Clause 3 stand part of the bill. Honourable Senators, the question is that Clause 3 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 3 now stands part of the bill.
Clause 4.
Honourable Senators, the question is that Clause 4 stand part of the bill. Senator Timal.
Mr. Chairman, I had prepared this amendment prior to the wrap-up of the AG, and in the context of what he did address this extensively in his wrap-up. So I'm withdrawing this proposed amendment.
So the proposed amendment to Clause 4 put forward by Senator Timal is so withdrawn. As such, I shall proceed with the question. Honourable Senators, the question is that Clause 4 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill.
Clause 5.
Honourable Senators, the question is that Clause 5 stand part of the bill. Senator Timal.
Chairman, the Honourable Attorney General did address this concern that I raised in my contribution. Now, although his wrap-up did address the concern rather extensively, I still want to be on the side of caution and probably still ask for this amendment to be considered, subject to the provisions of the Act after the word law.
Okay, Attorney General.
Thank you, Mr. President. I can understand the concerns of Senator Timal, but I think that, and I am not a drafts person, so of course I will bow to the drafts person. So can I just have 1 minute, please? Just. For that opportunity, Mr. Chairman. Whilst I appreciate the concerns of Senator Timal, my initial instinct has just been advised by those who are better at drafting than I am. And the question that I ask, which I now utter as a statement, is the amendment which is being suggested, respectfully, is superfluous because everything in the Act is subject to the provisions of the Act, and particularly in light of the very clear language, earlier language of Sections 3 and 4 of the Act. I don't think these words are necessary.
Senator Timal, is it your wish to have this question put to the Senate still?
No, Chairman, I'll withdraw. There is sufficient coverage, I think, in the Act. It's just that I just want to be extra careful.
Okay, so Honourable Senators, the proposed amendment by Senator Timal at Clause 5 has been withdrawn, and as such I shall now put the question. Honourable Senators, the question is that Clause 5 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 5 now stands part of the bill.
Clauses 6 to 13.
Honourable Senators, the question is that Clauses 6 to 13 stand part of the bill. Honourable Senators, the question is that Clauses 6 to 13 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 6 to 13 now stands part of the bill.
Clause 14.
Honourable Senators, the question is that Clause 14 stand part of the bill. Senator Timal.
Chairman, what I'm proposing is that we insert the words, who shall also be the presiding arbitrator of the arbitral tribunal after the words third arbitrator. I am of the view that if we do have a arbitration panel, a tribunal consisting of 3 persons, then we should clearly identify who is going to chair that panel or who is going to be the presiding arbitrator, particularly in the light that each party nominates 1 arbitrator and the 2 arbitrators nominate the 3rd arbitrator. But it is not clear who would be the presiding arbitrator in that tribunal panel. So this is why the reason for the proposed amendment.
So consult with my team, please.
Or is it understood?
Sorry.
Attorney General.
Thank you, Mr. Chair. Bearing in mind that this is a bill that is drafted employing the UNCITRAL model, and bearing in mind that the parties to the agreement are the driving force to invoke the arbitration and thereafter to invoke, subject of course to the jurisdiction of the tribunal, to invoke the procedures that will apply, we do not consider that this suggested amendment is necessary, and it could in fact collide with the model of the uncial model, which gives preeminence to the wishes of the parties to control their procedure. And therefore, we would not agree to this amendment.
Senator Timal. Oh, Senator Richards.
Thank you. Thank you, through you, Mr. Chair. In the absence, Honourable AG, of the inclusion of Senator Timal's suggested amendment, who is it that it's a free-flowing discussion at these levels, or can they nominate someone to be guiding the discussions? The arbitrators who are agreed to.
Attorney General.
It would have to be a discussion that would have to take place amongst the arbitrators who have been chosen by the parties to resolve how they proceed procedurally at that point.
Senator Mark.
As it relates to 14.6, I should say, subsection B. Attorney General, could you explain this provision here as it relates to advisability of appointing an arbitrator of a nationality other than those of the parties? Who is going to decide that? And when we talk about a person of another nationality, I'm not too sure if we are looking outside of the jurisdiction of Trinidad and Tobago, or we are looking within the Caribbean. I'm not too sure. So I'm just trying to clarify this because it is a bit confusing as it stands.
Attorney General.
Trying to get some clarification.
Thank you, Senator Mark. As I read clause 14, subsection clause 6, the language of the section speaks for itself. The court, in appointing an arbitrator, shall, and then A is prescribed, have due regard to any qualifications, etc. And B, in the case of a sole or third arbitrator, the court shall also take into account the advisability of appointing an arbitrator of a nationality other than those of the parties. So it's a discretion given to the court, bearing in mind we are dealing with domestic and/or international arbitration, bearing in mind that the parties at that particular point in time may be a French company with a Trinidadian company. The court may take into consideration that if the parties want to consider a French national to be one of the arbitrators, then that is appointed. It's in the discretion of the court on the facts presented before her or him at the point in time.
Thank you, Mr. Chair.
Yeah, I want to come back to my proposed amendment. I mean, I hear what the Honorable Attorney General is saying, but being involved in one or two arbitration matters in the past, it's really a humbug, and to me, a backward step, that if you do not have someone who can chair that tribunal, it could turn out to be rather a messy affair, particularly when the arbitrators, they are appointed by either party and maybe not willing to give way in certain instances. So where the two arbitrators, one nominated by each party, they meet under this provisions of this clause to appoint a third arbitrator. I think it's a very safe approach in that, seeing that the two parties, the arbitrators of the two parties have appointed a third arbitrator, for that arbitrator to be a presiding arbitrator. For efficient functioning of the panel, structured way of working together. Not that the presiding arbitrator derives any additional powers because he or she is the presiding arbitrator, but it's just a question of chairing a panel.
Well, can I suggest then? Can I suggest?
One second. Are you adding to the proposed amendment of Senator Timal?
Yes. I'm just
proceed.
As opposed to the word "shall be the presiding arbitrator," because that suggests he is the presiding person. But what about the "shall be the chairman of the arbitration"? Because the chairman doesn't have the chairman merely coordinates but doesn't have any superior power over the other two as such. And I think Senator Timal's point is valid in terms of tidiness of the proceedings. But I wouldn't use the word presiding arbitrator because it suggests that he has some greater function than the others.
Okay, Senator Lachmidial.
Perhaps the suggested term by Senator Welch is better, so it doesn't suggest superiority. But perhaps because you want to leave it open to the parties to sort of contractually agree to the structure, perhaps you could say that each party shall appoint one arbitrator and the two arbitrators shall appoint the third arbitrator, who shall be the chairman unless otherwise agreed by the parties, because you leave it open to the parties in their contractual agreement to then decide who will be the chairman or coordinating arbitrator or whatever term you use. But in the event that that isn't specified in their contractual arrangement, well, then the third arbitrator appointed by both of them will assume that role. So it's a sort of a, you leave it open to them to not have that procedure, but if it's in default of anything being agreed, this will be the procedure where the third one will be automatically the chairman.
Attorney General.
Thank you, Mr. Chairman. I've had the time, and I apologize to you, Mr. Chairman, and to my colleagues, because I read the amendment, the proposed amendment, literally coming off my legs into this seat, and I've had the time to look at it more carefully in the context of Section 14(3) as a whole. And I think that what we are missing, and I say this respectfully, is that subsection 3A1, which is what Senator Timal is seeking to amend, has to be read with subsection 3A2. Because what 3A1 says is each party shall appoint one arbitrator, and the two arbitrators so appointed shall appoint the third arbitrator. And 2, if a party fails to appoint the arbitrator within 30 days of receipt of a request to do so from the other party, or if the two arbitrators fail to agree on the third arbitrator within 30 days of the appointment, the appointment shall be made upon request of a party by the court, so that the contingency which Senator Timal is trying to guard with at A1 to have a presiding arbitrator appointed is taken care of by A2, because if the two arbitrators fail to agree, the third arbitrator, 30 days of the appointment of that third arbitrator shall be made on the request of a party by the court.
No, Chair, I don't agree with that. Sorry.
Who would chair? Or who would chair? Yes. I see.
Okay, Senator Richards.
Thank you. Through you, Mr. Chairman. That's not what I understand Senator Timal to be suggesting. He is not suggesting there's a difficulty with appointing the third arbitrator with the process outlined. He's suggesting that there may be merit in having the two arbitrators from either side decide on a chairman to guide proceedings. And according to Senator, is it Lachmidial or Welch, that may or may not decide to assign a chairman to guide proceedings, not to decide upon a third arbitrator if they can't decide. I don't think that's the intention, if I'm wrong.
Yeah, thanks, Senator Richards. Thanks, Senator Richards, for the clarification. But I would agree with what Senator Richards is putting forward, because it reflects my intention in this proposed amendment. Senator Welch has, if the term presiding has connotations from a legal perspective, I think, as he has suggested, chairman is a much more safer word. And then Senator Lachmidial, I can't recall her exact wording, but if we add in what she had proposed about, unless that, yeah.
Okay, so we 1 second. So I will take 1 second, Senator Marks. I will take the Minister of Tourism, then I'll take Senator Mark, and then I'll have the Attorney General have his final say. So, Minister of Tourism.
Thank you very much. I'd like to refer us to Part 6, Clause 34, 1, where it says, subject to the provisions of this Act, parties may agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings. So I think it is totally up to the parties to agree on how they proceed, whether they want to proceed as the third arbitrator, as a chairman, or in any other way. It's a contractual sort of arrangement that these provisions are seeking to guide. So it has to be read in line with Clause 34.1 in my respectful submission.
What Senator Timal is saying is that to avoid unnecessary confusion, because remember, as I understand it, and I could be guided and corrected, when we are talking about mediation, we are talking about informality. When we're talking about arbitration, it appears from our understanding of what is before us, a more formal kind of arrangement. Of course, not at the level of a court or the judicial system. However, you don't want parties to be in a state of confusion as it relates to taking decisions to appoint someone to either chair the tribunal, and if you don't have that specified in the law, based on what Senator Timal said, it could lead to a lot of confusion. So we may not use the word presiding, but we should use language that would indicate that the third party to be appointed as an arbitrator or to assume the role of chairman of proceedings of the tribunal. So the law could be very clear and predictable. That is how I am seeing it based on what is being said as well.
Attorney General, your final comments?
May I, through you, Mr. Chair, Senator Lachmidial, to just repeat the recommendation she had made, please?
So it should read, each party shall appoint one arbitrator, and the two arbitrators so appointed shall appoint the third arbitrator who, sorry, let me just get to the emails, who shall be the presiding arbitrator of the arbitral tribunal unless otherwise specified by, or unless otherwise agreed to by the parties. So you leave room for the parties to have their contractual procedure agreed, and only when their contractual arrangement is silent, then the proposal that Senator Timal is putting forward will kick in as the automatic.
Yes. I would be prepared to accept that with the introduction of chairman from Senator Welch in place of presiding arbitrator, and the guarded words at the end by Senator Lachmidial.
Okay. So, that being said, procedurally, what we shall do is treat with Senator Timal proposed amendment as he has circulated, unless you withdraw that, Senator Timal, pending the subsequent amendment put forward by, I guess it would be Senator Lachmidial. Well, I don't see what else there is to say, Senator Mark, because we are moving to now treat and dispense with this particular clause.
Well, just to add to what you have said, rather than rush it, may I suggest through you to the Attorney General that we stand on this provision, get this thing in writing, and make sure the Honorable Attorney General is satisfied before we rush it.
Okay, then we shall do that. We'll stand down that particular clause, get the wording of the proposed amendment correct, but like I said, I just want to dispense with Senator Timal's proposed amendment. So is it that you withdraw your amendment as proposed, pending the proper wording of the forthcoming amendment for this particular clause?
Yes,
because your proposed amendment is worded very specifically and has to be dispensed with.
Now, I'll withdraw in the context of the discussion and the pending wording that is.
All right, so done. Senator Timal's proposed amendment, for clause 14 is so withdrawn. We will also stand down this clause at this point in time to get the proper wording of an amendment as put forward by Senator Lachmidial.
Clauses 15 to 18.
Honourable Senators, the question is that clauses 15 to 18 stand part of the bill. Honourable Senators, the question is that clauses 15 to 18 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 15 to 18 now stands part of the bill.
Clause 19.
Honourable Senators, the question is that clause 19 stand part of the bill. Attorney General.
Mr. Chairman, I intimated earlier in my wind-up that I had listened to the contributions of Senators Sipasad and Timal, and in the context of the concerns raised by them, and having regard to the fact that Clause 19 was a clause that had been recommended to us by the judiciary, I am prepared to withdraw that clause to delete Clause 19 in its entirety.
All right. Honourable Senators, the question is that Clause 19 be amended as circulated by the Attorney General. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that Clause 19 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Clause 20.
Honourable Senators, the question is that Clause 20 stand part of the bill. Attorney General.
Thank you, Mr. Chairman. And again, as I said, having reflected on the contributions of Senators Sipasad and Timal, following on my deletion of Clause 19, I would also ask to delete, for the same reasons, Clause 20. Yes.
Okay, Honourable Senators, the question is that Clause 20 be amended as circulated by the Attorney General. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that Clause 20 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 20 as amended now stands part of the bill. Okay, so we are now moving to clauses 21 to 54 as there are no proposed amendments before me in relation to those clauses, and as such we take them on block. Clerk.
Clauses 21 to 54.
Honourable Senators, the question is that clauses 21 to 54 stand part of the bill.
Mr. Chairman, with your leave, can I just ask for clarification? The final amendment that I have proposed, following on my deletion of 19 and 20, is for the clauses to be renumbered, so that
will be treated with.
Yes,
that will be treated as a matter of.
Yes, thank you.
There you go. Honourable Senators, the question is that clauses 15 to 21 to 54, now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 21 to 54 now stands part of the bill.
Clause 55.
Honourable Senators, the question is that Clause 55 stand part of the bill. Senator Lachmidial.
We are proposing the inclusion of two additional grounds, so to speak, upon which the award could be set aside. The wording here, we looked at some comparative legislation, I think in the Cayman Islands. I understand the point made in winding up about the inherent jurisdiction of the court. And of course, inherent jurisdiction of the court may cover these things, but I feel for certainty, we can include that the making of the award induced by or affected by fraud, corruption, or misconduct, misconduct being, I believe, the term that is used in the Section 19 of the present Act, where the arbitrator might have misconducted themselves. And I think it is always wise to include a breach of the rules of natural justice so that there's prejudice to a party. Again, it would be open to a party to argue that a breach of natural justice occurred and to appeal to the inherent jurisdiction of the court to set aside the award on that ground. But if you want to have certainty in your law as to the grounds upon which the award can be set aside, I would suggest that these two additional grounds be included in Clause 55.
Okay, so you treated with all of the podium. Senator Attorney General.
Thank you very much, Mr. Chairman. I don't accept the suggested amendments, and Senator Lachmidial has already pointed to one of the reasons, that is to say, the preserved residual inherent jurisdiction of the court, in my view, will always continue to apply. Secondly, and in any event, I've already spent some time in my winding up pointing to the learning, which is now part of the accepted law that gives to arbitrators a power to deal with corrupt or fraudulent conduct or misconduct, and all of that is already provided for, so I don't see the necessity for that. And thirdly, and very importantly, what we are seeking to ask this House to pass today, this evening, is a model law that is uniform across the jurisdictions based on the UNCITRAL model law. And except for compelling reason, and I don't see this being compelling, I would not wish to alter or deviate from the model law that UNCITRAL recommends. Thank you.
Senator Lachmidial or Senator Mark?
Mr. Chairman, through you to the Attorney General, in the Cayman Islands, they have also incorporated the UNCITRAL model law in their legislation, which they have updated at the end of 2022. So I fail to see the inconsistency with the attempt by the Attorney General not to consider these additional provisions in an attempt, Mr. Chairman, to ensure that there's some degree of certainty so that when people are before a tribunal, they would know the grounds that they can use to set aside a particular award. And I'm saying that this is part of the modernization process, and unless it is inconsistent with the UNCITRAL model law, I would ask the Attorney General to reconsider his position on this matter.
Do you have anything to add?
No, Chairman, I think it is clear that, a model law is just that. It's a model. It doesn't have to be cut and paste wholesale. It's open to us to specify, as the Cayman Islands have done, if we think it is, worthwhile to include other provisions. The law that the Attorney General is referring to is a first instance decision, which, is subject to be overturned later. We could have varying decisions coming from that. So I wouldn't rely on a first instance decision on the applicability of fraud and so on to set aside judgments. And again, I reiterate that certainty in the way your legislation is set out, it reinforces, again, confidence in the piece of legislation.
Comes after everything.
Yes.
Okay, Senator Attorney General, final comments?
Yes. Yes, thank you very much, Mr. Chairman. I've heard the remarks of Senator Lachmidial and Senator Mark. I am not prepared to accept Senator Mark's assertion of what the model law consists of in the Cayman Islands. What I will rely on is at the 6th of June, 2023, we had circulated this model law to the UNCITRAL Secretariat, and in their response to us, which I've read into the record, they did not suggest to us that we had omitted something from the model law which is to be found anywhere else, and therefore I will be prepared to continue to rely on that which we have before the Parliament. Thank you.
Mr.
Okay,
Chairman.
so Honourable Senator Timal.
Yeah, if you just allow me just one intervention, Honourable AG. I know we are working with a model law, the UNCITRAL model law, but should not adequate consideration be given the conditions of particular application with regards to the jurisdiction that we are in, and the conditions, historical conditions, and factual conditions concerning fraud and corruption and all those things. And the model law should be conditioned by the act that we are passing to reflect those concerns. And this is why I think the amendments that have been proposed here by Senator Lachmidial merits, I think, consideration.
Any response, AG, or the response? 1 second, Senator Mark, or the response remains the same?
My response remains the same. Thank you, sir.
Senator Mark, that is the...
And then, in fact, this is my final intervention. Mr. Chairman, I think that the point that was made by Senator Timon is one that is worthy of consideration, because you have to take into account the objective cultural, concrete environment that we are in. And whilst we have a model law, and as the AG said, he has passed on this law to the Secretariat of Uncitral, and they have said, well, look, no problem. But that doesn't mean to say, Mr. Chairman, that we as a sovereign democratic republic going through this thing with a fine-tooth comb is seeking to enhance the law to ensure that there's balance in what we are doing. So I really think it's something that the Honorable Attorney General should revisit.
Attorney General, is response the
Yes,
same, or is there anything else to add?
One final response, just to make the point, while I respect the point made by Senator Timal about the cultural realities, this is precisely why the UNCITRAL model law has recommended one uniform model, because if each nation that went to adopt the UNCITRAL model law sought to make a variation to reflect their cultural dynamics, we would be very far from having a model law enforceable across nations to produce the result which we want to produce, an attractive destination for all investors to feel confident that they can rely on a law that is applied with consistency. On top of which, and when we look at the particular amendments that are being suggested, dealing with fraud, corruption or misconduct, breach of rules of natural justice, that is already subsumed within the language of the section 55, subsection 2, 3, and 4, in my view, deal with issues of natural justice and the inherent jurisdiction of the court, as I've read out in my winding up, will also allow a court of superior jurisdiction to be able to deal with evolving cultural issues of corruption as they emerge in the domestic court. So I would not agree to this amendment. Thank you.
And had sufficient back and forth on this matter. At this point, I will put the question as it relates to Senator Loch-Medial's proposed amendment. Honourable Senators, the question is that Clause 55 be amended as circulated by Senator Loch-Medial. Those in favour say aye. Aye. Those against say no. No. I think the noes have it. Honourable Senators, no. Good. Honourable Senators, the question is that Clause 55 as amended now stand part of the bill by Senator Loch-Medial. Those in favour say aye. Aye. Those against say no. No. I think the noes have it. So Clause 55 as amended does not stand part of the bill.
Clauses 56 to 64.
Honourable Senators, the question is that clauses 56 to 64 stand part of the bill. Honourable Senators, the question is that clauses 56 to 64 now stand part of the bill. Those in favour say aye. 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 Those against say no. I think the ayes have it. Clauses 56 to 64 now stands part of the bill.
Clause 65.
Honourable Senators, the question is that Clause 65 stand part of the bill. I will start with the proposed amendment by Senator Timal, and then we will dispense with that and then treat with the proposed amendment by Senator Loch-Medial. Senator Timal.
Yes, Chairman, I'm proposing that the word may that comes after Attorney General, that should be changed to shall. And after the word act, we add the words which shall include qualification criteria for the appointment of arbitrators under Section 14 and the appointment of the umpire under Section 19. But considering that the clauses that relate to the umpire has been removed, then after Section 14 and the appointment of an umpire under Section 19 would also have to be removed. The reason for this is that I know that in terms of regulations, what is being allowed here is that the Attorney General may. Now, in the whole context of separation of powers, I mean, we are being asked to pass legislation on the basis of regulations that may be passed. And I think there are gaps in what is being proposed, particularly in the context of the qualification of arbitrators. And this is the reason for this proposed amendment.
Attorney General.
Thank you, Mr. Chairman. Dealing with the proposed substitution of shall for the word may in section 65. I do not agree with the proposed amendment, and I do not agree with it for two reasons. Yes, I do not agree with the proposed amendment for two reasons. First of all, the use of the word may is deliberate, which gives a discretion to the Attorney General whether or not he will consider it necessary or expedient to propose making regulations for giving effect to the purposes of the Act. That discretion, in the context of the totality of the bill, will be understandably informed by section 46(1), among other sections. 46(1), which is a very important section, says an arbitral tribunal shall decide a dispute in accordance with such rules of law as are chosen by the parties as applicable to the substance of the dispute. It goes back to the grundnorm of this model law. That is to say, the process is driven by the parties. The parties may decide for themselves to make rules for the regulation of their particular arbitration that has been invoked under their particular agreement, which may render it entirely unnecessary, almost otiose, for the Attorney General to consider making any regulations at all. So to substitute the word shall and make it an imperative on the part of the Attorney General runs against the express provisions and the spirit and intent of the model law as captured by 46(1). Thank you.
Okay, Senator Timal, any further comments?
Yeah, I understand it in terms of the provisions of 46(1), but Honorable Attorney General, 46(1) will deal primarily with the procedures and the functions of the arbitral tribunal and how they go about their business. But in terms of the selection of the arbitrators, that was my main concern. And if we are going to address the selection of arbitrators, possibly in regulations, particularly since it's not really referred to here in the bill, this was attempting to capture the due diligence that would be done in the selection of arbitrators, and not necessarily the functioning of a panel.
You mean like qualifications?
Attorney General, final.
Yes, thank you, Mr. Chairman. I was dealing in the first instance with the change of the word may to shall. When we come to the addition of the words, which shall include qualification criteria for the appointment of arbitrators under section 14, I don't consider that necessary, and I would stay with the model law prescription of the UNCITRAL model law. Thank you.
Okay, so we shall now put the question to the proposed amendment by Senator Timal. Honourable Senators, the question is that clause 65 be amended as circulated by Senator Timal. Those in favour say aye. Those against say no. Aye. I think the noes have it. Honourable Senators, the question is that clause 65 as amended by Senator Timal now stand part of the bill. Those in favour say aye. Those against say no. I think the noes have it. Clause 65 as amended by Senator Timal does not stand part of the bill. Senator Lochmidial, your clause 65. Senator Mark.
Mr. Chairman, nowhere in our Republican Constitution is there a provision for the executive arm or organ of the state to be a lawmaking organ. It is the Parliament of the Republic of Trinidad and Tobago that has given that authority to the executive arm. And it's the Parliament to take it back if we so desire. We are in charge of lawmaking under the Constitution. I start off with this introduction to let you know that the Attorney General cannot arrogate unto himself a function or a power to make law or laws through regulations, which is known as secondary or subsidiary legislation, Mr. President, Mr. Chairman, and then leave out the Parliament that is debating the very law that he wants to pass. The Attorney General, Mr. Chairman, is saying that the Parliament that is responsible for lawmaking will have no oversight responsibility for legislation that the executive arm of the state is making. Now, Mr. President, Mr. Chair, let me just put an additional point on the table. The Attorney General is conflicted. The Honorable Attorney General is conflicted, and I'll tell you why I'm saying so. I made the point earlier that any matter, if somebody takes legal action on a civil scale for monies that are outstanding by the state, they do not sue the Prime Minister or the executive. The Attorney General is the one that is sued. Now, could you imagine, Mr. Chair, you have in a contract a provision for arbitration involving the same contractor that has sued the Attorney General. And the Attorney General is being given the power on his own, Mr. Chairman, to make regulations. That cannot be fair. It cannot be ethical. And I am saying that if the Attorney General wishes to do so, we want to protect him. And you protect him by subjecting the regulations to affirmative resolution. So the entire Parliament would be in charge and not the Attorney General alone. The Attorney General is exposing himself to lawsuits. And I am saying, Mr. Chairman, I'd like the Honorable Attorney General to give this thing considerable thought before we go forward with it. And therefore, I am saying is either it is left out, Mr. Chair, completely, and let the courts, let the Supreme Court draw up the rules as an independent body, rather than have the Attorney General singularly, solely doing that without any supervision or oversight of the Parliament, which is the only lawmaking body under our Constitution. That is my submission for the Attorney General's consideration.
Attorney General.
Mr. Chairman, thank you. So as not to cause Mr. Senator Mark any undue stress this late in the evening, I would propose that we make Section 65, the Attorney General may, subject to negative resolution, make regulations generally for giving effect to the purposes of the Act, so that the regulations will be laid and they would have the opposition, if they consider after sight of the regulations that there is reason why it should be rejected, they would have the requisite period of time to reject.
Mr. Chair?
Senator Mark?
Now, Mr. Chairman, I have put on record over and over, we on this side do not like that kind of secondary legislation, and we would want the Attorney General, given his graciousness, to reconsider. Because the reason why I'm saying so, Mr. Chair, Attorney General, we are trying to protect your office. We are trying to protect the office of the Attorney General. And if the Parliament, Mr. Chairman, is given the...
Please let Senator Mark make his case.
Yeah, Mr. Chairman, if the Parliament is given that overall authority, then the Attorney General is protected
because he comes to the Parliament with an affirmative resolution for the regulations. It is debated among us in the both places, rather than have us now bring a matter after the fact. So, Mr. President, Mr. Chairman, it is my considered view it should be affirmative and not negative. That is my final submission to you.
Attorney General.
Subject to the negative resolution, I stand by that. Thank you.
Okay, so in treating with this, I propose that we deal with the proposed amendment as put forward by Senator Lakshmi Dayal first, and then, Attorney General, you're indicating that you will subsequently put an amendment using negative as opposed to affirmative, which I will then put after we've dealt with Senator Lakshmi Dayal's amendment. Sure.
Why doesn't the Attorney General consider deleting the word affirmative in Senator Lakshmi Dayal's contribution and replace it with a negative, rather than go through all this hullabaloo? I mean, to say, I am reluctant.
Well, it's not for the Attorney General to do that. It's for the proposer of the amendment. So if Senator Lakshmi Dayal is willing to do that, then we can do that, and then just put it as one.
Although we are reluctantly agreeing.
Senator Mark, there's no need to re-debate it.
Yes, I'm not re-debating.
So Senator Lakshmi Dayal, are you willing to further amend your proposed amendment to change affirmative to negative?
Reluctantly, yes, please, Mr. President.
Okay, so therefore I shall put the question as follows. Honourable Senators, the question is that Clause 65 be amended as follows by Senator Lakshmi Dayal to read, insert after the word act, the words subject to the negative resolution of Parliament. Those in favour say aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that Clause 65, as amended by Senator Lakshmi Dayal further, now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 65, as amended, now stands part of the bill.
Clauses 66 to 68.
Honourable Senators, the question is that clauses 66 to 68 stand part of the bill. Honourable Senators, the question is that clauses 66 to 68 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 66 to 68 now stands part of the bill.
Clause 14 revisited.
Clause 14 revisited. Honourable Senators, the question is that Clause 14 be amended as follows. In subsection 3A1, by inserting the words, who shall also be the chairman of the arbitral tribunal unless otherwise agreed to by the parties, after the words third arbitrator. Those in favour say aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that Clause 14, as amended, now stand part of the bill. Those in favour say aye. Those against say no. Senator, Minister of Tourism. Is there an issue?
Through you to the Attorney General, if I could direct the Attorney General to Clause 47.2. I hate to detain the proceedings. Now, going back to my initial comment on the bill, I believe that in Clause 34 there is a certain amount of flexibility and latitude that the provisions give the parties. Now in 47.2, it makes mention of a presiding arbitrator. So I'm not sure if the insertion of the word chairman would now confuse the matters.
Attorney General.
And further, in examining both model bills, one by the Impact Justice and the UNCITRAL model, they both do not have reference of a chairman. Both allow for that flexibility of the parties to determine their own procedure.
Well, perhaps we can deal with that by, although it's a bit late in the day to suggest it, 47, where the word presiding arbitrator appears, change on that to chairman as well. And I think that might be the most practical solution.
Attorney General?
Yes, thank you very much, Mr. Chairman. And may I express my gratitude to the Minister of Tourism, Senator Mitchell. This would be governed by an old phrase known to common law lawyers known as the slip rule. I think that to be safe, we should stay with the language that Senator Timal had first proposed, presiding arbitrator, instead of the word chairman, so that the language is consistent throughout the Act. So that the amendment which we just approved should really read who shall be the presiding arbitrator of the arbitral tribunal, unless otherwise agreed by the parties.
But to achieve consistency as well, Attorney General, if 47 is changed from presiding arbitrator to chairman, one would achieve consistency by that means as well. You see, when you see the difficulty I have with the word presiding arbitrator, because all the arbitrators are really presiding. All the arbitrators are equally presiding. But if you want to say one for tidiness guides how the proceedings, not that that person has any final decision, but every tribunal should have a chairman. He doesn't have any greater say than the other members of the tribunal. He merely guides procedures to keep things tidy. And I think every tribunal should have a chairman, whether it be in this arbitration situation or otherwise. And that chairman, for other minor things, could be the person to decide on a particular issue. So I would say one should achieve consistency by perhaps looking at 47 being amended to be consistent with Senator Lutch-Medial's.
Thank you, Mr. Chair, and thank you, Senator Welch. I think the consistency is better accomplished by staying with the language that already exists in other parts of the Act, and I don't think that any ambiguity is introduced by keeping consistency, because when we read the amendment that we would now be effecting to section 14.3a.1, it would mean that we will read, shall appoint the third arbitrator who shall be. So clearly, the third arbitrator shall be the presiding arbitrator. So there's no potential there for inconsistency. The third arbitrator shall be the presiding arbitrator, and that is consistent with language used elsewhere in the Act. So you are maintaining consistency throughout the Act. No, the third arbitrator shall preside among the three, as in effect the chairman, but I would prefer to remain with the language.
But because it seems to me that all members of the tribunal are presiding arbitrators.
No, the presiding arbitrator is the language of UNCITRAL, and the two other arbitrators are deciding that the third shall be the presiding. So there's a consensus among them.
Okay, so I think that the Attorney General has made his final comments in relation to what is being discussed here at clause 14 revisited. So what I will do is I will put the question now, and I would ask all senators to follow quite carefully, as this is important to ensure that the procedure is done correctly. So that being said, honorable senators, the question is that clause 14 be amended as follows, as put forward by Senator Lutch-Medial. In subsection 3A1, by inserting the words, who shall also be the presiding arbitrator of the arbitral tribunal unless otherwise agreed to by the parties, after the words third arbitrator. Those in favor say aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that Clause 14, as amended, now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 14, as amended, now stands part of the bill.
New clause 69.
Honourable Senators, the question is that new clause 69 be read a second time. Senator Mark.
I don't know if this is the correct time, but I wanted to ask through you to the Attorney General whether the Attorney General would like to consider the issue of a code of conduct or ethics for these officers.
That's something different, Senator Mark? Yes, Senator Mark, is that something different? Because we're dealing with new clause.
No. All right, okay.
Yeah, the new clause as put forward by Senator Lakshmi. So, Senator Lakshmi.
Chairman, again, this is a clause we've found in other comparative legislation within the region. I believe one of the contributors from the independent bench raised the issue as to changes being made to the ancestral model and updates and so on, and keeping our law abreast. So this clause is really just to reinforce the point that if the model law is changed, we would have the obligation to look at it and to bring our law up to speed so that we remain consistent with what is taking place around the world and in other jurisdictions.
And even the Attorney General himself indicated earlier on in his contribution that if there is need to amend the law consistent with changes to the ancestral model law, he will come back to Parliament. So all we are saying, Mr. Chair, is that this legislation, because of its importance to what we are trying to achieve, should be held or be kept under constant review. And in that context, I really believe that the Attorney General should consider this amendment, this new clause, so that, for instance, we could review ever so often, whether it's every 3 years or 2 years or 5 years. It is something that is worthy of consideration. So, Mr. Chairman, I support this clause, and I ask the Attorney General to look at it.
Attorney General.
Thank you very much, Mr. Chairman. Mr. Chairman, the new clause as proposed is an aspirational mandate that is consistent with the duty that I consider I have to the government as Attorney General. I always keep the laws under review. That is why we have a Law Revision Commission and a Law Reform Commission, and I do not consider it necessary or prudent to put a mandatory clause into any legislation to make that legislation mandatorily to be kept under review by the Attorney General. That's my job, and we have departments that are continuously doing that. Thank you.
Senator Mark.
Yeah, Honorable Attorney General, you would know that we don't have updated laws, even though, since 2016. And even though you were not in office at that time, the reality is that our laws have not been revised since 2016. So even though you have that, it doesn't exist. So it's something that we need to really be serious about.
Okay, sir. Attorney General, your response is the same?
Yes, thank you very much, Mr. Chairman.
Honourable Senators, I shall now put the question. The question is that new clause 69 be added to the bill. Those in favour say aye. Those against say no. I think the noes have it. New clause 69 does not stand part of the bill. Honourable Senators, the question is that the bill as amended be now reported to the Senate. Those in favour say aye.
Chair.
Those against say no.
Chair, did you renumber the bill? Renumber the clauses?
It's consequential in terms of its renumbering, but if senators would like me to you know?
Just mention.
Okay. All right, well, Honourable Senators, just to let you know that clauses 21 to 68 will be renumbered as clauses 19 to 66 accordingly. Okay? So the bill I'll put the question again, just for procedural matters. Honourable Senators, the question is that the bill as amended be now reported to the Senate. Those in favour say aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate. Attorney General.
Mr. President, I wish to report that the Arbitration Bill 2023 was considered in the Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on the Arbitration Bill 2023. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Thank you, Mr. President. I beg to move that a bill entitled An Act to Repeal and Replace the Arbitration Act, Chapter 5, Number 1, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters, be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Repeal and Replace the Arbitration Act, Chapter 501, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters be now read a third time and passed. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Repeal and Replace the Arbitration Act, Chapter 501, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and related matters.
Leader of Government Business.
Mr. President, I beg to move that this Senate do now adjourn to a date to be fixed.
Honourable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised on the motion for the adjournment. Senator Richards.
Mr. President, the motion is for the government to address the issue of bullying and cyberbullying in the nation's schools. Mr. President, according to the Education Hub 2019, bullying is a form of mean, hurtful behavior that can actually happen to anyone at any time and not limited to age groups. Not all aggressive or harmful behavior is considered bullying. The issue of child bullying or school bullying is even more pervasive in many jurisdictions. The definition of bullying has four essential characteristics. The behavior is mean and harmful. Bullying causes short and long-term negative outcomes for the victim or victims. The behavior is repeated, persistent, and ongoing, and it's not a one-off incident, and not a normal part of growing up, as we like to sometimes think in Trinidad and Tobago or other jurisdictions. The behavior is carried out on purpose with the intent to cause harm, fear, distress to another person or child. It can be in the form of physical, emotional, psychological, academic, or social harm, including hurt to the person's reputation, their personal belongings, feelings, safety, and feeling of well-being at school. There is a perceived or real power imbalance between the perpetrator and the victim based on factors including age, physical size, strength, gender identity, ethnicity, perceived intelligence, physical resources, including weapons, social status, popularity, or disability. Alana James, 2010, a PhD researcher in the University of London, indicated bullying as a pervasive type of aggression which often occurs in schools. It refers to peer-to-peer bullying within the school context. Key findings of a study she conducted and her colleagues conducted, including bullying around the world, report victimization rates of between 9 to 32%. Verbal abuse is the most commonly reported type of bullying, but cyberbullying, which happens outside the school, is becoming increasingly significant and dangerous. Victimization decreases with age, although there's an initial peak during the transition from primary to secondary school. In the Trinidad and Tobago context, over the years, we engaged in behaviors that were at the time accepted culturally. We have colloquial expressions called peacock, and with phrases like a little peacock never hurt anyone. So we accepted it for many years, but we realized through research after many years, these bouts of peacock or old talk or verbal abuse had medium and long-term devastating effects on the psychology and well-being of the victims. We now know that untold damage to thousands of students locally and million globally who have been negatively affected by bullying. In an article written by Valère Marsh, October 2018, out of the Center for Urban Education Success indicated 20 to 29% of students are involved in bullying, either as a victim or a perpetrator. Bullying occurs through the grades, peaking during adolescence and middle school years, as the earlier study indicated, primary and secondary schools are transitioned to those. Cyberbullying occurs more and more frequently as the internet becomes more pervasive, and at-risk student populations for increased bullying include students with disabilities and students who identify as LGBTQ. Contributing factors include bystanders who can have a powerful effect on either stopping or encouraging bullying, depending on the peer group norm they ascribe to. Teachers can intensify, encourage, or limit bullying, depending on the approach and the policies in place at the school. Bullying perpetrators and victims share the same risk factors. Persons who are bullied tend to sometimes, in some instances, go on to be bullies themselves as an externalizing behavior. In a study on the impact of bullying on adolescents at Holy Faith Convent in Couva by D.M. Ram, Savi Ali et al. 2015 by UE Open Campus, focused on bullying as a global concern in the past 5 years in Trinidad and Tobago before the study was carried out in 2015, which included physical, verbal, hidden, covert, cyberbullying, imposing significant short and long-term consequences on victims, as well as the bully. At Holy Faith Convent, at that time, school bullying affected adolescents from Form 1 class level all the way to Form 6. The research indicated that 5 out of 10 students encountered bullying of some kind during their school term. Also dealing with an article titled Dealing with Child Bullying, published on the 11th of February 2020 by Dr. Paula Robertson. She indicated a person is bullied when he or she is exposed to repeatedly and over time negative actions on the part of one or another student or a group of students in some instances. School violence bullying leaves scars for life. An article by Raphael John Lal, February 26, 2022 in the Sunday Guardian, which quoted our esteemed colleague, Dr. Varma Diyal Singh, as indicating and underscoring the negative effects of bullying in Trinidad and Tobago. I'll end by underscoring 2 examples of devastating effects on young people published by silverliningtt.com, which is titled Breaking Trinidad and Tobago's Tradition of Bullying. One is called Jenny, not her real name. For 16-year-old Jenny, the bullying began at the beginning of high school and persisted every day. She was a Form 4 student and has been bullied on multiple occasions because she was taller than most girls at the school. She was called Giant, and others made fun of her name. On many nights, she cried herself to sleep at night with no assistance from her teachers or school administrators, and too afraid to speak to her family for fear they would go into the school and make it worse. She often had suicidal thoughts. Her ray of hope came in the form of a sister who was a guidance counselor, and she disclosed her fear, and that intervention proved important in actually saving her life. Adam, not his name, was a Form 3 student with a passion for the arts. At the age of 15, he loved dance and drama and practiced at the performing arts school. He shared his experience with a primary school level, which in turn, because of his love as a boy for dance and drama, led to him being ridiculed by his peers at school. He was also bullied because of his weight and because of a speech impediment he had. He also recalled being in a state of depression for as long as he could remember, which affected him into his young adulthood. This is a phenomenon that we are not taking, to me, seriously enough in Trinidad and Tobago, and it has become even more pervasive with the anonymity provided by the internet. In the past, students had to go into the schoolyard or into school classes to be bullied. Now, they can be attacked anonymously online, their reputations and self-esteem destroyed leading to medium and long-term damage to their psyche and also impacting their negatively their academic performance and their socialization. I am aware that there have been interventions by the Student Support Services to the Ministry of Education, but I am getting more and more reports of bullying becoming more pervasive at every level in primary and secondary schools throughout the country. I am hoping that there is some sustained strategic intervention provided by the ministry to deal with this action, because it can lead to an escalation by the perpetrators into more violent actions in their teens and young adulthood, and also devastating effects for the victims if not remediated and counseled on a sustained and focused basis. Mr. President, I thank you.
Minister in the Ministry of Education.
Thank you, Mr. President. I know the goodly senator feels very passionately about this topic because we have spoken about his passion for education. And as I stand before this House, I want to first highlight that hurt people, and hurt children. And we at the Ministry of Education, while we focus on the victims, we also focus on the bullies, because they too, Mr. President, need help. It is a vicious cycle of hurting others. Some bully just because they have been bullied. Some because they want to be seen or perceived as powerful and popular. And unfortunately, some because they learned this behavior at home. Unfortunately, Mr. President, this issue of bullying is not new to any country or society, but one that requires a response and a hands-on approach from all sectors from society. At the policy level, the ministry has developed, approved, and issued policy guidelines in the National School Code of Conduct 2018, the National School Discipline Matrix 2022. Collectively, these guidelines address various forms of bullying, cyber, social, physical, and verbal. The NSCOC clearly states the Ministry of Education prohibits all forms of bullying. This applies to all school personnel. It pertains to activities within the school and extends to external school-related activities, as well as commuting, walking to and from school. Incidents of bullying must be addressed promptly and effectively by schools while protecting the confidentiality of the process. The NSDM identifies bullying as a major infraction and outlines the consequences of first, second, and third offenses. As a ministry, we will and have continued to implement ongoing measures implemented by the ministry to deal with the issue, and these are as follows. The frequent monitoring of this infraction with the accompanying consequences. This includes memos to remind principals they must report, treat with all instances of bullying which are reported and observed at schools. B, provision of counseling by the personnel of the Student Support Services Division to both victim and perpetrators. 26 secondary schools which have the highest levels of school infractions, including bullying, have been assigned dedicated social support workers and guidance officers over the last academic year to ensure that more attention is paid to the students who require support for behavioral transformation. And 3, up to 3 learning support assistants have been assigned to these schools to support the principal in school operations, including student supervision. Mr. President, the implementation of restorative practices in 10 pilot schools, which aims at transforming negative behaviors and assisting students to manage conflict, resolve disputes, and build communities through different practices by focusing on repairing any harm that has been done. And 2, address conflicts through not just communication, Mr. President, but also by group therapy. Although it's not always the case, bullying is also associated with low levels of academic achievement, as pointed out by the senator. And this is also being addressed through the following ongoing initiatives. The After-School Support Education Program, which targets approximately 8,000 students at standards 3, 4, 5 in 80 selected primary schools in foundation subjects. the training of approximately 400 teachers, principals, school supervisors, and curriculum officers in remedial mathematics, writing and reading comprehension, with a special focus on remediation, which began in June 2023 in selected 80 schools. The introduction of the vacation revision programs at both primary and secondary levels, which will seek to minimize the learning loss as students at standards 4, 5, and Form 1 will receive 5 weeks of instruction from highly qualified and trained teachers in mathematics, writing, and reading. Our Turn Up and Don't Give Up mentoring and the 40 under 40 programs. These programs are all aimed at inspiring students to stay the course, push forward, and learn better by seeing better, despite the academic or social or economic challenges they currently face. These mentoring sessions form part of the vacation revision program and continue into the school term. Members of the Defense Force and the TTPS have already confirmed their participation in these programs. Mr. President, we understand the effects of bullying can be long-lasting for victims, including fear, anxiety, depression, thoughts of suicide, the decreased academic achievement, the fear caused by being a victim can make it very difficult for someone to focus at school. What we hope through the Ministry of Education and through our programs is to create safe spaces in all our schools. Mr. President, however, we need to understand, and it needs to be quite clear, that children learn from their environment. And it cannot only be the Ministry of Education, but we all as citizens of this country are supposed to lead by example, even in this particular chamber. When we learn to treat people with kindness and compassion, and we treat our children well, the bullying will stop. But in the meantime, Mr. Chairman, and Mr. President, I would like to stress the Ministry of Education is constantly working on improving the situation. I thank you very much.
Senator Mark.
Mr. President, I have brought to this Honorable Senate a matter on the motion for the adjournment, calling on the government to provide an update on its plans and programs in preparation for the upcoming, well, it is here already, the 2023 Atlantic hurricane season. Now, Mr. President, the public of Trinidad and Tobago, with all the dire predictions that are being made, even though we are told it is going to be a normal season, we have already begun to experience some abnormalities. And we just had to throw our minds back to what has happened in the last 48 hours and what is continuing to happen in different parts of the island, resulting in children, students, not being able to proceed to do their CSEC and CAPE exams over the last 2 days, particularly in Ibagpo, Maruga, and I think Tableland area, Penal Debe area. Now, Mr. President, I have not heard, maybe you have, maybe my other colleagues have heard, some action, some program, some preparation, some planning coming out of the Office of Disaster Preparedness and Management, the so-called ODPM. Now, the question that is being asked is whether this ODPM is functioning in Trinidad and Tobago today, because we have seen what has taken place, Mr. President, and there has been no responses, none whatsoever. You would have thought, Mr. President, in this period of uncertainty and unpredictability, with all the waters that are flowing all over the country, there would have been the Army, the Defense Force out there providing students with the necessary transportation. Not PNM. It is the UNC that had to hire trucks to get their children from Penal, from Barkpo to Maruga. Where was the Army? Where was the Defense Force? Mr. President, I just read in tomorrow's Newsday advance information that has reached us. This is coming out tomorrow, but we are getting it now. Where the Met Office is predicting, or has issued, Mr. President, a yellow level high winds alert. And that is expected, Mr. President, according to the information that I have in my possession, to commence at 8 a.m. tomorrow and expected to end, according to this Met Office release, on Friday at 2 p.m. in the evening. Now, Mr. President, you know the kind of challenges that we are facing with the floodings that are taking place. Many homes are being inundated. Farmers' crops are being destroyed. Poultry being destroyed. We saw recently where some 10,000 poultry products are being destroyed, right? Farmers experiencing hardship. So what we are seeking to do, Mr. President, is to get the government of Trinidad and Tobago to be a little more sensitive and to be in a state of high alert, because they, according to the member for Tobago West, the PNM is in charge. And if the PNM is in charge, Mr. President, why it isn't so we had all this disaster over the last 48 hours and still to come? So I am appealing. This is a very simple and straightforward matter that I have brought to the attention of this Honorable Senate. And that is to get the government to speak, to address the people, to allow this leaderless ODPM to have a leader. Because there's weakness at the level of the ODPM. I don't know if the former Army commander or Chief of Defense Staff, his name is, I think, Colonel Smart, I think that's the last time I recall he was in charge, that gentleman. I don't know what is happening, sir. But we are concerned, not only as the alternative government, but as an opposition. We are concerned, Mr. President, that we are not hearing anything from the government. The people are not hearing anything from the government. The ODPM is silent. And we know, Mr. President, that the season, even though they told us in inverted commas, will be normal, we are seeing, Mr. President, that is not the case. And therefore, I have brought this matter on the motion for the adjournment, for the government to share with this country and share with the citizens throughout Trinidad, because Tobago has its own team. I think they are in fact, they are the most efficiently run disaster preparedness organization in Trinidad and Tobago. I think we could learn a lot of lessons from TIMA in Tobago, I must tell you. And therefore, our focus is on Trinidad. So I would like to ask the Honorable Minister to really explain to Trinidad and Tobago what decisions have been taken, what plans have emerged, what preparations are being made to alert and prepare the country and its citizens for this situation that we are facing almost on a daily basis in the last couple hours, in the last couple of days in Trinidad, and expected to worsen in the coming hours according to the information that I have shared with this Honorable Senate. So as I said, Mr. President, it's a very simple and straightforward matter, and it is designed to get from the government a status position to update the country through the Senate as to its plans and programs as it relates to preparing Trinidad and Trinidad in particular for the upcoming 2023 Atlantic hurricane season. So that is my submission, just to allow the government to tell us what their plans are, what their programs are, and to have it on a consistent basis so that the nation could be prepared. So, for example, Mr. President, in closing, if a Category 1 hurricane were to hit Trinidad and Tobago, we should know in advance because you have to refresh people's memory. If a Category 2 hurricane were to hit us, what should people do? So I'm just giving these things as examples because the people are not alerted to what is taking place in our country as it relates to the coming 2023 Atlantic hurricane season. I must say, finally, Mr. Chairman, in closing, that the Met Office has been keeping us abreast, and that's how we get information. But the ODPM that is supposed to be preparing us, they are not doing it. So, Mr. President, I thank you for allowing me to raise this issue so that we can get an answer from the
Minister of National Security.
Thank you, Mr. President. I sat here in dismay and disappointment at the flimsiness, the softness of the presentation made by the senator. One would think that his presentation was water-soaked yesterday somewhere, in a drain perhaps. I'm disappointed. A serious matter such as this, a country like every other country in the world having to deal with the outflows of climate change. I am disappointed that the senator will come here this evening to trivialize this matter in the way that he has embarrassingly done. He made 3 points in all of the time available to him, that children did not get to do their exams. I do not want that senator talking about too much exams in this Senate, especially when I'm here. He will distract me, and it will take me to the Arthur Lockjack Institution. He also spoke about the army. Where was the army? It is as if he does not know that the first responders in these kinds of crises would be the regional corporations who were out there doing what they had to do in accordance with the National Response Plan. He made another flimsy point about the farmers experiencing hardships. Yes, farmers experience hardship. When it rains and it floods, farmers lose crops everywhere in the world. But he behaves as though it is only in Trinidad, trivializing this thing. And finally, and his big point, was that the ODPM could not be found. But he was able to tell us at the beginning of his presentation that he is aware that there's a particular alert to be published tomorrow by the government. He knows in advance and still comes here, frothy as always, to ask what is happening. Let me tell him a few things. The government of Trinidad and Tobago, through all of its ministries, departments, and agencies, undertook and continues to undertake several initiatives to prepare for the Atlantic hurricane season, which began on the 1st of June. I want to tell you, Mr. President, truthfully, that since I took the office of Minister of National Security, I have admired the operation and functioning of the ODPM under the leadership of retired Major General Smart. Quite honestly. But they are here to just demean everything, condemn everything, criticize everything, repose, depose, oppose, dispose, but propose nothing. These preparations are informed by Cabinet's decision in 2020 to establish a National Disaster Prevention and Preparedness Multi-Sectoral Committee. and declared the month of May, which precedes the hurricane season, to be the National Disaster Prevention and Preparedness Month, which we have just finished observing. While disaster prevention and preparedness is a year-round activity for us, May is used as a whole of society call to action for organizations and persons at all levels to become involved in disaster prevention and preparedness activities in order to reduce the risk of potential impacts. A number of initiatives were undertaken this year as they were last year. Let me name a few of them for you. Expansion of the community flood early warning systems. I was in Diego Martin recently when another one was established to gauge the levels of water that comes in the Diego Martin River. That happened just about 3 weeks ago. The senator clearly doesn't know that. Wet and hurricane season readiness checklists are established. Pre-positioning of emergency disaster stores, meaning warehouses in certain places for when the circumstances warrant their application. Preparation of Trinidad and Tobago's response through a regional tabletop exercise, Synergy 2023, which took place on the 24th of May. Where was the senator? Updating the Office of Disaster Preparedness and Management's 2023 hurricane season operational plan, development of a national adaptation plan, public education and information, the ODPM and other stakeholders. We want the Brian Lara Promenade, when this was launched, they would have gone to San Fernando and Tobago too, as they did last year. Where was the senator? The National Disaster Preparedness Month was a very successful event with 40 activities being executed. The launch of the public alert notification systems, which they call PANs, evacuation drills, community outreaches and fairs, webinars and training, social media and educational videos. Let me tell you a little bit more about each of them. The PANs is a mass notification system, and it is an innovative technology to warn our citizens and visitors of national level disasters and emergencies and provide timely updates to protect lives. All of this in advance so that they can shift and make arrangements as the circumstances might warrant. In terms of evacuation drills, in conjunction with the Ministry of Education and the Trinidad and Tobago Fire Service, preparedness lectures and evacuation drills were conducted at 11 primary schools across Trinidad and 3 in Tobago. In addition, for the first time ever, full-scale community emergency response simulation exercise was conducted for the Piparo mud volcano. See the level of thought? In addition to this, WASA conducted a chlorine leak drill at the Caroni water treatment plant in Piaco, and this aimed to strengthen emergency and safety procedures at that facility. These exercises will be continuing over the next few months, with emphasis being placed on wet and hurricane season preparedness as part of the government's multi-hazard approach. Where was the senator? Was he on his own in a room with a bib?
I did not give instructions to keep their bread from us.
Mr. President, to educate the public on preparedness, 8 large community fairs and outreach events were held across Trinidad and Tobago in the month of May alone to boost disaster knowledge and preparedness, to make communities more resilient.
Minister, you have 2 more minutes.
Indeed, webinars and training, as I told you, Mr. President. So, Mr. President, there is so much more to be said. I'm quite prepared to forward this long and impressive list of government preparedness to the senator and his team, hoping that having taken 2 minutes to read it, they will stop dogging Trinidad and Tobago and give thanks for the fact that so far we have not lost a single...
Senator Mark, stop shouting across the floor. Minister, finish.
Thank you very warmly, Mr. President. And notwithstanding his false and deceptive cries about how much disaster and everything went to mayhem, one family, as far as I'm aware, had to be evacuated yesterday, and not a single life was lost or any personal injury sustained. I am quite prepared to pass this impressive list to the senator, and it might put good sense upon him, rather than demean the country in the way they always do. Thank you very much, Mr. President.
Senator Mark. Senator Mark. Honourable Senators, at this time I invite greetings on the occasion of Labour Day to be celebrated on Monday, the 19th of June, 2023. Minister of Digital Transformation.
Thank you, Mr. President, for this opportunity to bring greetings. On behalf of the government bench and on behalf of the entire government, it is my honor and privilege to extend greetings and best wishes to the labor movement and to all workers and citizens of Trinidad and Tobago as our country prepares to celebrate Labor Day next Monday, the 19th of June. It was on that day, June 19th, in 1973, that this annual holiday was the first declared. History reminds us that the labor uprising, also known as the Butler Riots in June of 1937, marked the start of the modern trade union movement in this country as we know it. Labor Day affords the solemn recognition and to the many contributors many contributions made by labor organizations and by labor activists in their quest to improve labor conditions and legislation over the years. And of course, prominent labor figures feature normally at this time of year. We know many of them. I'll mention a few. Obviously, this list is not exhaustive. Tubal Uriah Buzz Butler, Captain Cipriani, George Weeks, Emma Francois, Adrian Yenzi, Daisy Crick, Albert Gomes, and of course, there are many, many, many more. And they have made an indelible mark on the labor landscape of Trinidad and Tobago. Our country, like the region and of course the world, is experiencing a period of rapid and profound change. The way we live, the way we socialize, the way we interact with each other, and the way we work and conduct business are all being simultaneously revolutionized. Against this backdrop, we and the labor movement included must take concerted action to do a few things. We want to build a resilient Trinidad and Tobago in the face of change. We want to provide a safety net for the most vulnerable of our citizens and to make sure that they receive the resources, support, and training needed for success. We want to take advantage of every opportunity to strengthen and grow our economy. And of course, we want to unlock the vast potential of our people. Mr. President, these uncertain times are not unlike in the early 20th century when workers recognized that success was built on hard work. With the conviction that a unifying force could together and do things to overcome all challenges, they worked shoulder to shoulder towards a common vision. Our Labor Day celebration this year presents an opportunity for our citizens, or Team Trinidad and Tobago that is, to come together in an active partnership to take ownership of our challenges so that together we can overcome them as we fix our eyes firmly on the vision of a strong, safe, prosperous, secure Twin Island Republic that takes full advantage of the blessings that our Creator has heaped upon us. The history of the labor movement contains many important lessons. This is one I think we should take note of. The popular saying that says, if you don't know from where you've come, then you don't know where you are. And if you don't know where you are, then you probably don't know where you are going. The labor movement was born out of a struggle in the 1930s and emerged victorious because of the partnerships that were built and the willingness to stay the course. I'm a firm believer that now, more than ever, we recognize that the tripartite relationships that were established then and now, through the founders of the labor movement, explored common solutions that these seemingly intractable challenges, they used them to solve them. Given our current prevailing circumstances, that relationship has evolved. And it is no longer about negotiating a balance between competing interests, but rather is about forging genuine partnership to explore and implement solutions that are fit for purpose in a fast-paced, constantly evolving, and very dynamic environment. A reinvented tripartite process could present a new way to explore the delivery of end-to-end workplace and national solutions through the pursuit of appropriate and genuine partnerships. As we celebrate Labor Day 2023, let us also use the opportunity to continue forging these partnerships that will take our beloved country of Trinidad and Tobago to the next level of development. On behalf of the government of Trinidad and Tobago, I extend best wishes to the labor movement and to all workers and citizens as we celebrate Labor Day. May God bless this industrious nation. Mr. President, I thank you.
Senator Mark.
Thank you, Mr. President. No, don't worry about them. I'm able. Mr. President, Monday, June the 19th, 2023, will mark, no pun intended, the 86th anniversary, as my colleague from Tobago said, the Honorable Hasselbach-Bacchus. We represent the 86th anniversary of the founding, and my brother Seals would know about that. Senator the Honorable Seals would know. He was a former president of a union, of the modern trade union movement in our nation. The Butler movement that emerged in the 30s, culminating, Mr. President, in the uprising and revolution of 1937, brought fundamental changes to the working conditions of the ordinary people in our land. So Butler led that movement. And throughout the years, Mr. President, we have had very important figures leading the labor movement and seeking to use the union movement to improve the quality of life and the standard of living of the ordinary working class man and woman in this land. You know, it is extremely disappointing that after 86 years of the founding of the modern trade union movement, that the labor movement today, Mr. President, as we speak, controls less than 20%. I dare say it may even be less than 20% of the organized labor force in this nation, in this country of Trinidad and Tobago. And Mr. President, over the last few years under this administration, the labor movement has experienced a series of setbacks, right, in our country. For example, Mr. President, as we prepare, I should say, to celebrate the 86th anniversary of the founding of the modern trade union movement, it would be remiss of me if I do not bring to your attention and this Honorable Senate's attention some of the challenges facing the modern labor movement, the modern working class forces in our land. Mr. President, there is a continued disrespect and disregard for the trade union movement in our nation. That is one of the challenges that we are facing in Trinidad and Tobago. Mr. President, there appears to be an end to what is called the free and fair collective bargaining process in light of the latest public sector negotiations that have concluded at another level. Mr. President, as we speak, we need to understand the challenges as we commemorate the 86th anniversary of the founding of the modern trade union movement, Mr. President.
Collective agreements, Mr. President, seem to be out of the window as we speak today, Mr. President. There's an undermining of the collective bargaining process. Mr. President, workers face mass retrenchment in our nation, and there's a privatization of the process taking place in many industries under the guise of what is called restructuring, Mr. President. Mr. President, there is no real commitment as we celebrate and commemorate the 86th anniversary of the founding of trade union movement. There is no real commitment, in spite of what my colleague said, to tripartism in our nation, Mr. President. There's none whatsoever. And Mr. President, what has taken place as we celebrate and commemorate the 86th anniversary of the modern trade union movement is a proliferation of contract labor throughout the public sector. I have dubbed and said contract labor is equivalent to slave labor in our country, Mr. President. So, Mr. President, what I would say is that there is a growing level of attack on our workers in our country and the democratic institutions in our land. So on behalf, as I commemorate, as I celebrate, as I extend militant solidarity greetings to the working class and the modern trade union movement, as we prepare to celebrate the 86th anniversary of the founding of the modern trade union movement, may I, on behalf of the alternative government, may I, on behalf of the honorable leader of the opposition, soon to become Prime Minister of this nation once again, may I, on behalf, Mr. President, of the opposition bench, may I say through you, Mr. President, to the working class, to the labor movement, militant solidarity greetings as we prepare for celebration the 86th anniversary of the labor movement. And Mr. President, I want to extend to you and your family a wonderful and happy Labor Day 2023. And I extend to the nation of Trinidad and Tobago and the people of T&T happy Labor Day greetings as we celebrate the 86th anniversary of the founding of the modern trade union movement in the Republic of Trinidad and Tobago. I thank you, Mr. President, for giving me the opportunity.
Senator Richards.
Thank you, Mr. President. May I begin with a quotation from Dr. Leighton Jackson, renowned legal luminary and former lecturer in law across the Caribbean, this past weekend at the Industrial Court Symposium in Port of Spain. He opined, and I quote, "The Caribbean, and in fact the Western world, was built on the labor of slaves from the African continent in the transatlantic slave trade and indentured servitude from the Indian subcontinent. Labor, in Dr. Eric Williams' seminal thesis, Capitalism and Slavery, was underscored as being a driving force for development across the world and also debunked the humanitarian ideals and motives behind the abolition of slavery and the importance of labor as a commodity in production. Over the years, the value of labor has been primarily determined by, in large part, by persons who are outside the working class, private sector, public sector, through the state, governments, business, and international market forces. Yet labor remains the most important component of production and, by extension, GDP and national development. Labor Day celebrations in Trinidad and Tobago were declared as an annual holiday in 1973, celebrated on June 19th. It was the anniversary of the day of the Butler oilfield riots, which took place in 1937. Prior to this, there were ongoing tensions between workers and employers in many sectors. These were characterized by situations of worker abuse, underpayment for labor, racism, economic depression, and a considerable fall in the living standards of the working class. Between 1934 and 1937, workers became more influenced by a need for change, resulting in strikes and riots in the sugar plantations and in the oil fields. And in September 1937, the Oilfield Workers Trade Union also became the first registered trade union in the country, representing the rights of those in the petroleum industry. The social unrest extended through the Caribbean and gave rise to several prominent labor leaders in Trinidad and Tobago, including Tubal Uriah Bus Buckley, George Weeks, Albert Marina Gomez, Adrian Cola Rienzi, Elmer Francois, CLR James, among many others. During a labor dispute in the Port of Spain Wharves in November 1919, Captain Cipriani called on workers to withhold their labor, resulting in the first important industrial strike in Trinidad and Tobago. George Weeks was also a well-known trade unionist, possessed a powerful political leadership style, and moved people toward a confidence to stand up for what is just and right. He gave them a vision that planted the seeds of liberation to move beyond salaries and working conditions along the road to self-development, identity, worldview, economics, and also government. Adrian Cola Rienzi served as a mayor in San Fernando, in November of 1939 and administered the borough for 3 consecutive terms until November 1942. He was a member of the Franchise Committee, which was appointed in 1941, and strongly advocated universal adult suffrage. St. Vincent-born Elmer Francois became a founding member of the National Unemployed Movement, its more radical successor, the Negro Welfare, Cultural and Social Association, which she devoted the rest of her life to, fighting for the rights of workers. And of course, Tubal Uriah Bus Butler, a Grenadian immigrant who worked in the oil field and was instrumental in the development of the labor movement, which emphasized the importance of collective unionism and treating workers' discontent and the abuses they faced by employers. Butler was awarded the country's then highest honor, the Trinity Cross, and the main highway had been renamed in his honor. Today, the statue of Butler stands at the Fyzabad Junction, also known as Charlie King Junction, the place where police attempted to arrest him on June 19th, the day of the historic 1937 riots. Over the years, labor's struggle has become a shining example of how a divided society can find common ground and unite. In the words of the mighty Sparrow in the Calypso many years ago, Indians and Negroes unite. We have won the battle for human rights, showing that we can come together in the common interest of the people of Trinidad and Tobago. It's an example of how we can make progress as a nation by uniting on what is in the interest of all the people of Trinidad and Tobago, and labor drove this, underscoring our nation's motto, together we aspire, together we achieve. On behalf of the members of the independent bench, I would like to wish the labor movement, and by extension the people of Trinidad and Tobago, a happy, productive Labor Day, and Godspeed and safety. Thank you, Mr. Vice President.
Honourable Senators, before I join you in bringing greetings, permit me to remind all senators that when I invite greetings, the intention is for those greetings to be positive in nature towards imparting cheer and goodwill to the celebratory sector of society. So once again, I just remind senators that when we bring these greetings, that they are intended to bring cheer and goodwill to the sector of society that is celebrating. Honourable Senators, I am honoured to join the previous speakers in bringing greetings on the occasion of Labor Day. On Monday, June the 19th, 2023, our nation will commemorate the 86th anniversary of the modern trade union movement as we recognize Labor Day. The 1937 labor riots is a watershed moment in our history. Many notable leading figures emerged during this snapshot in history, such as Uriah Buzz Butler, Captain Arthur Andrew Cipriani, George Weeks, Adrian Cola Rienzi, CLR James, and a host of other powerful figures. Notwithstanding the admirable contribution of these pioneers of industrial relations, the labor riots also resulted in great loss. Even some 87 years later, we continue to remember Corporal Charlie King, Sub-Inspector William Bradburn, and the 9 civilians who tragically lost their lives as a result of these riots. Let us never forget that the aftermath of the 1937 labor riots and the subsequent protests brought about major transformations in labor movements, such as the legal recognition of trade unions, the right to strike, and the right to engage in the collective bargaining process. These significant transformations live on in our public institutions and the bylaws, regulations, rules and orders that are approved right here in this august chamber. I am also heartened to recall the annual march of the hundreds of labor rights enthusiasts that gather in Faizabad on this day. Our fellow citizens stride arm in arm and lift their voices in unity from Avocat Junction to Faizabad Junction, hailing the achievements of the labor riots and exalting the memory of the brave men and women that achieved them. This procession culminates at the statue of Uriah Buzz Butler, where marchers listen almost reverently to the various speeches about where we are as a country, where we are now, and where we aim to be. It is therefore with a depth of respect and with gratitude that I join senators in wishing all citizens of Trinidad and Tobago and members of the labor movement a reflective, peaceful, and enjoyable Labor Day 2023. Honourable Senators, the question is that this Senate do now adjourn to a date to be fixed. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to a date to be fixed.